record. My name is Tommy Tucker. I'm Commissioner of the North Carolina Utilities Commission, and I'll be presiding over this hearing. With me today are Chairman William M. Brawley Jr. and Commissioners Floyd B. McKissick Jr. and Don Vandervaart. I now call for hearing dockets number E-2 sub 1383 and E-7 sub 1332, joint application of Duke Energy Carolinas LLC and Duke Energy Progress LLC to engage in a business combination, not a merger, a business combination. I was told yesterday by the attorneys it's a proper term, so I want to be official here. Address regulatory conditions and code of conduct and request accounting order. Before we proceed further, as required by the State Government Ethics Act, I remind members of the Commission of our duty to avoid conflicts of interest and inquire at this time as to whether any commissioner has any known conflict of interest with respect to this docket. Let the record reflect no such conflicts were identified. On August 14, 2025, joint applicants filed an application pursuant to North Carolina General Statute 62-111 and Commission Rule R1-5, seeking the Commission's authorization to engage in a business combination to combine DEP and DEC with DEC as a surviving entity. On September 10th, 2025, the Commission issued an order scheduling expert witness hearings and establishing procedural and filing requirements. On September 24th, the joint applicants and the public staff filed a joint proposed public notice. On October 3rd, 2025, the joint applicants filed supplemental direct testimony of Rachel Elliott and Nelson Peeler. On October 8, 2025, the Commission entered an order scheduling the public witness hearing and requiring notice and issued an errata order correcting the start time of one of the hearings on October 10, 2025. On October 14, 2025, joint applicants filed a motion to reschedule the November public witness hearings to December 15th and 16th, 2025. On October 16, 2025, the Commission issued an order rescheduling the hearings and requiring public notice. On December 4, 2025, the joint applicants filed their affidavits and certification of publication. On December 15, 2025, a public witness hearing was held in Raleigh. On December 16, 2025, a public hearing was held via WebEx. The following parties have petitioned to have been allowed to intervene in this proceeding: the Attorney General's Office, Carolina Clean Energy Business Association, Carolina Industrial Group for Fair Utility Rates 2 and 3, Carolina Utility Customers Association, Inc., Google, North Carolina Sustainable Energy Association, Nucor Steel Lexington, Southern Alliance for Clean Energy, Walmart, and Carolina's Transmission Customer Group. North Carolina Electrical Membership Corporation was denied intervention but granted amicus curiae status. On December 19th, 2025, the public staff and certain interveners pre-filed direct testimony. On January 20th, 2026, Duke Energy filed their rebuttal testimony and exhibits. On February 2nd, 2026, Duke Energy filed an update on the status of the business combination proceeding before the Federal Energy Regulatory Commission and the Public Service Commission of South Carolina. On February 17, 2026, the Commission issued an order establishing additional procedures for this expert witness hearing. In addition, Duke Energy filed a list of witnesses for this hearing. On February 18, 2026, both NCSEA and Attorney General's Office corrected testimony. On February 19, 2026, the applicants and public staff filed an agreement and stipulation of settlement. The public staff and the applicants filed testimony in support of the settlement on February 20th, 2026. On February 23rd, 2026, the applicants filed a motion to delay the start of the evidentiary hearing in order to continue settlement negotiations. Later, on February 23rd, 2026, the commission granted the motion to delay the evidentiary hearing until Wednesday, today, February 25, 2026. And that brings us to today. I'll now call upon the parties to announce their appearances, beginning with the applicant. And then after Duke has made their appearances, we'll receive appearances from the interveners, beginning with the public staff. As you provide your appearances, please be sure to come forward and speak into the microphone. However, you can do it where you sit if you wish. Before we begin, I'll say a few words regarding the process of this proceeding. It is the commission's intent to conduct this hearing in an efficient manner toward the end. I will remind the parties that witnesses' testimony summaries are to be filed with the commission in docket E-7, sub 1332A, and E-2, sub 1383A at least 2 business days before the witness appears to testify. The witnesses should not read summaries of their testimonies during the hearing, and that proposed orders and post-hearing briefs must be filed with the commission no later than 15 business days after the conclusion of the expert witness hearing. The commission asks that parties monitor cross-examination questions carefully and avoid asking repetitive questions repetitive questions of the witnesses. In regard to the exhibits, when making motions to enter cross-examination and redirect exhibits into the record, please identify the exhibit by its potential exhibit number first. This allows the parties and the commissioners to access the exhibit. At that time, I will identify the exhibit for identification purposes, and the parties may make their motions to have the exhibits entered into the record at the conclusion of the witness's testimony. Each party is responsible for presenting its notebook of potential hearing exhibits to the commissioners and testifying witness for the reference. After the commissioners have asked questions of the witnesses, the attorneys will have an opportunity to ask questions specifically related and limited to the commissioners' questions. An attorney that wishes to ask questions on commissioner questions will be required to first identify the commissioner that asked the question and restate the commissioner's question before asking his or her question. The capacity of the hearing room is 96 people. I would venture to say 99 of the 96 are attorneys. If we observe that we are at capacity, which I do not think we are, non-essential attendees will be asked to exit and observe the hearing via the commission's YouTube channel, which can be accessed from the commission's webpage at www.ncuc.gov. We encourage viewers to watch remotely to the greatest extent possible. It is imperative that this hearing proceed efficiently. Parties and witnesses should be ready to proceed when called. Questions and answers should be succinct and not repetitive, and exhibits should be organized at hand. It is important that all parties and attorneys proceed in an organized and prepared manner. I'd like to say a few words about the schedule at this point. With the exception of today, we plan to start tomorrow at 9:30 a.m. and each day conclude around 5 p.m. We plan to take an hour for our lunch break each day. Unless there's some reason to take a shorter or longer lunch break, we generally plan to begin the lunch break around 12:30. Since we have now discussed the procedural matters, we're ready to begin the evidentiary hearings. I now call for appearances of the parties, beginning with the applicant.
Thank you. Good morning, Commissioners. Presiding Commissioner Tucker, Chair of our all-in Commissioners. Good to be with you this morning. My name is Jack Turek, appearing on behalf of Duke Energy Progress, Duke Energy Carolinas, and I'm joined this morning by my colleagues Kamal Robinson, Kathleen Richard, Malika Franklin, as well as Faran Mehta with law firm Troutman. Thank you very much.
Thank you. Public staff?
Presiding Commissioner Tucker, Chair Brawley, Commissioners. My name is William Creech. I'm a staff attorney with the public staff on behalf of the public. Here with me is our Chief Counsel, public staff Chief Counsel Lucy Edmondson. Other attorneys on behalf of public staff here are Jennifer Herod, as well as Ann Keyworth and Nadia Lohr and Tom Fell. Thank you.
Thanks, sir. Yes, sir. Go ahead, Mr. Jimenez.
Good morning, Presiding Commissioner Tucker, Nick Jimenez with the Southern Environmental Law Center. On behalf of the Southern Alliance for Clean Energy, the North Carolina Housing Coalition, the North Carolina Justice Center, and Vote Solar, collectively SACE et al. And with me are my colleagues, Menashe Margarira and Ham Klaus.
Thank you.
Good morning, Presiding Commissioner Tucker, Chair Brawley, Commissioner McKissick, Commissioner Vanderbart, Christina Kress with the law firm of Ward & Smith, here with my law partner, Peter Ledford, appearing on behalf of the Carolina Industrial Group for Fair Utility Rates 2 and 3, SIGFR 2 and 3. Thank you.
You may use, you use those up there.
Good morning, Your Honors. Appearing this morning on behalf of Walmart Inc., Carrie Grunman and the law firm of Spillman, Thomas & Battle.
Thank you.
Good morning, Presiding Commissioner Tucker, Justin Somolowski on behalf of the North Carolina Sustainable Energy Association, and I'm joined by my colleague Ethan Wingfield today.
Okay, thank you.
Morning, Commissioners. John Burns for Carolina's Clean Energy Business Association. Good morning.
Okay, John.
Good morning, Presiding Commissioner Tucker. Heather Fenella Brooks Pierce on behalf of Google.
Hey, Heather.
Morning, Christopher Dodd of law firm Brooks Pierce on behalf of the Carolina Utility Customers Association.
Okay, Chris.
Morning, Commissioners. On behalf of Nucor Steel Lexington, Joseph Briscar of the law firm Stone, Matthias, Annapolis, and Brew.
Thank you.
Good morning, Rita Coxton on behalf of the North Carolina Attorney General's Office.
Okay, thank you. After all those, Lord. Yeah. Okay. Are there, we're ready to begin the hearing. Are there any preliminary matters?
Yes, Presiding Commissioner Tucker, if I may.
Sure.
Thank you. Commissioner Tucker, at this time, the companies have a few preliminary procedural matters that we would like to bring to the Commission's attention. At this time, we would ask that the company's joint application and exhibits as filed on August 14th, 2025 be entered into the record and then placed at the appropriate place in the record.
Okay. Is that all?
That's the first motion, Commissioner. Next, we'll turn to a series of settlement agreements that have been filed in the Commission's docket that we would also move into the record, and I will walk through those very briefly for you, if I may. Beginning with the stipulation agreement that dealt with the regulatory conditions, that stipulation agreement was filed on February 19th, 2025. In addition, a second settlement agreement was filed on February 24th, 2026. That's an agreement and stipulation of settlement between the public staff and the companies regarding a comprehensive settlement of this proceeding. And then a third settlement agreement was filed just a few moments ago in the docket. That is an amended version of that comprehensive settlement, with the primary changes being the addition of Google and Walmart as additional parties to the settlement, as well as a few additional additions to the settlement agreement that are shown in the filing. So, Commissioner, in conclusion and summary, I would move that the company's application and the three settlements filed in the docket be entered in the record at the appropriate time.
Okay, no objection. So moved.
Thank you very much. If it's all right with you, Commissioner, we'll now begin with witnesses on behalf of the companies.
Very well.
And before we call them to the witness stand, wanted to just explain a few procedural items that we have discussed with the parties, and certainly want to give a chance for any parties to offer their perspective on these issues to the extent necessary. The company's plan at this time for the proceeding would be to present our witnesses at the start of this hearing to present their direct testimony, their supplemental testimony, wherever they filed supplemental testimony, as well as their settlement testimony. From our perspective, it makes sense for those witnesses to be available to speak directly to the settlement at this time, to the extent that parties of the commission have any questions. We also understand that parties have not had a lot of time yet to review all of the terms of the settlement. So we wanted to make clear that to the extent that any party would like to ask questions about the settlement when the company's witnesses reappear on rebuttal, we certainly will not object to that, and we'll be glad to have our witnesses, when they appear for the second time on rebuttal, additionally answer questions about the settlement, notwithstanding the fact that they'll be presenting their settlement testimony here at the start of the hearing. So that's our proposal and how we plan to proceed unless any party would like to raise concerns with that approach.
Any concerns to be raised by public staff or any party?
No objection from the public staff.
Okay, we see no objections. May call your witnesses.
Thank you. At this time, the companies would like to call to the stand Kendall Bowman and Nelson Peeler.
Ms. Bowman, Mr. Peeler, welcome. If you'll place your left hand on the Bible, raise your right hand. Do you swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, thank you. Okay.
Thank you very much. Ms. Bowman, can you please begin with stating your name and business address for the record?
Kendall Bowman, business address is 410 South Wilmington Street, Raleigh, North Carolina.
Thank you. And by whom are you employed and in what capacity?
Duke Energy, and I am the North Carolina State President.
Thank you. And on August 14th, 2025, did you cause to be pre-filed direct testimony consisting of 21 pages?
I did.
And do you have any corrections to be made to your testimony?
I do not.
And if I were to ask you the same questions that are set forth in that pre-filed direct testimony, would your answers be the same?
Yes.
Commissioner Tucker, well, I'll hold motions till we get through all of these matters. That's okay.
Thank you for doing that.
Of course. Ms. Bowman, did you also, have you prepared a summary of your pre-filed direct testimony that was pre-filed in this docket on February 19th?
Yes.
All right, Ms. Bowman, now turning to your pre-filed settlement testimony. On February 24th, 26th, did you cause to be pre-filed settlement testimony consisting of 9 pages?
Yes.
And do you have any corrections to make to that testimony?
I do not.
If I were to ask you the same questions that are set forth in your pre-filed settlement testimony, would your answers be the same?
Yes.
And did you also prepare a summary of your pre-filed settlement testimony that was filed in this docket on February 25th?
Yes.
Commissioner Tucker, in conclusion, at this time, I would ask that the pre-filed direct and settlement testimony of Ms. Bowman be entered in the record along with the respective summaries for those testimonies.
All right, without objection, so move.
Thank you. I'll now turn to Mr. Peeler. Mr. Peeler, can you please state your name and business address for the record?
My name is Nelson Peeler. My business address is 525 South Tryon Street, Charlotte, North Carolina.
Thank you. And by whom are you employed and in what capacity?
Senior Vice President of Grid Strategy Planning and Integration for Duke Energy.
Thank you. And Mr. Peeler, on August 14th, 2025, did you cause to be pre-filed direct testimony consisting of 35 pages?
Yes,
And do you have any corrections to that testimony?
I do not.
If I were to ask you the same questions as are in that testimony, would your answers be the same?
They would.
Thank you. Now I'm going to turn to your pre-filed supplemental testimony. Mr. Peeler, on October 3rd, 2025, did you cause to be pre-filed supplemental testimony consisting of 12 pages?
Yes,
Do you have any corrections to your pre-filed supplemental testimony?
I do not.
And if I were to ask you the same questions that are set forth in that testimony, would your answers be the same?
They would.
And have you provided summaries of both your pre-filed direct and supplemental testimonies?
Yes,
Thank you very much. Mr. Peeler, did you also cause pre-filed settlement testimony consisting of 11 pages?
yes.
And do you have any corrections to make to that pre-filed settlement testimony?
No, I do not.
If I would ask you the same questions that are set forth in your pre-filed settlement testimony, would your answers be the same?
Yes,
And did you also cause to be pre-filed a summary of your settlement testimony?
yes.
Commissioner Tucker, at this time, with your leave, I would move that the direct, supplemental, and settlement testimony, as well as the respective summaries for Mr. Nelson Peeler be entered in the record as if given orally.
Without objection, so moved.
Thank you very much. And with that, the witnesses are available for questions from all parties in the commission.
Ms. Kress, you're recognized.
Thank you, Presiding Commissioner Tucker. Mr. Peeler, Ms. Bowman, good morning. I have a few questions for both of you, and feel free to answer, as appropriate, either one of you. These questions are initially going to be for Ms. Bowman, but Mr. Peeler, if you have anything to add, please jump in. Ms. Bowman, you testified this morning that you have no corrections to make to your testimony. Is that correct?
Yes.
And I want to turn your attention to your settlement testimony, which was filed late yesterday afternoon, around 4 p.m. Eastern Time. I'd like to turn your attention to page 4 of your settlement testimony,
Okay.
lines 18 through 21. Could you please read that sentence?
Under the terms of the settlement, the companies are now guaranteeing that benefits will be realized that exceed both the CTA cost to achieve and the share the benefits contribution, which further provides assurance that the combination will benefit customers.
And if you could turn with me to page 8 of your settlement testimony, lines 5 through 7.
So the question is, have the companies agreed to guarantee a certain level of benefits for customers? Yes, the companies have agreed to guarantee an amount of benefits that is equal to the total North Carolina retail impact of the cost to achieve and the share the benefits contribution.
Thank you. So do you recognize that in the first reference, your testimony said that the benefits will exceed the costs, but in the second reference, your testimony states that the benefits will equal the costs?
The companies have agreed to guarantee an amount of benefits that is equal to the total North Carolina retail impact of the CTA and the share of the benefits. So I think the amount that we guaranteed more than exceeds the retail impact of the cost to achieve and the share of the benefits.
Recognizing that you testified in 2 different places in your testimony, different things, materially different things. One is that the benefits will exceed the costs. The other, that the benefits will equal the costs. Which one is it?
It is exceeds, and I will admit that we recently reached the settlement agreement, and we were trying to get the testimony filed before the start of the hearing.
So is this a correction then that you need to make to your testimony?
Yes.
The combination of DEC and DEP requires approval by 3 regulatory bodies: the Public Service Commission of South Carolina, the North Carolina Utilities Commission, and the Federal Energy Regulatory Commission. Is that correct?
That is correct.
And Ms. Bowman, you testify in your direct testimony that share the benefits is, quote, critical to achieving approval in all 3 jurisdictions. Is that right?
That is correct.
And you go on to testify that wholesale customers will provide a $55 million per year contribution to South Carolina retail for 5 years, and North Carolina retail jurisdiction will provide $25 million per year for 6 years. Is that right?
Our proposal is for North Carolina retail to contribute $25 million for 6 years.
And wholesale customers will likewise contribute $55 million per
Yes.
year to South Carolina. Okay. Are you familiar with FERC's order on the combination?
Yes, I am familiar that FERC has approved the combination.
Presiding Commissioner Tucker, at this time, I would either like to request that judicial notice be taken of the FERC's order on the Duke combination application, Or alternatively, happy to request that this be introduced as a potential cross exhibit, in which case you are welcome to turn with me to SIGFR potential cross exhibit number 29.
Okay.
Would you prefer that I request that you take judicial notice of the order, or would you like me to request that it be marked for identification as a cross exhibit?
Judicial notice is fine.
Okay, thank you. Ms. Bowman, if you could turn with me to page 12 of this order. Do you have it in front of you?
If, Commissioner, May, if we just need a moment to get documents available for counsel as well as the witness.
Sure.
And this is, again, the FERC order approving the merger?
That's correct.
Okay.
And there's a binder on witness table.
You said page 12.
In part 2. Potential cross exhibit number 29. Yes, sir.
Get that one. You gonna get it?
Are you with me, Ms. Bowman, on page 12?
I am.
Okay. Could you please read paragraph 34 into the record?
And this is under the heading, Share the Benefits Plan. Applicants explain that the primary objectives of the Share the Benefits Plan are to address the impacts of proposed transaction on applicants' South Carolina retail jurisdiction, which is allocated a greater proportional responsibility for system costs, and to protect Duke Energy Carolina's existing wholesale power supply customers from an immediate rate increase related to cost sharing of the Duke Progress system, the higher cost system.
Thank you. And if you could turn just to page 12 of the same order.
Okay.
And if you could read the first sentence of paragraph 37 for the record.
Are you on page 13?
Page 13, thank you. Paragraph 37, first sentence.
The applicants explain that after deriving the per Duke Progress wholesale customer contribution to the Share the Benefits Plan, they calculated an annual amount for the transition period that would mitigate the rate impacts of the proposed transaction for each legacy Duke Carolinas wholesale power supply customer and work with each existing customer to evaluate their historical cost shift impacts, as well as their forecasted impacts to derive a per customer annual bill credit.
And so to be clear, FERC's order is stating that Duke Carolina's existing wholesale customers will be protected from an immediate rate increase related to cost sharing with the Duke Progress system. Is that correct?
So you have to think about this in totality of the Share the Benefits. And Witness Elliott can go into a lot more details than I can. You're looking at every class of customers. So you have North Carolina DEP wholesale, North Carolina DEP retail. You have South Carolina DEP wholesale, South Carolina DEP retail. You have North Carolina DEC retail, North Carolina DEC wholesale, South Carolina DEC wholesale, South Carolina DEC retail. And we looked at all of those classes in terms of the combination and what happens from the rates perspective. And the DEP, both retail and wholesale, at the beginning of the merger, didn't see as many benefits as the North Carolina retail and wholesale customers did. So in order for this transaction, although there's benefits to everyone, if you look out through the years, and Witness Peeler can explain this, in order to get all three of these jurisdictions to agree to this, we proposed the Share the Benefits concept so that on day one of the combination, everybody could start to see benefits.
So just for the record, the answer is yes. The FERC order says that this is about protecting Duke Carolina's existing wholesale power supply customers from an immediate rate increase related to cost sharing with Duke Energy Progress?
I think it's approving the entirety of the combination and is in the public interest. It's showing that there's now going to be benefits to customers.
Mr. Peeler, Ms. Bowman alluded to you maybe having something to add. Would you like to add?
I think she described it well. I mean, the issue is that the benefits, which are in my testimony, accrue over a long period of time, but the initial reallocation of cost has different impacts on the different customer classes she identified. And so in order to address any immediate impacts, the share the benefits was developed so that everyone benefits initially, so that then everyone can benefit for the long term as those benefits are realized. And again, I'll just add to what Ms. Bowman said is Witness Elliott is really the expert, and her testimony addresses this very clearly, I think. So if there are more detailed questions, I think she's the appropriate witness to address those.
Thank you. We'll be happy to do that. Ms. Bowman, if you could please turn back to page 16 of your direct testimony. Lines 13 to 14.
Give me a moment to find it.
Sure.
What page again?
Page 16, lines 13 to 14.
Okay.
In light of what we just read from the FERC order on the combination, is it still accurate to say that wholesale customers, quote, will provide for a $55 million per year contribution to South Carolina retail for 5 years?
I believe it is, but I would really defer to Witness Elliott to go into the specifics and details of that.
Okay. On page 7 of your pre-filed direct testimony, I'll give you a second to get there. You testify that the 2012 Duke Progress merger saved customers over $1 billion. Is that accurate?
Yes, that is what my testimony says.
And were those savings or were those cost avoidances?
I believe they were a combination of both. So in the 2012 Duke Progress merger, there were eliminations of positions because it was a holding company transaction. So there were eliminations of positions and other things that created some actual savings. And I do believe there was a fuel decrement that took place as well that created actual savings. But a component was avoided costs. We implemented something called the JDA, the Joint Dispatch Agreement, where we could dispatch energy jointly. And in that merger, we proved out and guaranteed $700 million for joint dispatch savings and fuel savings. And those were avoidance.
You agree with me that there is a difference, a material difference between cost avoidance and savings. Is that fair?
I'm not sure that I agree with that. I think they can be viewed together. I think savings can be avoiding costs.
Can cost avoidances also be savings then? Is the inverse also true?
I think that is, I'm not sure I'm following you, but I think if you can avoid costs, that is savings.
Did rates go down for customers following the Duke Progress merger as a result of these so-called savings or cost avoidances?
So if I remember correctly, and this has been over a decade, I think there was a fuel decrement rider that happened immediately after the merger. So I think that directly benefit customers, but you know, the company has definitely, we proved out the JDA and fuel savings benefits. We filed reports with this commission for a period of 5 years after, and we far exceeded what was guaranteed in those. So customers have seen the benefits of that combination.
I'll just add that the largest components of this amount were through the JDA and through fuel contracting and arrangements for fuel. So it's lowered production costs, lower fuel costs, which showed up very quickly in fuel hearings. So absolutely, it results in lower costs than otherwise.
So aside from the fuel rider decrement, was there a decrease to base rates that resulted from the Duke Progress merger?
No, and nor was that anything required in the 2012 merger order.
Turning to page 11 of your testimony, please, lines 19 through 20,
What page?
page 11.
Okay.
Lines 19 through 20. You testify that the combination will benefit customers through substantially reduced overall system costs, which translates into savings for customers. Is that correct?
That is correct.
Are those savings or are those cost avoidances?
As I just said before, I believe savings and cost avoidances are the same thing. But over time, the customers will realize all of these benefits.
Is it your testimony that base rates will go down following the merger between DEC and DEP?
No, this case is not about base rates going down. This is the combination of two utilities that is going to benefit all customers over the long term, as witness Peeler can explain all of the benefits. This is not about a rate reduction.
And is the benefit that you just testified to guaranteed?
We are in the settlement agreement. We have agreed to guarantee the cost to achieve, the cost sharing that is going to happen between the North Carolina retail to the South Carolina retail. And we've also agreed on storage facilities that witness Peeler can explain. So yes, we are guaranteeing a portion of the benefits that we see coming to customers in North Carolina through the settlement agreement.
And can you testify about what happens in the event of an unforeseeable circumstance beyond the company's control?
Can you point to me what you're referencing? Is this in the settlement agreement?
Correct.
Do you know what paragraph?
And again, this was filed yesterday afternoon, so bear with me.
I have it.
Okay.
I've got it. So it's referencing if the shortfall in achieving these targeted measures that we have agreed to, that we just went through, if we do not meet those and it's due to some kind of unforeseen circumstance outside of the direct control of the combined utilities, such as a material, economic, legal, or regulatory changes, the utility shall be permitted to come before the commission and plead its case if the commission finds it's in the public interest to relieve us from the obligation. But that is, I think of it in terms of like force majeure. Something major happens, some kind of big change happens in PJM, for example, and there's an inability to make any kind of economic purchases, which is one of the things that witness Peeler can go into that we're going to be tracking. Something significant that prevents us from doing that, but it is all subject to this commission's approval.
So it's fair to say there's still a risk that benefits will not exceed or equal costs. Is that fair?
I think it's highly, highly unlikely. We see overwhelming benefits, and I believe all parties, with the exception of maybe one in this case, have explained that everyone sees benefits by combining the mergers together, significant, combining the utilities together.
But it is still possible, correct?
In the abstract, it could happen.
Mr. Peeler, were you about to say something?
I was going to say, I mean, certainly all future scenarios, you can come up with lots of different scenarios, but all of our, everything we put forward here, multiple scenarios of not just benefits to cover the cost to achieve and the share the benefits, but the benefits that we've demonstrated in our testimony, and to Ms. Bowman's point, that pretty much no one's disagreed with the basis of those benefits. They far exceed what we're talking about here guaranteed. And so the risk of what you're talking about is small. And the issue here, of course, is this still requires action by the commission to make any exception to this. It requires this commission to decide, was it appropriate? Was there really a catastrophic or unforeseeable event? Or was it a performance issue? So it's totally on the commission here to make that determination at that point. Although we have high confidence, that's why we're guaranteeing the benefits. We think this is in the best interest of customers and the public in general. And so high confidence that this number is met, but there's never an absolute certainty that far in the future. So that's why we put this, why we agreed and put this in the hands of the commission if we reach that.
Mr. Peeler, sticking with you for a moment, on page 14 of your direct testimony, and I'll give you a second to get there. You testify lines 6 through 9 that pump storage is more suited to DEC's service territory due to its mountainous terrain. Conversely, building utility scale solar generation requires areas of flat, open land and is better suited to DEP's current service territory. Is that correct?
That's correct.
And at the bottom of the next page, if you could turn with me.
Page 15.
That's right. And continuing on to page 16, you testify that existing natural gas pipelines run through Western North Carolina in DEC's current service territory, meaning that it's more cost-effective to site natural gas generation in that service territory. Is that correct?
Yeah, that's what the testimony says, and that's generally true.
So in essence, many generation choices are based in large part on geography. Is that fair to say?
The geography is one component that is important in selecting generation location.
What else is important?
Well, you just gave two different things. You just said geography and infrastructure. Those are two different things. The fact that the gas pipelines are in a certain place is not a geography thing. It's an infrastructure. So it's infrastructure, geography, available land, available transmission. I mean, all those things play into this. These are two different examples of one is the geography of the state, mountainous versus flat, or where existing infrastructure has been constructed. So those are two different things.
And how many balancing areas does Duke have?
So there are 3 balancing authority areas and 2 balancing authorities.
Okay. And for the balancing authority areas that Duke does have, can you identify those for the record?
Sure. There's CPO East, CPO West, and Duke.
Can Duke operate those 3 balancing authority areas as one?
No,
Can you explain why not?
certainly. So NERC reliability standards, NERC, the North American Electric Reliability Corporation, oversees the bulk power system in North America. They have mandatory reliability standards. Those standards speak specifically to the roles and responsibilities of a balancing authority. And they speak to what they are required to do. Specifically at a high level, the balancing authority, the entity responsible for managing that specific area, they must match generation and load in real time and other things as well, but that's the primary thing. So there is a responsibility that each of those meets its own obligations within its boundaries. defined by the North Carolina liability standard.
Presiding Commissioner Tucker, I would like to have what SIGFR pre-filed as potential cross redirect exhibit number 24, identified for the record as SIGFR Bowman Peeler Panel Cross Exhibit number 1.
So moved.
Thank you. Mr. Peeler, in the binder that you have in front of you, could you please turn to tab 24?
Which one?
It should be the same binder that the FERC order was in.
Just, could you clarify which exhibit we're turning to now?
SIGFR Potential Cross Redirect Exhibit number 24. Mr. Peeler, is this the, may I proceed, Presiding Commissioner? Mr. Peeler, is this the company's response to SIGFR data requests number 2-3? Okay. And Duke states in response to this data request that no transmission investments are necessary, correct?
That's correct.
Is Duke guaranteeing that there will be no incremental transmission costs associated with the merger?
There are no costs for additional transmission included in our cost to achieve. If you're going down, if you're trying to predict the future, once the systems combine, normal planning processes certainly could identify transmission investments, but they would only be pursued if they are beneficial and cost effective. The current system can be operated with the existing transmission system once combined.
But it is possible that incremental transmission investments will be necessary when the combination occurs.
That's not what I said. I said transmission planning would identify potential beneficial investments, just like always. So it's not incremental investment because of the combination.
If you could turn to your supplemental testimony. On page 7, lines 2-5, you testify that the results of the analysis show that the 1U portfolio saves customers approximately $2.3 billion on a system basis net of CTA over a 14-year period. Is that correct?
That's correct.
Is the $2.3 billion in savings guaranteed?
No, this again, as we've already testified that the guarantee is to cover the CTA and the share the benefits. And also, as I've testified, that future scenario of trying to predict or guarantee that exact amount is a very complicated and also inaccurate exercise. This representation is, again, model results that are based on multiple scenarios. Again, not disputed by really any interveners.
Thank you. No further questions.
Thank you. Next question, Recess. Mr. Jimenez.
That's right, Commissioner. Say all did reserve 15 minutes for to cross-examine this panel on direct. We are waiving that 15 minutes, but reserve the right to ask questions on commission questions and maintain our rebuttal cross.
So moved. Walmart.
Your Honor, in light of the announcement this morning by the company that Walmart has joined the settlement, at this time, we do not have any questions, but again, would reserve in the event things get raised in response to Commissioner questions or on rebuttal. Thank you.
Okay, thank you. All right. We go to commission questions. Is there any redirect at all for Duke?
We do have a few redirect questions if we may.
Okay. May I proceed?
Thank you, Presiding Commissioner Tucker. There's just a few topics that we'll spend a few minutes here on if it's all right with you. So we'll kind of work backwards through some of the topics that were just discussed and clarify a few points. So to be starting with the transmission investment line of questions related to the combination. Just to be clear, are there any transmission investments needed at this time to facilitate the combination?
There are not.
And in the future, how will the company determine whether additional transmission investments are needed?
The company will use its normal transmission planning process, including participation in the Carolinas Transmission Planning Collaborative to identify beneficial transmission investments. So that could reduce other costs or facilitate reliability, just like transmission planning is done today.
Thank you. And when you say beneficial, can you say a bit more about what that means?
Certainly. So beneficial could mean it lowers production costs. It displaces other investment or improves reliability. Those types of things are beneficial.
Okay. So is it accurate to say that, as always, the company will only make those transmission investments in the future that save money for customers?
Correct.
Okay. Now, there were some questions as well about whether or not the rates went down after the 2012 combination, and some similar questions about whether or not rates are going to go down after this combination. I want to ask you all a few follow-up questions on that. So stepping back, is it the case, what kind of investments are needed to provide a reliable service for customers?
I'll start with that one. So as we normally go through our integrated resource planning process, right, we identify those needs to meet the load growth and provide an appropriate reliability margin. We identify investments in both the transmission and distribution systems as well as generation assets. That will continue.
And were those types of investments needed after the 2012 merger to provide reliable service for customers?
Absolutely.
And will they continue to be needed after this combination to ensure reliable service for customers? How does this combination affect the company's decision-making around the investments that are needed to provide reliable service for customers?
The combination actually will reduce the amount of investment needed, specifically in the generation assets required. The combination being able to plan for the single system, a single load curve or peak that will be a little bit smaller than the two combined, and being able to maximize the things that we talked about already of geography and infrastructure and so forth. That new investment will take fewer generating megawatts will be needed versus the two separate systems.
And so is it your testimony that the combination will allow the company to lower costs for customers while still making the investments needed to ensure reliable service?
Yes, that's correct.
So let's also step through just very briefly. There was a discussion about an attempt to draw a distinction between a cost that's avoided and cost savings. Mr. Peeler, can you briefly give an example of the types of savings that the company on the production cost side that's referenced in the settlement, some examples of how the combination will facilitate achievement of savings?
Certainly, from a production cost standpoint, being able to operate this single system allows any generating unit in that combined fleet to be the next unit to be utilized to serve load. So we can always select the next most economic unit in real time to dispatch. Today, the two systems are separate. That's not always the case. The unit has to be selected in the balancing authority that's in. So that combined full use of all the assets to make the most economic choice. And that results in lower fuel costs, lower startup costs for units, fewer starts and stops. So that materializes through production costs. Additionally, the obligations for a single balancing authority versus the obligations, when I say obligations, I mean the NERC reliability requirements, they are lower. So the obligation for the combined system to maintain operating reserves is reduced immediately. The first day, first hour actually, that the new system is operating. So there will be lower production costs and operating costs. So that's how the savings we're talking about tracking and guaranteeing materialize.
And please address your confidence level regarding your view that these savings will in fact materialize starting on day one of this, assuming the combination is approved.
Very high confidence. And as I've said, the immediate, once the balancing authority is combined, there is an immediate lowered obligation. So the first hour of hundreds of megawatts of obligation that the combined company is relieved of. And so that materializes really directly in production costs. So we're confident that we can demonstrate these operational savings. We're also confident that the capital savings will materialize. They're just much more challenging to demonstrate with tracking over time.
And as it relates to this attempt to draw a distinction between an avoided cost and a savings, please give us your view on whether the things you're describing that will result, the efficiencies that you're describing that will result from the combination on legal day one and continuing for decades to come. Please comment on whether those are things that will deliver savings to customers.
So from my perspective, those are savings. It's fuel that's not utilized. It takes less fuel. It takes less cost to operate the units. Those will materialize again very quickly, and I consider those as actual savings that will show up fairly in short order in customer bills.
Thank you. Just two more areas to explore very briefly, Presiding Commissioner Tucker. There were some questions about the FERC decision and some discussion around the impacts on wholesale customers of this combination. Do you recall those questions?
Yes.
And to step back again, big picture on this, just if you could very briefly, Mr. Peeler, remind the commission from your perspective what you believe are the sort of intuitive benefits of this combination for the entire system.
Yeah, intuitively, it's two smaller systems with separate obligations and separate requirements being allowed to take advantage of scale and operating as one combined fleet, one combined transmission system, so forth. That's just sort of somewhat of an obvious natural thought, right? Scale, the ability to use each resource, without those limitations. That's the primary issue here of the benefits.
So we have a big picture intuitive conclusion that the combination is going to provide immense benefits, but what's been complex about getting the approvals needed to effect this combination for the benefit of all customers? What is it about the approvals across multiple jurisdictions that make this very complex to achieve?
So it has the existing costs have to be reallocated is one of the significant challenges. So it's not really a question about everyone benefiting from the future opportunities and benefits. It's redistributing the existing cost allocation, and that requires approval from both retail jurisdictions as well as the FERC.
And has the company been engaged across all three jurisdictions to position this combination for approval in a way that benefits all jurisdictions?
Absolutely. And the share the benefits, while it's easy for it to look simplistic here, there's a lot of effort in that to reach agreement with all those different parties around how this is necessary so that they can all benefit in the long term. And that's what the shared benefits is about.
And you've described the share the benefits as the key that unlocks the combination, correct? And we were discussing the FERC approval, and FERC's approved it, correct? FERC has approved this combination. And what have you described about what's very remarkable about what occurred at the wholesale level to facilitate this combination?
So FERC found this, quickly, they found this in public interest. And part of that is because all the affected customers were supportive.
And how did some of the customers specifically support the combination in terms of the share of the benefit?
Yeah, so they're supportive of it and agreed to to support the shared benefits by providing the 55 million of cost saving of shift.
Okay, so other parties have voluntarily agreed to make the exact same share of the benefit contribution that is being proposed in this
That's
proceeding,
correct.
correct? And was that amount that they've agreed to contribute more than or less than the amount that's being requested in North Carolina retail?
It's 55 million per year, so it's significantly more.
And why do you think the customers were willing to make such a significant contribution, the wholesale customers, to facilitate this combination?
Clearly, they recognize the long-term benefits that they will result in cost savings to them and benefits over the long term. So they're willing to make that decision in the short term for the long-term benefit.
Okay, thank you. One last line of redirect here, and this goes to some questions at the start about the benefits guaranteed under the combination and whether or not those benefits were equal or exceed a particular number. Do you recall those questions?
I do.
All right. So again, I want to step back here and think a big picture. What has the company's analysis consistently shown about the benefits of this combination for customers in terms of cost savings?
They're going to be significant.
Yeah, so even our lowest range is almost 10 times the cost to achieve. So 3 different scenarios between 1 and 3 billion. The cost to achieve, is in the hundreds of millions. So it's about a 10x even on the lowest end.
Okay. And the settlement doesn't change the company's analysis in that respect, correct?
That's correct.
Okay. The settlement does guarantee a specific amount of savings, correct, Mr. Peeler?
That's correct.
And can you just briefly at the highest level explain the logic of the amount that's specifically guaranteed in the settlement?
So again, we stick with the position that customers have the opportunity here to benefit billions of dollars over the long term, but realize, the importance of demonstrating confidence in the cost, being able to cover the cost to achieve this. So what we're guaranteeing is to cover the cost to achieve the merger, plus the North Carolina retail contribution, which is all that the North Carolina retail has at risk here. And so guaranteeing that amount, while we expect the benefits to be in the billions, that should, clear the hurdle for North Carolina retail to be held whole with certainty.
And would you say that removes the risk in North Carolina? It addresses the risk in North Carolina.
It does. It addresses the risk that the costs aren't covered.
And again, your analysis has confirmed the projections of billions of dollars of savings. Have any parties fundamentally challenged the company's views in that respect?
No, no one who's done modeling has really disagreed with the general conclusion.
Okay, and so you have produced analysis showing billions of dollars savings. You've guaranteed a very significant amount of savings, hundreds of millions of dollars. And that's part of the settlement, correct?
Correct.
Okay. Will the savings stop accruing once you get to the guaranteed amount?
They will not. So the savings will accrue really indefinitely. They go on forever. Both the savings that we're tracking and guaranteeing, those types of savings continue, as well as the resource planning and capital savings. They continue to accrue as you gain the benefit. You continue to benefit from that single system versus the 2 separate ones doing their own thing.
So while the settlement guarantees an amount of savings that will equal $286 million, you are very confident, are you not, that this actual savings will far, far exceed the guaranteed amount, correct?
Correct.
So in that respect, Ms. Bowman's testimony is accurate. Do you agree with that?
I agree.
Okay. We have no further questions.
I think we're at the point of commissioner questions. We okay, public staff? Okay. All right, we'll just begin commissioner questions, and Either one of you can answer them, whichever one of you feel appropriate to answer that. First of all, you know, we've sat here this morning, we've talked about billions of dollars in savings and 55 million here, 25 million going here, 1.6 going here, 2.3 billion going here, 3.2 billion going to the average customer out there for Duke. Does this mean on legal day one that there will or will not be a rate increase?
Presiding Commissioner Tucker, there will not be a rate increase. Did you say increase or decrease?
Excuse me, say that again, please.
Was your question, I didn't hear you, a rate increase or rate
Increase,
decrease?
increase always.
There will not be a rate increase on day one. The
Legal day
combination
one, no.
is not about rates. The rates will be handled in separate rate case proceedings.
And I appreciate that statement, but I also am asking so that if the press listens or anybody's watching by TV, they don't expect a rate increase legal day one through the first year of this combination, right?
That is correct. There will be no rate increase on day one in light of this combination. And Witness Byrd can talk about the gradualism of how we're going to integrate this in the combination into rates.
Okay, very well. Could I refer you, well, you probably don't have this, I'll just read this, but out of Exhibit A on page 1 of 3, in the first paragraph, it says customer savings resulting from the combination will not all be realized immediately upon the combination taking effect legal day one. Instead, these savings will accumulate over time as efficiencies of integrated planning and operations are implemented and take hold. So I assume you both agree with that.
I do.
Okay, so for the folks listening by YouTube and or the press covering this, the customers will not receive, we've talked about savings of billions. The customer will not receive a line item refund on their bill. The savings are accumulated over a period of time, 12 to 14 years. Is that a fair statement? And would you like to elaborate?
So Presiding Commissioner Tucker, you are correct. What we're proposing is benefits over time. And the proposal is not to have any kind of specific line item on a bill. We're talking about benefits, for example, reliability purchases. I think that Witness Peeler mentioned. The combination will allow us to make fewer off-system reliability purchases because of the size and the scope and the one balancing authority area. And so that's going to be costs that we don't actually incur. So when we go in for a fuel proceeding, for example, we will not have that added cost. But what we will do is we can certainly work with the commission to be transparent and educate customers on how the combination is providing benefits and reducing costs to customers. But right now, there's no simple line item that will show up on a customer's bill, but it is benefits that we will see over the long term.
Okay, very well. Is it fair to say that the base rates will continue to increase, just not as quickly in DEC, DEP? Is that a fair statement?
So rates are going to continue as we are building infrastructure, whether we are two single operating companies or not. We need to continue to make investments to meet the growth, to ensure reliability, keep the lights on for our customers. With this combination, as Witness Peeler can go into more detail, we see that it will be more beneficial and can reduce the amount of operations and generation that's needed going forward as one big utility.
Okay. It simply allows us to build fewer assets to meet the need and operate the assets at a lower cost.
Okay. All those statements in my mind are accurate and good for this proceeding. But for someone who is not familiar with utility law, such as me, I what is Duke doing to communicate this to customers? Because when we throw out $3 billion in savings, or we talk about the JDA and fuel rider in the first 12 years saving $700 million, what are we doing to communicate to customers? Because this commission, as you are, but ultimately this commission has to respond along with public staff to the consuming public about what's going on. And if you're outside this room or not watching by TV or following this in depth, how is Duke communicating to customers that, one, there'll be no rate increase the first legal year, from the first legal day of the combination, and then moving forward, the savings that we have talked about this morning will be over a period of time, and investments made from the savings into further generation or transmission, et cetera. How are you communicating that to customers? Once I've heard that the primary focus has been on the DEP customers, telling them that there will be a substantial change in name. What have you done to communicate this? Because we are already receiving some calls, and of course, public staff receives calls on high bills all the time and has to deal with the consuming public, and we get them on the commission side as well. How and what way are you communicating to the customer base?
It's a great question, Presiding Commissioner Tucker, and it's one that we will continue to work with the public staff and with this commission on being transparent with our customers. Once we receive the approvals from all, we've got to get all three bodies, the South Carolina Commission, North Carolina, and we've received the FERC. Once we receive all of them together and we move towards actually doing the combination, we will need to put together a customer communication for sure, and need to explain through customers what's going on. I think one of the nice things about the settlement that we've entered into with public staff, Walmart, and Google is we will be tracking some of these benefits and savings that we're talking about, and we will file reports tracking those savings. Now, we're unable to track everything, but we will be tracking some of those savings, and we can certainly share that with customers over time to try to be transparent about the benefits of this combination.
Okay. Let me move on from there. And I guess, Mr. Peter, perhaps this is your question. Of the three cost benefit analysis presented in your direct and supplemental direct testimony, which do the companies see as the most reasonable projection of future possibilities if the combination is approved? Is it the 1.6? Is it 2.3? Is it the $3 billion? You have alluded, I think, from my perspective, that the savings will be ongoing from now on, and that number could exceed the $3 billion number. Could you speak to that, sir?
Certainly. So the analysis in the supplemental testimony is based on our most recent RP filing. So I think that's probably the most likely that we know today. It has the most updated load forecast and most updated resource plan, which is in the middle of the other two. So I think that's I would be, if I had to pick one today, I would say that one's the most likely.
Okay. All right, sir. You mentioned earlier that when over the 12-year period, excuse me, let me back up. For the record, is it correct that this combination was consummated around July 2012? Is that correct?
The holding company merger happened
Right.
in July of 2012.
Yeah, so it's been 16 years. You've had the opportunity to work on that $1 billion worth of savings that you alluded to in your testimony. Ms. Bowman, you stated, Mr. Pidler, that there was a $700 million savings. I think when you did the JDA and the fuel rider, that was a big chunk of the $1 billion in savings. What do you look toward as anticipation as far as the savings goes by having one versus three balancing authorities?
Yeah, so the 2.3 billion number incorporates the production cost as well as the capital deferral that we're talking about. But the big difference between what we're doing today with the JDA and what we would be able to, how we would be able to operate the system when combined, it takes down a few constraints. The JDA only allows us to jointly dispatch, doesn't allow us to jointly commit units. So we can't turn on a DEP unit, for example, for the benefit of DEC. We can dispatch the energy of an online unit economically across the footprint. When you combine, you can commit. You can turn it's all one system then. So a lot of the delta in operational cost between JDA operation like we have today and single company operation are taking down really that constraint. So we can commit the units for the whole system. We can dispatch them for the whole system on a firm basis, not just non-firm energies. That's the biggest operational change. And then on the capital side, it's the ability to plan together.
Okay, at this time, I don't believe I have any, well, let me think. No, sir, I don't believe I have any additional questions for you, Commission. Questions from commissioners, Commissioner McKissick?
I just have a few questions of you just to try to make sure I understand the terms of the settlement that's been proposed. In going through it, I did not see any reference to the contribution from wholesale customers, the 55 million figure. So can you tell me how that's going to function, how that's going to operate, what's going to occur? Since I don't see that reflected in the stipulation that's before us at this time, even though it was referred to in your testimony, Ms. Bowman.
So I believe witness Elliott can go into more details on how that will all function. The wholesale customers have agreed to it. So there is agreement for that to flow. I think we're still figuring out the details on how all of this is going to happen, but I believe witness Elliott and witness Byrd can perhaps help with explaining some of the mechanics of things.
Some of the mechanics. Are there actually contractual agreements with the wholesale customers? Would that be a question best asked of?
There are contractual agreements.
Okay. Now, originally, there was a request for an accounting order that covered 3 different classifications of deferrals. And looking at the settlement, I'm only seeing one that is moving forward at this time. Is that correct?
I think witness Elliott is the best witness to talk about the accounting orders.
All right. Okay. So witness Elliott will be the best one to address those with. Now, let me ask you this. With the most recent order that came in this morning, which Google is a part of, there's discussion about a clean energy tariff and moving forward with that. And I think in their original testimony as interveners, they referred to a similar tariff that I believe was with NV Energy, if that's correct. But can you explain a little bit more of what the goal would be of that clean energy tariff and what is anticipated in terms of that moving forward at an appropriate time?
Yes, we've agreed that we're going to work with Google on trying to come up with an idea, perhaps propose a clean energy transition tariff. I think if you will recall, a while ago, we announced a memorandum of understanding with Google looking at the same thing. We're trying to figure out the parameters and details. I know they reference Nevada as an example. Obviously, each state has its own statutory constructs and requirements. So we are going to be meeting and discussing to try to figure out a way. And this is for our large customers to be able to bring on clean energy resources onto the system to meet their needs. I think of it as an expansion of a green source choice program.
Okay. And do you know what that time frame would likely be?
I don't know that I have a time frame in mind, but we're going to be meeting and discussing.
Okay, now, when it comes to, again, one of the terms and conditions in the stipulation, they talk about establishing a tracking matrix after all the regulatory approvals are granted. And it talks about South Carolina participating in that process. Have there already been discussions held with South Carolina about serving in that capacity and in that role and what that would amount to?
So yes, in the settlement, we have agreed to developing the mechanisms, and Witness Peeler can go into this in more detail on how we would actually track the benefits that we're going to be guaranteeing. We are talking to parties in South Carolina as well. There's nothing that I can really share, but we're optimistic that things are moving in the right direction in South Carolina.
You have anything to add to that, Mr.
I would just add, we've shared the specific categories that we're talking about here, the 4 categories that we've listed here in our testimony, and the approach of jointly agreeing on how to track and monitor. So those conversations are ongoing.
And it's my understanding that if those benefits are not obtained within 14 years, that's when the shareholders of the new reorganized entity would contribute toward making up the shortfall. Is that correct?
That is correct.
Now, there's also what I'll refer to as savings that's anticipated other than just those financial amounts that have been articulated in the stipulation. And I take it in the reason that they have not been, what I will say, categorized in a way that would attribute savings to them is because perhaps they're too speculative. Would that be a correct assumption? And when I say that, you talk about the joint planning capacity and optimizing resource siting and consolidated balancing authorities and along the laundry list. But I guess when I look at the range that was originally identified, going upwards to 3 billion, but on the low side, about half of that one of the reasons that those are not identified in terms of actual dollars amounts that will be realized as a result of this reorganization is because they're perhaps too speculative to actually be able to identify with some degree of accuracy.
Yeah, Commissioner, I think you're on the right track for sure. That the issue is that a lot of those benefits are based on, in order to calculate benefits, you need a 2 utility cost and a single utility cost. The further we move away from having 2 utilities, the harder it is to create those 2 different universes to compare. So if we look ahead, let's just look ahead 10 years, what decisions would have been made by this commission, by the South Carolina Commission on our resource plans during that 10-year period? It makes it hard to look back and compare that. You'd literally have to do the commission would literally have to approve a 2U IRP and a 1U IRP going forward to actually have a comparison. And so speculative is a good word, uncertain. It's just difficult to create that counter universe the further you get out into the future. However, for the benefits we're guaranteeing, those typically are short-term operational things that we can do a comparison of much more readily. So point is exactly right that we've identified benefits that we believe we can track in a practical manner and demonstrate. We still stand by the fact that these other benefits will be realized. It is just more difficult and a little bit fruitless to be able to create that separate universe.
Now, let me ask you this. South Carolina is a separate independent regulatory body, but assuming that this commission were to accept the stipulation that is before us at this time, and of course that's unknown, it's my understanding they're looking for an additional $173 million that has been discussed in terms of something of a far greater magnitude than the curative benefits plan that is before us for consideration that's incorporated into the stipulation. What would be the process for addressing this difference in magnitude if South Carolina were to reject what is before us at this time? What do you see procedurally unfolding to address any difference in opinion relating to this proposed reorganization?
Well, we can't predict the future, Commissioner, so we're really not sure, what would happen. If we did in that hypothetical, we would need to reassess the materiality. What did they not approve? What did they change? What is in the order? And if it's something that we could live with, we would come back in front of this commission. That's kind of how the process probably would work, but we don't know. We'd need to reassess and see what it was.
All right. And in terms of the cost to achieve, the way I read the settlement agreement, it's envisioned that there will be a rider in a future rate case of the reorganized entity that would allow you to recover that, but just the debt, but not a return. Is that correct?
That is correct. And Witness Elliott can go into all of the details on that.
Okay. Having just seen some of these documents, it's a little more challenging to go through them and ask more thoughtful questions at this time, but Presiding Commissioner Tucker, I think that kind of covers the key things that were on my laundry list as a result of reviewing the settlement agreements, which I wanted to get greater clarity and specificity about. Thank you.
Thank you, Commissioner Kissick. I think right now we'll take a 10-minute break and we'll come back on at 11:35. Thank you. Record. We'll continue with commissioner questions with the chair, William Brawley.
Thank you, Commissioner Tucker. There was one thing I wanted to talk about a little bit. Part of the savings that were included was 242 million in savings from not buying 200 megawatts of batteries. And, batteries have been a real discussion in a lot of the solar CPCNs that have come in and a way to make the electrons more usable. How long will it be before you have to come back and buy 200 megawatts of battery if you delete this from the current CPCN, or excuse me, CPIRP?
So the specific savings here from removing a battery is it's capacity megawatts. So it's not solar power with storage. It's a standalone battery. Its purpose is to help meet reserve margin, have capacity on, let's just say, a winter morning. And the combined system eliminates the need for that 200 megawatts. So it's gone. That specific 200 megawatts is the need for it is explicitly removed. Future resource plans may identify additional resource needs, right? But that particular battery is actually removed from the current RP proposal. The proposed resource plan with that battery removed meets our resource needs of the combined system for that study period. But it is needed if the two systems stay separate. So it is explicitly removed for future studies, if you will.
So if I can restate what I'm hearing, absent the merger, you will need this 200 megawatts plus everything else you're going to ask for over the next 20 years. With the merger, you will never have to ask for these 200 megawatts, but you'll still be asking for all the other things that would add on absent the merger.
That's correct. So it removes that need in this resource plan because the need is for a specific, to meet the DEC reserve margin. And with it removed, with the system combined, the combined system can achieve the combined reserve margin without that resource. So it's removed from the plan.
Thank you.
That's it. Commissioner Vandervaart.
Thank you, presiding commissioner. So overall, from a sort of a high level view, DEC customers are going to be paying more and DEP customers are going to be paying less, right, over time, because you're going to be trying to get through one rate. Is that overly simplistic?
I believe that's overly simplistic.
Please clarify.
The analysis shows through this combination, all of the customers are going to be benefited. And when you get into the actual.
So so DEP and DEC customers their rates are going to go down. Or their rate of increase is going to decrease.
Right.
The latter.
The latter.
But will the rate of increase for DEP be different than the rate of increase for DEC? Since they're starting at different points, the initial conditions here are different. Since we're doing a little differential equations here, I mean, I get it with the rates, but the initial condition for DEP customers is higher than DEC. So is their rate of increase going to be less than the rate of increase for DEC customers?
I think this is more appropriately asked to witness Byrd. We're not doing the rates allocation, the proposals to do gradualism. So witness Byrd probably better to answer these questions.
Mr. Peeler, could you just follow up on Chairman Brawley's question? What was so your position is that were the merger not to go through, those those 200 megawatts battery were going to have to be installed. Correct?
Correct.
What was the schedule for that?
I think it's 2030.
2030?
I think that's right. Subject to check, but I think that's right.
So I was looking at the savings that you're putting forth to cover the CAT, and I note that they were in nominal dollars. If I calculate the 14, what is it, the reduction that you're going to realize due to the batteries not being installed in 2030 and net present value dollars, that's going to be a little bit less. And the benefits to the customers were going to be over 14 years. I did the net present value calculations on it. That's a lot less. So when I add those two net present value values together, you're actually under the, what is it, 200 and the CAT. Is that right? Because your CAT costs are going to be incurred pretty quickly.
Well, yeah, the
See what I'm saying?
I do, but I don't think it's quite that straightforward.
I didn't think it was.
Yeah, and actually, I hate to keep saying this, but I think witness Elliott can explain the revenue requirement.
Okay.
Cash flow is much clearer, but at a high level, the CTA costs don't start being incurred immediately. They're later in the flow here as well.
They look to me to
But I
be
think she can
pretty
she can line
soon.
that up.
Certainly not 14 years. And you're cutting this on a razor thin margin. Even though you've claimed that there's going to be, uber savings, you're only committing to very small savings. And so that's why I have to sharpen my pencil and look at present values. And it looks like you're coming up short. The two sweeteners that were added this morning when we were walking into the room here, are you, one of them has to do with, I think that chargers and something to do with solar. You're committing here, they're not going to be funded by ratepayers. They're going to be funded by the participants. Is that right? Because they're not in this calculation that we just talked about.
Are you referring to the settlement with
Yes.
Walmart?
Yeah, and Google, I think. I just want to make sure that those, whatever that is, it was very vague, and you alluded to the fact that it was very vague. I just want to make sure that my understanding is that you're committing that whatever that ends up being, it's not going to be funded by the ratepayer, because otherwise we ought to fold it into the razor thin margins we're working with here.
They are outside of the scope.
They're in the settlement.
They're in the settlement, but
Okay.
those were provisions that we've agreed to work with those parties on.
And they're not going to be funded by the general ratepayer.
That is my understanding.
Very confident of that. That sounds a very, very, very confident answer there. So I mean, everybody's been beating around this thing, but we're talking about, we were told this was going to be a huge benefit. You've said it's a huge benefit. And it's a little bit disappointing when we were told we were going to be served a very high-end meal, and now I come in here and it's McDonald's. And the only person that seems to be protected by this settlement are your shareholders, because of the very low bar that has to be met before they have to backstop any shortfall. You have a very narrow set of benefits that you're tracking, and you explained, I think, Mr. Peeler, that it's just difficult to get some of these guys. When you did the work in anticipation of this merger, what were the kind of savings you were getting just from the efficiencies for your dispatch, your ability to dispatch a broader universe of resources? And as you alluded to earlier, you expect to see substantial savings because of the ability to dispatch more efficient resources. Did I get that right?
Yes.
So when you did the work in preparation, what were the kinds of numbers that you were seeing I guess, through modeling and what have you.
Yeah, I don't recall the exact breakdown of the numbers, but we certainly believe that the dispatch savings we're talking about guaranteeing that we expect to achieve those. And so that.
Guaranteeing, you mean you're talking about the 44 million that's left over after we take.
And realize that's the 44 million is North Carolina retail portion. So the system savings are larger than that.
Yeah,
Again,
I'd say they're
generate-
quite a bit larger.
Yeah, so probably 70 or 80 million to get 40%.
Is that what you remember seeing when you were doing the production cost modeling?
It's larger. It's that or larger.
Right.
Yeah.
How much larger? Do you remember?
I do not.
Hundreds of millions?
I just don't recall. I mean, the biggest portion of the money is associated with the capital deferral, but there are significant dollars in production costs, and it's definitely 100 million plus. But I don't have the numbers in front of me.
Yeah. Are you tracking the deferred generation and transmission capital in the settlement?
We've not proposed to do.
So it's the biggest benefit and you're not tracking it in the settlement.
Correct.
So no wonder we're only talking $44 million, right? Well, whatever it is net present, I calculate about 18 million. Okay. Well, that's all for now.
All right, thank you, Commissioner. We have questions on Commissioner questions?
Yes, Presiding Commissioner.
Yes, ma'am, go ahead.
Thank you. Ms. Bowman, you answered a question from Presiding Commissioner Tucker regarding a potential rate increase on legal day one of the merger. And I want to circle back to that because Duke Energy has a rate case that is pending before the commission. Is that correct?
Yes, that is. And I'm glad you brought that up because I was mistaken. I had forgotten the rate cases. I'm not sure how I could have, but not related to this combination that sits in front of the commission. Those rate cases that you're referencing are the DEC and DEP that are before this commission this year. And ultimately, you'll have the authority over those rate increases, but the timing of those would take effect on January 1.
And so just to be clear, continuing on that same question explored by Presiding Commissioner Tucker, on legal day one, January 1st, 2027, there will in fact be a rate increase subject to the commission's approval in the pending rate cases.
That is the day that in those rate cases, we have the rate increase to be effective, but it is not related to this 1U combination.
Ms. Bowman, it's fair to say that for the remainder of this decade, at least, rates are only going in one direction, at least as it pertains to base rates. Is that fair to say?
I think we are continuing to make infrastructure investments. North Carolina's #1 state for business, got a lot of growth coming to the state. So we're going to continue to need to make investments. And when we make investments, we will see needed rate increases.
So yes, rates will continue to increase.
I can't promise crystal ball, but I do see significant investments being made. And I think, to keep the lights on from reliability to meet the growth, we will need to come in for rate cases.
Thank you. I want to turn to Commissioner McKissick's questions regarding South Carolina and the share the benefits proposal. Ms. Bowman, you alluded to the possibility of needing to come back in before this commission in the event that either something is stipulated or decided by the Public Service Commission of South Carolina in such a way that requires a contribution in excess of what Duke has proposed under the share the benefits plan. Do you recall that testimony?
I do. But we believe the settlement that we have reached with the public staff and other parties puts us on a really good path for South Carolina. The public staff agreed to, from their testimony, they were having 20 million share the benefit savings. This settlement raises that to 25. We believe that puts us in a really good position in South Carolina. We're continuing to work with the parties in South Carolina, and we feel very positive that we're going to be able to get there in the state of South Carolina. But in my line of questioning, I did say, if for some reason in a hypothetical, we would need to reassess and reevaluate.
And I want to explore what you mean by that statement. As we sit here today, there is uncertainty, is there not, regarding where South Carolina is going to come down on this issue?
We cannot predict, but we believe that this settlement we've put in place puts us in a really good position for South Carolina.
And so it would be appropriate, wouldn't you agree, to, at a minimum, leave the hearing open in North Carolina until the South Carolina stipulation is filed or until the South Carolina Commission issues an order resolving this issue?
I do not believe that that's necessary. I believe we're in a really good position in North Carolina, just as the FERC approved and deemed this combination in the public interest. I believe what we've put forward, particularly with this settlement with public staff, puts us in a really good position and should be deemed in the public interest for North Carolina.
But in this hypothetical scenario, to use your words, hypothetical scenario, who would be left holding the bag if South Carolina decides that a share the benefits contribution in excess of what Duke has agreed to the public staff in its filed stipulation in this proceeding? If South Carolina finds that that is not sufficient?
I think it's too much speculation to go into hypotheticals and what ifs and whatnots. We don't precisely know what would happen. If something changed, we'd need to assess the materiality of that.
North Carolina retail ratepayers could be on the hook for that difference, correct?
We don't know what would happen, but they would not be on the hook without this commission's approval.
Thank you.
Further questions on commissioner questions?
I do, Your Honor, very briefly.
You recognize?
Thank you, Chair Tucker. If you believe that this question should be directed to Company Witness Byrd, please let me know. Commissioner Vanderbart asked you all some questions specifically about the new language related to Google and Walmart and whether those would have rate impacts for customers. And I just want to ask you a few questions about that.
Witness Byrd is probably the best. I'm not very familiar with those.
I will ask them and then that way we can defer the specific questions instead of the topic. You understand that the agreement reached with Walmart concerns proposing a future rate with respect to DCFC EV charging in a future case. Is that correct?
That is correct.
And so that issue will come back before the commission with a rate for them to consider in that subsequent docket, not as part of this merger.
That is correct.
But the parties have contemplated that should some level of agreement be reached on what that rate design would look like, that it could potentially be proposed for this commission's consideration in the company's pending multi-year rate plan base rate proceedings that are pending before the commission right now.
That is correct.
But to the extent what is agreed to, though, within the context of the settlement in this case, with respect to Walmart and the paragraph with respect to Walmart's ask, there are zero rate implications as a result of that specific agreement. Is that correct?
That's correct.
Thank you. Those are all the questions that I have.
Further questions on commissioner questions?
Presiding Commissioner Tucker. Just a few, if there's none from the other parties.
Just none from the other party? Okay. Board Med, Mr. Durack.
Thank you. Just to I'll approach that line of questions just one more time for the sake of clarity. The commitments in the settlement agreement for Google and Walmart solely involve engagement and discussion, correct?
That is correct.
And the company there's no cost associated with that. That would be part of the CTA.
Correct.
And if anything comes out of those discussions, it will be presented to the commission, correct?
Correct.
And the commission will be free to decide whether or not those proposals provide overall benefits for customers at that time.
Correct.
Okay. So just stepping back, the company has frequently described this combination as an operational combination. What does that mean, and who fundamentally receives all of the benefits of this combination?
Objection. Presiding Commissioner Tucker, he did not associate this line of questioning with any line of questioning asked by a commissioner, as was requested by Presiding Commissioner at the outset of the hearing.
Sustained.
So, thank you. If I may, Presiding Commissioner Tucker, these questions relate to a number of questions asked by the commissioners about the benefits and the amount of the guarantees that are being provided relative to the benefits, including questions asked by you, Commissioner Brawley, and Commissioner Vandervaart. So I want to lay the foundation for the discussion around benefits and why we are guaranteeing a specific amount of benefits in this case.
Could you rephrase?
Sure.
Your question to align with questions asked by us? If you remember in my reading, you needed to recognize the commissioner who asked the question and then repeat his question as you go through this process. But what you're stating, I understand the objection, but I'll just allow it to be permissible if you'll rephrase.
Absolutely.
To align with what we've outlined earlier. Okay.
Absolutely. Thank you. Again, a number of the commissioners asked questions about the scope of the guaranteed benefits, and Commissioner Vandervaart specifically was asking questions about why the company is not willing to guarantee a higher amount of benefits in this case than they're guaranteeing through the settlement. And I would like to ask questions around why the company's guarantee is what it is.
That's permissible. Go forward.
So again, in light of the questions that you were asked about why it is that the company is guaranteeing the amount of benefits that they're guaranteeing, who receives the benefits of this combination?
Various customers.
Does the company receive any direct financial benefit from this combination?
Company does not.
And so the company has elected voluntarily to pursue this combination in order to deliver cost savings, all of which will be received by customers.
That's correct.
And has any party to this proceeding identified a direct financial benefit to the company in pursuing this combination?
None that I'm aware of.
And again, what is the logic behind the specific amount of benefits that the company has agreed to guarantee in this proceeding?
Company has agreed to guarantee the potential cost implications to North Carolina retail so that they can reap the benefits that are much larger. So it's really assurance that the customers will not have the obligation to pay for the cost to achieve or the share of the benefits that is necessary for the other parties to make this transaction complete, that those costs will be assured. And so that's what the company has guaranteed. It's because we believe in the transaction is beneficial for all customers.
And does that reduce or eliminate risk for customers associated with this combination?
Absolutely. It reduces all the risk of bearing the cost of the transaction.
And is the company taking on risk in pursuing this combination?
Absolutely.
Objection. Presiding Commissioner Tucker, I'm going to reassert the same objection because Mr. Durack has now moved on to a different line of questioning and is not tying his questions to any specific questions asked by any of the commissioners.
Commissioner Tucker, all of this discussion relates to the question of what is an appropriate amount of guarantee of benefits, which was a question asked by Commissioner Vandervaart as well as other commissioners. And in order to explain why the company believes the amount of guaranteed benefits it's providing is reasonable, one has to look at the overall balance of risks of this transaction.
Well, perhaps if you'd identify the commissioner as you start the questioning.
Sure.
And then restate the question from the commissioner and then move forward from there. And that's aligned with what you're trying to ask. And I'll allow that to be permissible.
Sure. And this is the last line of questions on this topic.
Okay.
So going back again to Commissioner Vandervaart's questions about why the company is guaranteeing the level of benefits, how does the risk borne by the company in pursuing this combination inform why you believe the guaranteed benefits before this commission are reasonable and fair to customers?
Yeah, the company bears the risk of guaranteeing the benefits. So if they're not achieved, then the shareholders will pay at the end to cover those costs. And as we've said, the company doesn't have a direct financial benefit, customers benefit. So the company is bearing the risk of guaranteeing the cost to achieve as well as the share of the benefits contribution from North Carolina.
All right, turning to a couple other issues that are addressed. Commissioner Vandervaart specifically asked about whose rates will increase faster in the years ahead post combination, assuming the combination is approved. Do you recall those questions? And recognizing that Witness Elliott can also address some of these questions, would you agree that the commission retains full discretion to assess the appropriate rate at which rates are merged together over time?
Yes.
And so the commission is equipped to make those judgments in future proceedings around what's the fair and appropriate way to merge rates.
Yes.
And nothing about what's being in front of the commission today is binding them in any respect to decisions on those issues.
That's correct.
Thank you. I want to turn now to a few questions from Commissioner McKissick. He asked a number of questions, one of which involved South Carolina and the parallel proceeding there. As you also testified earlier, this is a unique proceeding in that it requires 3 parallel approvals. Just as a quick reminder, which of the proceedings have already been concluded?
The FERC.
And so would you agree it's sort of an unavoidable element of a 3-way approval that states have to go somewhat sequentially?
Yes.
And we now have approval from FERC, correct?
Correct.
And do you believe that the proposal that you have in front of this commission as modified by the settlement is a reasonable and fair outcome in North Carolina that will lay a very strong foundation for approval in South Carolina?
Yes, and as I previously said, we are very confident that what we've put in front of this commission will be what's needed in South Carolina.
Thank you. And just a few more questions, if I may. I want to return to a few commissioner questions that Presiding Commissioner Tucker asked, and were also clarified by questions from SIGFR Council. As we think about the relationship between a pending rate case, such as the one that's pending in this combination, is it the case that over the long term, you believe this combination will allow future investments to be lower than they otherwise would because of this combination?
Objection. This is redirect, Presiding Commissioner Tucker. This is not questions on commissioner questions.
Commissioner, I would ask the opportunity to specifically address the questions around will rates increase on day one, and the further questions that you asked around how customers will see the benefits of this combination, whether it'll be a line item on a bill or there'll be other opportunities for customers to be made aware of the benefits of the combination. Those were topics that you explored in your questions. I think they're important ones for the witnesses to address.
Since it's my question, I'll do
Thank you. Thank you. And I will be as brief as possible here. In all future rate cases, is it the case that the commission will have the opportunity to review the investments and the decisions driving the need for rate increases?
That is correct.
And does the commission also oversee all of our resource plan decisions going forward in the future?
That is correct.
And so would you agree generally that the commission will have full ability to assess all of the investments the company needs to make in the future to ensure reliable service for customers?
Yes.
And this combination doesn't change any of that?
It does not.
Do you continue to believe this combination will allow us to deliver reliable service at a lower cost?
Absolutely.
And Commissioner Tucker again asked about how do we make the average customers who don't know what the JDA is, don't know what the CTPC is, how do we make them aware of how this combination is benefiting them? Do you recall those questions?
I do.
Is it your view, tell me how the guarantee of benefits and the reporting around those benefits will be one of the tools that can be used to help customers understand the benefits of this combination.
And those benefits are, again, they're guaranteed, they're captured, they'll be reported. So they'll be visible. And the commission will have the visibility to that, and they can be shared and demonstrated the impact that it has for customers.
And we can work with the public staff, and I believe Witness Byrd is already thinking about customer communications. So we can work with the commission staff and public staff to figure out a manner in which could be easily understandable for our customers. We understand this is a complex transaction, and we want to be able to show our customers the benefits that they will be receiving from this.
And again, going back to the normal customer, at the end of the day, would you agree the average customer just truly cares about the bottom line on their bill, correct?
Right, most customers simply care about that.
And Ms. Bowman, is it your view that both this combination will help us to keep that number as low as possible, and that the company is also doing everything in its power to keep that number as low as possible while still providing reliable service for customers?
Yes, we do not take rate cases lightly, increasing rates for customers lightly. So we are doing everything we can, cost control, operational efficiencies where possible, supply chain, negotiating rates as low as we can with vendors. We're taking advantage of tax credits. I think you're all aware of the nuclear production tax credits to help lower cost for customers. So we're really working hard to try to do everything we can to keep cost as low as possible.
And this combination is one of those tools to keep rates as low as possible.
Yes, it is.
Thank you. I have no further questions.
I believe that ends the period for questions on commissioner questions. Folks, it's about 12:07. Let's just go ahead and go to lunch and come back at 1:05. All right, we'll adjourn for 1:05. Thank you. Are there any motions?
Yes, Sigfer would move admission of its Sigfer Bowman Peeler Cross Exhibit number 1 into the record, please, at the appropriate time.
Okay. Without objection, so ordered.
Thank
Thank you.
you, Presiding Commissioner Tucker. We previously moved all of the pre-filed testimony relevant to the witness's appearance into the record, and I appreciate that. Just want to confirm that the witnesses are excused from further testimony at this time, and they will be, of course, appearing on rebuttal.
Well, I was going to ask them to come back up so I could ask them to step down.
At your leisure.
The attorneys told me to say it that way.
Whatever you prefer.
No, they can be excused for the time. Expect to come back up though.
Thank you very
Okay, you may call your next panel of witnesses.
Thank you, Commissioner Tucker. At this time, the companies would like to call Ms. Rachel Elliott and Mr. Jonathan Byrd to the stand.
Mr. Byrd, Ms. Elliott, if you would place your left hand on the Bible and raise your right hand. You solemnly swear that the testimony you're about to give is the whole truth and nothing but the truth, so help you God?
Yes.
Okay,
Yes.
thank you. All right.
Thank you. I'll start with Ms. Elliott first. Ms. Elliott, good afternoon.
Good afternoon.
Can you please state your name and business address for the record?
So my name is Rachel Robinson Elliott. My business address is 1201 Main Street, Columbia, South Carolina.
And by whom are you employed and in what capacity?
I am employed by Duke Energy Carolinas as the Director of Rates and Regulatory Planning.
Thank you. Ms. Elliott, on August 14th, 2025, did you cause to be pre-filed direct testimony consisting of 36 pages and Elliott Exhibit 1 consisting of 2 pages?
Yes.
Do you have any corrections to your pre-filed direct testimony or exhibit?
No, I do not.
Ms. Elliott, if I ask you the same questions that are set forth in your pre-filed direct testimony today, would your answers be the same?
Yes.
And on October 3rd, 2025, did you cause to be pre-filed supplemental testimony consisting of 10 pages and Elliott Supplemental Exhibit 1 consisting of 1 page?
Yes.
Do you have any corrections to your pre-filed supplemental testimony or exhibit?
No, I do not.
If I asked you the same questions that are set forth in your pre-filed supplemental testimony today, would your answers be the same?
Yes.
Ms. Elliott, on February 24th, 2026, did you cause to be pre-filed settlement testimony consisting of 6 pages?
Yes.
Do you have any corrections to your pre-filed settlement testimony?
No, I do not.
Ms. Elliott, if I asked you the same questions that are set forth in your pre-filed settlement testimony today, would your answer be the same?
Yes.
Ms. Elliott, did you prepare summaries for your direct, supplemental direct, and settlement testimony?
Yes.
Thank you. Commissioner Tucker, at this time, the companies would ask that Ms. Elliott's pre-filed direct, supplemental direct, and settlement testimony be entered into the record as if given orally from the stand.
Without objection, so ordered.
Thank you. And that Ms. Elliott's direct, supplemental direct, and settlement summaries be entered into the record as if given orally from the stand.
Without objection, so ordered.
Thank you. And that Ms. Elliott Exhibit 1 and Supplemental Exhibit 1 be marked as pre-filed.
So ordered.
Thank you. I'll move to Mr. Byrd next. Mr. Byrd, good afternoon to you.
Good afternoon.
Can you please state your name and business address for the record?
Jonathan Byrd, 525 South Tryon Street, Charlotte, North Carolina.
And by whom are you employed and in what capacity?
By Duke Energy, the Managing Director of Rate Design and Regulatory Solutions.
And Mr. Byrd, on August 14th, 2025, did you cause to be pre-filed direct testimony consisting of 11 pages?
Yes.
Do you have any corrections to your pre-filed direct testimony?
I do not.
And if I asked you the same questions that are set forth in your pre-filed direct testimony today, would your answers be the same?
Yes.
Mr. Byrd, have you prepared a summary of your pre-filed direct testimony that was pre-filed in this docket?
Yes.
Okay. Commissioner Tucker, at this time, the companies would ask that Mr. Byrd's pre-filed direct testimony and direct testimony summary be entered into the record as if given orally from the stand.
Without objection, so ordered.
Thank you. Commissioner Tucker, Ms. Elliott and Mr. Byrd are available for cross-examination and questions from the commission.
Okay, thank you, sir. We'll do the cross now and call on Siegfried.
Thank you, Presiding Commission. Thank you, Presiding Commissioner Tucker. Ms. Elliott, Mr. Byrd, my name is Peter Ledford. I'm with the law firm of Ward and Smith, and I'm here on behalf of Sigford 2 and 3. I believe you were both in the room this morning for the testimony from Witness Bowman and Witness Peeler. Is that correct?
That's correct.
Yes.
I want to follow up with a few questions that were asked of that panel that were deferred to this panel, I think. And Witness Elliott, this is going to start with your testimony. On page 24 of your testimony, you state that wholesale customers are going to provide $55 million per year to South Carolina for 5 years as a part of the Share the Benefit plan. Is that accurate?
You're in my direct testimony?
Yes, ma'am.
Yeah, that's correct.
All right. And we asked, my co-counsel asked some questions about the FERC order approving the transaction. Are you generally familiar with that order?
Yes.
All right. And if you need a copy of it, in front of you should be a binder that says Sigford Cross Exhibits Part 2 of 2. It's the smaller of the two binders. I believe Witness Byrd has it right there. It's behind number 29 there, and the commission has previously taken judicial notice of this order.
Okay.
And so on page 13 of the FERC order, in paragraph 37, the FERC writes that each legacy Duke Carolinas wholesale, applicants explained that after deriving the per Duke Progress wholesale customer contribution to the Share the Benefits plan, they calculated an annual amount for the transition period that would mitigate the rate impacts of the proposed transaction for each legacy Duke Carolinas wholesale power supply customer. Is that accurate?
Correct.
And so my question generally is, where's the $55 million going from the wholesale customer contribution? Is it going to South Carolina retail, or is it going to Duke Carolina's wholesale customers?
It's going to South Carolina retail customers. So the Share the Benefits framework, it's designed to be a jurisdiction from the retail's perspective. It was a framework to address the jurisdictional cost reallocation challenge that we have in South Carolina. But within the wholesale jurisdiction, they take service under formula rates. And so they had kind of a two-part Share the Benefits framework within the FERC jurisdiction. And so there was one part to address the DEC versus DEP wholesale impacts from the cost reallocation. And then there's a second component to the Share the Benefits plan within the FERC jurisdiction to address the contribution to the South Carolina retail customers. So the $55 million is the net impact after the DEP wholesale customers share benefits with the DEC wholesale customers. That difference is then going to be contributed to South Carolina retail jurisdiction.
So if you go back in the FERC order to paragraph 36.
What page are you on?
This is on page 12.
Okay.
Do you have it in front of you?
12.
Yes.
So about 4 lines down, it says that wholesale customers will contribute $55 million per year to the Share the Benefits plan for 5 years, beginning on January 2027. So the FERC, that is only part of what wholesale customers are contributing. That's your testimony?
That's correct.
Okay, thank you. Switching gears and going back to your direct testimony. On page 24 of your direct testimony, you have a figure of the cost to achieve that are going to be coming up over the next, 12 years or so. It's figure 6 on page 24.
Yes, I'm there.
All right. And that shows that for the years 2027 and 2028, there would be net benefits of $14 million and $13 million respectively. Is that correct? Oh, I'm sorry. I misspoke. If you could please turn to figure 1 of your supplemental testimony on page 7 of your supplemental testimony.
Okay.
Now, does that say in 2027 and 2028, there will be net benefits of 14 and $13 million respectively?
Yes.
All right, thank you. Now, this is probably to both of you. The Bowman Peeler panel earlier today testified that the company won't benefit, that all benefits flow through to the ratepayers, the shareholders receive no benefit, but that the company bears the risk. Is that an accurate summary of what was stated just before lunch?
I think that's an accurate summary.
Okay. So, Mr. Byrd, turning to your testimony, on page 4, you note that customers will not experience immediate changes to their existing retail rates upon consummation of the merger, correct?
This proceeding is not going to drive.
Excuse me, Council, give us time to get to that, if you would, please. Say that again, please, under Bird's testimony.
Witness Bird's direct testimony, page 4.
Okay, thank you, sir.
And so retail rates are not going to change as a result of this proceeding on legal day 1, correct?
My testimony says that customers will not experience immediate changes to their existing retail rates upon consummation of the combination. That's correct.
Thank you. Presiding Commissioner Tucker, I would like to ask that the pre-filed SIGFR potential cross redirect exhibit number 26 be identified as SIGFR Elliott Byrd panel cross exhibit number 1.
Number 1.
Yes, sir.
Without objection, so ordered.
And Witness Byrd, could you please read the request that SIGFR asked in this? And item number.
Repeat where I'm supposed to read, I'm sorry.
SIGFR potential cross exhibit number 26. It isn't, it's in that. No, I'm sorry. It's in binder 2 of 2.
This is the discovery request?
Correct.
And you want me to read the request or the response?
The request, please.
The request says, witnesses Elliott and Byrd discuss the fact that the combined utilities retail rates will not change on legal day 1, but will instead be adjusted in a future general rate case. Please identify the combined utilities anticipated rate of return for 2027 and 2028.
And the response is to please see the response to a different question. Is that accurate?
That's correct.
Presiding Commissioner Tucker, at this time, I would ask that SIGFR potential cross redirect exhibit number 25 be identified as SIGFR Elliott Byrd panel cross exhibit number 2.
Without objection, so ordered.
Now, Mr. Byrd, could you flip back to item number 25 right before that?
Yes, I have that.
Thank you. And this is the company's response to the question that you read moments ago. Is that correct?
It appears to be yes.
And the response says that the answer to this question at this time is unknown and unknowable, correct?
The response says the companies do not concede that the combination will produce decrements to ROE or cost of debt. However, the answer to this question is at this time unknown and unknowable. I just read a portion of the response.
Thank you. So the company bears all the risk was the testimony previously, but this testimony is that it's unknown and unknowable. Excuse me, this response is that it's unknown and unknowable if the company will over earn as a result of the merger. Is that accurate?
I believe the response says the companies do not concede that the combination will produce decrements to ROE or cost of debt.
Okay. So then going back to Elliott's supplemental figure 1, where does the $27 million in savings go?
That's the $27 million. The savings that's modeled in this exhibit are savings that would go directly to customers.
But we've also established that retail rates will not change on legal day one. So how are they going to customers on legal day one?
Modeled assumption. And if you look at, let me pull up, see. So if you look at the savings that's modeled in, and this is cost benefit analysis number 3, which is our most recently filed in the supplemental. The total system benefit for those 2 years is approximately 26 million. The North Carolina retail allocated portion of that is approximately 17 million. If you break that 17 million down by the drivers behind those savings, a large portion of it is related to costs that, or savings that would be included in the fuel rider. And so those savings, when we would file our 2027 fuel rider, because fuel rider proceedings are an annual proceeding, any savings related to the combination would be reflected in that fuel rider proceeding.
Now, witness Byrd, General Statute 62-133.16 is the performance-based rate making statute, the multi-year rate plan statute. Is that accurate?
Subject to check, I'm not sure.
And under that, Duke is authorized to earn up to 50 basis points above its set ROE. Is that accurate before it has to be refunded to customers?
I believe there's an earning sharing mechanism that applies to what you're describing.
And do you happen to know the dollar amount of that 50 basis point delta?
I do not.
Okay. And so some of these benefits that are described here are going to be a part of that 50 basis point delta between the ROE and the actual earnings due to the savings.
The benefits are benefits that would run through the fuel rider. So they're not impacted by the earning sharing mechanism.
All benefits, all $2.3 billion of benefits?
Or you were asking about what's going on in 27 and 28. And so the amounts that, the benefits that have been quantified in that figure are benefits that would run through the fuel rider. So they would not impact the earning sharing mechanism.
Yeah. Is it the company's positions that the benefits of $2.3 billion in savings are both modeled but also unknown and unknowable, as was stated in the discovery response?
Yes, I mean, you were about to say something. Go ahead.
I was going to, the unknown and unknowable reference in the discovery response is referencing a question that's pertaining to the company's borrowing cost and cost of equity. And so the reference, the full response here says essentially that future cost, future capital market conditions, interest rates are unknown and unknowable. That's the reference that we're talking about here, is what are my borrowing costs out over a long period of time? I think that's what this response is referencing.
That's one of the responses referencing one of those questions, but it's also referencing item number 26, which was the requested rate of return. You remember the first exhibit you read at, and it referenced the previous?
It just said, look back at that. That's right.
Right. So the anticipated rate of return is unknown and unknowable, but the savings are modeled to be $2.3 billion. Is that a fair summary?
I was just trying to make sure that this wasn't applying more broadly, because it was in the discovery response. Unknown and unknowable is specifically referencing this question about, cost of debt and so forth going forward.
Okay. Thank you. No further questions, Commissioner Tucker.
Thank you, Mr. Leffert. Now we'll hear from NCSEA.
Good afternoon, Presiding Commissioner Tucker. At this time, NCSEA actually has no cross-examination for the panel.
Very well, thank you. All right. Next up on the block is SACE. Mr. Jamete.
Excuse me, good afternoon, Presiding Commissioner Tucker. SACE et al. Have reached a settlement in principle and will be waiving across of this panel.
Okay, very well, sir. All right, and then I think that would probably be the last one on the list would be Walmart.
No cross, Your Honor.
Okay, well, that's pretty good. Can we go to Commissioner questions? Any redirect there?
No redirect.
Okay. We'll go ahead and start with Commissioner questions. And I've got a few and commissioners do too. I guess my first question will go to you, Mr. Byrd. Thank you for being here, sir. You cover the customer communications plan, is that correct?
I have colleagues that do, and I've spoken with them extensively about what our plans are at this time, so I can answer your
Okay.
question there.
Well, then if you have, can you elaborate on how Duke has brainstormed those ideas with your colleagues on how customers can better understand the merger, specifically its impact on rates? Because now it's clarified by Ms. Bowman, we do not have a rate increase legal day one, January 1, 2027. We do not have a rate increase that's applicable to this business combination agreement or settlement. So we don't have a rate increase from that. However, Duke has a rate increase now in a docket. How are you going to explain to customers this combination is going to save you all kinds of money, yet we're going to increase the rates perhaps if approved by this commission in the first year? I mean, it's like saying one thing and doing another. How can you explain that or communicate that to customers? Because again, as I stated earlier, public staff gets the calls, we get the calls, you get the calls on rate increases whenever they happen. And so we're coming out with this communique of saving you all kinds of money over a 14-year period, but you're not going to see it as a line item on your bill now. But, oh, by the way, we're going to have a rate increase in 2027. How do you differentiate between that for the customer?
It's good question. So
Potential rate increase.
Yes, sir. Our objective with the customer communication is just to make it as seamless as possible, specifically with reference to this docket with the merger. And I understand we would use emails, bill inserts, bill messages to make that very clear, referencing number one, that customers' rates will not change as a result of the merger. And also that there's this long-term savings that comes along with that merger. I understand the complexity of communicating both potential rate case outcomes as well as the merger at the same time. And that will be made clear in those bill messages on our website as well. I think as a result of the merger, though, specifically, most customers will not experience any change at all. They may see some different labels on the website, but they can still navigate to the tariffs, the rates that they're on. Some of our tariff sheets may have a different header, but as far as the customer receiving a bill, there will be no bill differences as a result of this merger proceeding. But I understand the complexity around the timing there with the rate cases, and we'll make sure that's clear in the communication.
So you're sharing with me that all Duke customers have computers and have the internet and ability to access this website you're talking about?
No, there will be multiple channels of communication. We usually do that. We'll have email, we'll have bill inserts or bill messages. So those are with the physical mailers. We also update the website so that whatever customer preferred channels, we'll have that information available to all customers.
Okay, so you're talking to someone who barely texts, so just to give you that format. So, and I do everything in writing because I'm from the old school. So what you're saying is you're going to do this blast out on the email to communicate with customers and try to give them the ability to navigate through that website. And then you're going to send it out to the customers about how this business combination is saving them money. And then, oh, by the way, 30 days later or 60 days later, after potential rate case has been processed through this commission and based on its outcome, if there were to be a rate increase, oh, by the way, we're giving you a rate increase. We just saved you all this money, but we're giving you a rate increase. Do you not see where that would be conflicting, at least to me?
I think we'll have to make that message clear between the two. I would say that we've had experience communicating these types of things before, like with securitization for storm, where customers are experiencing savings relative to what we otherwise would have had to charge them for storm recoveries. And we put that in a bill message so the customers can see that physically. This is saving approximately, in a number for customers. So we have experience there. If customers have questions about that, our call center representatives are going to be trained to answer any questions about the merger, particularly if customers call in and say, I'm a DEP customer or a DEC customer, what are the impacts to me? Our folks will be ready and able to handle those questions, even as they pertain to the interaction between rate cases or the merger proceeding.
Well, perhaps they would if they remember Helene, which all of us would have, or winter storm where there is a load shedding event or whatever that comes about. But this is something that's unbeknownst to them that happened 16 years ago. And then to try to communicate those two different messages, if it were potentially to come about, seems to me to be difficult. Now, you've had discussions with your colleagues. Are you down the road on this where you know what you're going to communicate? If potentially this is approved in South Carolina, gets in agreement with what's you're offering here for the business combination. I mean, where are you with this? I mean, we're 6 months out or 8 months, whatever the number is.
Yes, sir. I understand. There's been extensive work already on how customers will see differences on the website, navigating, where they land, and then being able to find the tariffs that they're on or answer questions about programs that are available between the two operating companies. So I can't speak in detail about that, but that work is well underway. And then when you think about bill messages, that's something that we'll be able to put on in an appropriate time frame for January. So I'm not concerned about that timeline.
Okay, very well. Better your job than mine. Ms. Elliott, well, thank you for being here, first of all, and here this morning too, to listen and to tune in. Can you kind of, again, reiterate for me the allocation of monies for wholesale customers, do that, and then the methodology that you used there for wholesale customers, was that ever considered to be done for the North Carolina retail customers? And is that possible?
In terms of the sharing within the jurisdiction,
Correct.
between DEC and DEP? Well, just to give you a little bit more context on
Okay.
the wholesale. So they take rates under a formula rate method, which is different than how we do retail rate making. And so when you think about how formula rates work, what essentially would happen on legal day one, absent the share the benefits plan, there would be this, decrease in, DEP's customers' rates and an increase in DEC's customers' rates. And so the share the benefits framework within the wholesale jurisdiction was designed to mitigate that immediate impact. And from my understanding from reading the FERC order and the testimony is that the way it's going to work is on legal day one, they're going to see the immediate cost reallocation because again, they take service under formula rates. But then there is going to be an adjustment to their monthly bills. And they've worked out this negotiation with the individual wholesale customer. So it's going to be very wholesale individual customer contract driven. And so the DEP customers, our wholesale team has worked with the DEP customers. They've agreed to a certain amount based on their contract for a 5-year period to hold the DEC wholesale customers harmless. And then they've also agreed to share a portion of benefits. So they're essentially agreeing to continue to pay under the current allocation methods to provide this benefit to both the DEC wholesale customers as well as the South Carolina retail jurisdiction. Within the retail jurisdictions, though, and my colleague, Mr. Byrd, can speak more to it, we have the concept of gradualism. So we don't have to have that kind of immediate rate impact that you would see in a formula rate type rate making setting. We have the option, and certainly the commission will have the discretion as to how we move the DEC and the DEP customers within the jurisdiction. So the share the benefits plan is really trying to address a jurisdictional issue because we need to secure the regulatory approvals in all three jurisdictions. But when you think about it from the retail perspective, then the respective commissions within those jurisdictions have the discretion as to how they integrate the DEC and the DEP retail rates. Whereas the formula rate, it happens immediately and you don't have this whole gradualism idea that you have in the retail space.
Is the goal in the three jurisdictional areas that all of them have the same KW cost?
Well, the goal for specifically for the share the benefits plan is to ensure that all three jurisdictions see immediate net benefit from the combination. Because what our cost benefit analysis demonstrated is absent this mitigation plan, South Carolina did not see an immediate impact or immediate benefit from the combination. So the share the benefits framework is designed to ensure that each jurisdiction's customers would see net benefits immediately from this combination. And how we then address that within the jurisdiction on a KWH basis or whatever, that the commission has the discretion. So you can make a different decision as to what happens in the North Carolina retail jurisdiction versus South Carolina. So if we solve the jurisdictional issue, then each individual commission can address what happens within their jurisdiction as far as the integration.
So if I rephrase my question, you could answer, is the goal for DEC and DEP customers to have the same KW cost?
I'll let my colleague jump in.
So when we have a combined business, we will have a single cost of service will come in for one rate case. And right now we have many tariffs across both of the utilities. And so what you would see over time is that we would have one common set of open tariffs and customers on tariffs that we would close to new customers. So over several rate cases or many years, we would see a price convergence there. And ultimately that would be the end goal is to have a single set of available tariffs for the one utility for all retail customers in North Carolina.
Okay. Well, I mean, one company, one goal, just the way I look at it. Ms. Elliott, on page 9, lines 7 through 14 of your direct testimony, again, page 9, lines 7 through 14 on direct testimony, you describe corporate administrative savings that will occur from the combination related to combined regulatory processes, eliminating duplicative riders and rate case filings and proceedings, that there would be a savings there doing one rate case versus two. Is that, I understand what you're saying there correctly?
That's correct.
Okay. And so it's my understanding, and correct me if I'm wrong, the savings are going to come from operational savings. I saw a number of 97% of the savings moving forward with the combination are going to come from that area and only 3% on administrative. What areas does administrative savings, where does that happen? What does that, elaborate on that, what that's going to be?
Well, it really comes down to what you just mentioned earlier, the regulatory efficiencies. So if we can go from filing 2 rate cases before this commission, if we can go to filing, 1 fuel filing, 1 rate case, 1 DSMEE rider filing. So it's really about the reduction in cost associated with the duplicative work we have to do today because they're 2 separate legal entities. So the vast majority of that 3% that's remaining, it's through the regulatory efficiencies that would be gained from combining the 2 utilities.
So what you're telling me is you have 2 staffs of attorneys that deal with one entity and deal with the other to to have two rate cases coming before us, right?
So currently today, right now we have two rate cases pending before this commission, and there are rate case costs that are associated with those individual proceedings. And so what we're saying is there's an opportunity over time from going to those two proceedings down to one to reduce some of those costs.
Okay, so when you say two down to one, I see that the word you use as far as duplicative riders and rate cases and filings and procedures. What about you saying also too that through this combination that there'll be some attrition through retirement, et cetera, that goes on? So you're pretty much going to retain the staff and the people that you have at this time and in the future, and those who move on, retire, whatever reason that they leave the company, you're going to allow that attrition to take place, and that's pretty much what you're going to do as far as duplicated employees, right?
Yeah, so we do expect there may be some headcount reductions, and I think Ms. Bowman spoke to this in her direct testimony that we would handle that through natural attrition.
Okay, all right. Okay. Yeah, either one of you is welcome for this one. Describe how the company will identify and calculate these actual savings to record them in a regulatory liability to ensure these amounts are passed on to the customers.
So we're down to one accounting order in this proceeding, and that is for the cost to achieve. And so we have an internal process that we are using unique accounting codes to capture the costs that are necessary, or the work that's necessary to effectuate the combination. And so should the commission approve the accounting order, we would defer those costs. And again, we're tracking them based on unique accounting codes. And so we would defer those costs, and then we would come back to this commission at some point in the future to request recovery of those costs.
So the unique accounting would track all of that?
Yes.
Okay. All right. This, I guess, would be a tracking question. If you could describe how the company will ensure that all cost savings related to amounts currently included in the base rates will be identified to return these amounts to customers. What measures will the companies have in place to help identify these savings categories and the amounts? I guess that's a unique accounting. For example, any employee reductions not related to natural attrition that may not be currently anticipated, duplicated operational costs identified once the combination is executed that have not been currently identified in the company's testimony, et cetera. So with that, the related amounts, are they going to be currently included in the base rates?
So are you speaking to savings from the corporate savings?
Yes,
Or, okay.
yes.
So we will work internally to, if say, for example, a position is eliminated as a result of the combination. Our current agreement is that we would net those savings against the regulatory asset that we set up for the cost to achieve.
Okay.
So we'll have the cost to achieve, and to the extent we identify savings from potentially headcount reduction that's already reflected in rates, then we would net those savings against the cost. So what you would see in the regulatory asset is the net effect of those two.
Okay. All right. On page 34 of your direct testimony, Ms. Elliott, and I'll get there. I think I'm close. Give me a second with all these books. On page 34 of your direct testimony, you state, for most riders, the companies anticipate seeking commission approval to start to converge the retail riders as early as the first annual rider filings after legal day one. Can you kind of elaborate on that or give us more detail on how that's going to work?
So we are still working through the details as to how exactly that would work. But I'll just use the fuel rider, for example. So if the combination is approved and we move to a single utility, then we will have to converge the fuel riders. And exactly how that will work, we haven't worked all those details out, but it would be, we would start the process in that first fuel rider filing that would happen after legal day one. And we talked about this idea of gradualism from the base rate perspective, but we're also anticipating that it may take multiple rider proceedings to fully merge these kind of legacy DEC and DEP riders. But we are anticipating that we will start that process in those first, and each rider has a different filing date, and we're still working on those details too. And how that convergence happens may look different depending on the rider and what the impacts are. So we'll really just need to look at the individual impact of each of the riders to determine exactly, maybe how long that convergence takes. But we do anticipate that we'll have to start that process in those filings after 27.
Do you feel like the structure's in place to do that? Or
Well, we
not
still
really?
need to work out, again, we don't.
A lot of work.
Yeah, it's a lot of work because we have a lot of riders. And so we are going to have to, we're working through now. I kind of look at this process in phases, like phase one, we're just, seeking the regulatory approvals. Phase two is then we've got to do all the work to be ready to operate as one utility on legal day one. And then phase three is where we now have to start this rate convergence. And so a lot of this is running in parallel, which is why we're not exactly, we don't have everything worked out at this point. But those are things that we are starting to work through now, because as you mentioned earlier, 27 is coming very quickly.
Right. I think this last question I have for both of you perhaps relates to some things you've already discussed, but can you provide more clarity on how rate differences between DEC and DEP customers will be integrated over time? And how do you address future base rates and what will be incorporated in future rider proceedings? In other words, do you know how long the process is going to take? You got 6 months, right? 7 months to get this done?
Well, we've got 7 months to legal day one, but that doesn't, we're not planning to file rider filings on January 1, 2027. So we have a little bit more runway to be prepared to make those rider filings in 27.
Okay. Can you tell me what the rate difference is going to be or anything close to it, Mr. Burke?
Yeah, so I think Witness Elliott was speaking a little bit about the riders in particular. Let me address base rates for a minute and kind of give you a picture of how that's going to work. Again, not going to happen by legal day one. We're going to use a process that we use in every rate case. So in every rate case, we do a cost of service analysis, and then we look at the different rate classes and tariffs, and we evaluate the rate of return for each class, and we compare it to the average rate of return. And so in the rate case, we would push classes from whatever rate of return they are presently towards the average. So that happens every rate case. We're just moving customers towards an average rate of return. We call that a variance reduction process, and every rate case. So in this first rate case following the combination, we would have a single cost of service, and the work preceding the rate case we would think about in the stakeholder process that we've discussed in my testimony. We would think about classes, tariffs to keep open, tariffs to close, but we'd walk into that case with a single cost of service and different customer classes and tariffs with different rates of return, and then an average rate of return. And so we would use that very familiar, very well tried and true variance reduction process to move the tariffs and the rate classes towards that retail average using a process we call gradualism. They're not going to all jump at once, and all customers are not going to jump to a single tariff overnight. It's going to move from whatever tariff they're on using grandfathering, if you will. They stay on that tariff, and they would slowly converge to that average retail rate of return. And then once you get enough convergence, there may be customers on, say, a residential tariff A, and it's closed to new customers, and there's a residential tariff B over here that's open. Once those prices fully converge, we would come back to the commission in a subsequent rate case, maybe a couple of rate cases from now, and say, the prices have converged. We want to fully terminate this rider, or this tariff, sorry, and move customers to the open tariff. That's a process we used for the Nantahala and Duke rate convergence years ago. It works. It took a long time there. And we don't anticipate rushing this. It would be something that the commission would review step by step as we go through case by case. And we propose a little bit of convergence in every case until we get that, achieving the goal that kind of we talked about a minute ago.
Yeah, the other case you're talking about with Nantahala, it's not even remotely close to the size or scope of this at all. We looked at that to try to determine whether we could glean some things that you were using here, and it's just too small. And but I'm glad there's some benefit that's coming out of that.
I understand. I think, you know, the challenge is real and it seems complex. However, I would say that what we accomplished on rate design in the last set of rate cases with modifying TOU periods and hourly pricing rates and all of that net metering was more complex than what I just described to you. And I think that when you look at some of the tariffs, we've got customers on DEC that could move to an open DEP tariff today and save. And then customers that the vice versa is also true from DEP to DEC. So when we think about what tariffs would be open, that process of convergence, when we have that common cost of service, it's going to be not as difficult, not as challenging, I think, as you might initially think.
Okay. And my last question, just for me, the word gradualism, I understand. Maybe I don't understand. It's probably one of the first times I've ever seen in my reading ever it used. It's kind of a neat word like load sharing, and then what load sharing really means, which I can't say anything about. Gradualism, can it go up or down?
Gradualism means I have, and it is going up or down. So when you do an average retail rate of return in a rate case, I have some customer classes that are below average and some that are above average. And what we do is we move them towards the average, but not all the way. So we might move them 25% of the way, which is what we've proposed in the pending rate cases. We move them a portion of the way, that is gradually. And you do that in every case. And over time, you do get that convergence.
Okay, that's all the questions I have. Chair Brawley? No questions. Commissioner McKissick?
I guess I have a couple of questions, and I'll pick up where Commissioner Tucker last left things. In terms of the cost of service study that would need to be conducted, how soon, assuming the reorganization were approved and we have legal day one that it's begun, what window of time do you anticipate it taking to do a thorough cost of service analysis?
Well, today, it takes us several months to do a cost of service study. And so what we will have to embark on after legal day one is doing a combined cost of service study. And we have some experience with that from this proceeding because that's how we estimated the impact of the cost reallocation. We had to take our two separate DEC and DEP cost of service studies and said if we were a combined utility, what would that cost of service study look like? So we anticipate that it's still going to take several months to do. We don't necessarily anticipate that it would take any longer than the separate ones because it's really, the process will look the same. It's just that we're now going to be putting our financial inputs into the cost of service study as a combined utility versus doing a separate cost of service study for DEC and DEC standalone.
And I gather the new entity will be working with the public staff during that process to look at the parameters that are involved.
Correct.
All right. And I'm just curious, I mean, when would you reasonably anticipate at this time that there might be a rate case submitted for a merged entity that might occur as a result
So
of this?
Commissioner, we're always evaluating rate case timing. We have not committed to a specific date at this time. It would obviously be sometime after legal day one, but we haven't committed to a specific date at this time.
Okay, I just didn't know there was some reasonable expectation as to when it might occur, knowing that right now in the current rate cases, you're looking at 2 years?
Yes, that's correct.
Okay. A couple of additional questions. I know in the stipulation that's before us, it doesn't address the $55 million annually that would be contributed by the wholesale customers. Is there a reason why that has been omitted? And how will that be addressed?
So the $55 million contribution is from the wholesale to the South Carolina retail jurisdiction. So what's going to happen if the combination is approved is the wholesale through their, contracts and their invoicing of wholesale customers, they're going to be collecting additional revenue from the wholesale customers. And we have requested approval in South Carolina for a regulatory liability, because the idea is the funds that are collected from the wholesale customers as part of the share the benefits framework would then go into this regulatory liability to then be flowed back to South Carolina retail customers. So that's why it wasn't specifically addressed in this stipulation with the North Carolina public staff and other parties, is because that's a direct contribution from the wholesale jurisdiction specifically to the South Carolina retail jurisdiction.
Got it. That puts it in context. That's helpful. And of course, originally in the application, there was a request for, accounting order that covered 3 categories. And I gather from your testimony today that the only category that would be established is the one dealing with the cost to achieve.
That's correct.
And it's anticipated at some point a rider would be approved in a subsequent rate case to address those costs. Is that right?
So the rider is
Yes.
specific to the share the benefits.
Oh, excuse
contribution.
me. You're correct. Yeah, that's correct.
And then for the cost to achieve, we would come back to this commission in a rate case proceeding and seek recovery of those costs.
Exactly. Okay, very good. And of course, at the end of this 14-year window, where it would be evaluated whether in fact the cost to achieve had been realized, that's when the shareholders of the new entity would theoretically make a contribution if those costs to achieve have not been realized. Is that correct?
So the kind of the guarantee that you're speaking to in the stipulation, so we will have our cost to achieve, and we're estimating it to be, I think, $136 million. And then we have the share the benefits contribution, which is the $25 million for 6 years, which is the $150 million. And so what we're saying is if we get to the end of this 14-year period and the benefits that we've been tracking don't exceed the sum of the cost to achieve and the share the benefits, then that's when the shareholder contribution would kick in.
It's a long time to wait. And then if it were done at that point in time, it'd be looking at whatever that deficit would be between the two. But you're funding it in dollars that are 14 years down the road versus, it's not inflation adjusted or anything like that.
No, we're talking nominal dollars here,
Yeah,
because we're looking at it from a revenue requirement view.
I understand. Commissioner Tucker, I think I've probably covered the lines of inquiry that I had in mind from reading the settlement agreement, or the stipulation, I should say. I think it's pretty straightforward. And I think you've certainly addressed the key things that were in my mind after reading it. Thank you.
Thank you, Commissioner McKissick. Commissioner Vandervaart, questions?
Yeah, I'm going to follow up on some stuff that Commissioner Tucker brought up, specifically the reallocation between the retail customers of DEC and DEP, and I touched on it earlier. And I guess it was curious to me that you all in the settlement withdrew the accounting order. So my first question is presumably you did some kind of analysis that showed something that was significant enough for you to seek the accounting order initially. Is that fair to say? So what did that analysis show? regarding the difference in cost between DEC retail and DEP retail customers?
So our cost reallocation was done at a jurisdictional level. So it wasn't looking at a reallocation between DEC and DEP. It was looking at the reallocation of existing costs between the wholesale South Carolina retail and North Carolina retail jurisdictions. And so the initial accounting order was to defer the impact of that cost reallocation to North Carolina retail until we could reflect that impact in rates. But after further analysis, what we realized is the vast majority of that cost reallocation, specifically for the North Carolina retail jurisdiction, was related to fuel and fuel-related cost. And so we already have a current mechanism within our fuel rider to capture over under recoveries of fuel. And so we don't need an additional regulatory asset for that.
But nevertheless, DEC customers are going to pay more. I know that whether we get into rates or not, I guess I'm trying to figure out whether DEC customers are going to be harmed as a result of this combination. And I was hoping that that accounting order might shed light on that. Are DEC customers going to be harmed?
No, I think what you've heard earlier this morning as well is that our anticipation is that all customers will benefit as a result of the significant savings that the companies see.
Right, but those DEC, yeah, sure, but are those DEC customers going to be made whole? I mean, I know that there's this warm glow feeling about what, 44 million or so. Is that enough to make them whole? I'm talking about specifically DEC retail customers, because I think, don't we have to ensure that all customers are going to benefit?
So a couple things. One, I think there's a significant savings associated with the merger that flows to all customers. So all customers are seeing that benefit. Secondly, in what I was discussing with Commissioner Tucker a minute ago with the convergence, the commission will oversee that process.
Well, I'm trying to understand it right now because the settlement doesn't talk about this harm to DEC if there is one. And I'm concerned to approve this settlement. I was under the impression we're looking for benefits to all customers, nobody getting harmed. And so again, are DEC customers going to be harmed? Are you telling me that the overall benefit will offset the harm that DEC customers will feel?
So there's significant savings with the merger that flows to all customers. And I was describing the kind of convergence between DEC and DEP. That's under the commission's authority with each rate case to review that convergence.
Sure. Yeah.
And you think about what exists presently within DEC and DEP. There is a spread between different classes and within classes, inter and intra-class.
Right, but there's an overall, we can agree that overall DEC retail customers are paying less than DEP retail customers.
I think that has to be looked at specifically within, say, different classes.
Well, I was hoping to see this in the accounting order that you all asked, but then you then asked to withdraw it as part of this. So, and I'll ask the public staff this too. And I guess it just means that I'm not sure I get to see everything. But you're not saying that the overall benefit's going to cover whatever harm DEC customers might endure.
And I guess I don't think about it in terms of harm.
I do.
Because the cost reallocation it's where we're saying today. So the DEC system today is a less expensive system for DEP to serve.
Thank you.
And it's just a function of how the systems have been built out over time. And so when we merge the utilities, we've got to merge the financial inputs associated with those utilities.
I agree. I just want to capture those costs in this settlement so that the net is positive or at least zero.
Well, and the cost reallocation that was in the original accounting order wasn't specific to DEC versus DEP. It was the jurisdictional cost reallocation.
Okay, but now I'm asking you specifically, and you agree with me. I couldn't get Mr. Byrd to agree to me, but that DEC is generally cheaper than DEP.
The system, yes.
Right. And now, I get it. We're going to have to merge to consolidate. some of those DEC people are going to see higher rates. And that's a cost.
Well, and what
I'm just trying to understand whether those costs are being covered by the consolidation. I'm not saying it, I get it, you got to do it. But for us to make sure that this consolidation meets, public, what is it, the public benefit, I interpret that to mean all customers. And I'm not sure I understand that DEC is going to be made, DEC retail customers are going to necessarily be made whole based on the very, very small benefit that is in the settlement right now.
And I think one thing to keep in mind too, Commissioner, is that the DEC system today is less expensive, but that is not indicative of what the DEC system will cost in the future. We have a pretty significant capital expansion plan before us as we continue to meet the load growth on the system, as we continue to protect the reliability of the system. So I
get that.
I wouldn't assume that just because the DEC system is cheaper today, that would always be the case.
I grant you that, but I'm focusing today on the settlement for this consolidation. And so that's happening the here and now. And as they stand, the two customers enjoy different overall rates. One is higher than the other. And I'm not disputing that they need to be brought in alignment. I'm just wondering whether those costs are being accounted for as part of this consolidation. That's where I'm fuzzy. The amount of money that's in the settlement is so small, I can't imagine that's going to cover DEC retail customers. And you've withdrawn, and you say that you never were going to ask for an accounting order for the reallocation between the DEC and the DEP?
We asked for it in our original application.
So you had an analysis for that. Otherwise, you wouldn't have asked for it.
Yes.
And it was significant. Otherwise, you wouldn't have asked for the order to give you a different accounting treatment. So I'm just trying to figure out what was in that analysis, and is this consolidation going to cover that cost?
So what was in that analysis is we took our two separate cost of service studies and we combined them. And what that cost reallocation represented is what happens when you fully integrate DEC and DEP from a jurisdictional standpoint. And so what
Wait a
that
minute, now you're
showed,
talking jurisdictional again. I'm sorry. We were just talking about the analysis you did for North Carolina DEC, DEP.
well, our cost reallocation analysis it was a jurisdictional
Okay,
analysis.
I see. Okay. I'm not very satisfied with that answer, if you can imagine. But that's all I've got. Thank you.
Got one follow-up question from Commissioner McKissick.
Yeah. And I guess this would go to you, Ms. Elliott. On page 26 of your testimony, beginning at line 12, you talk about the three components of the company's request for an accounting order.
Yes.
Number one was the regulatory asset to effectuate the cost reallocation to North Carolina retail. Number two, regulatory asset to defer North Carolina's retail contribution to South Carolina retail pursuant to the share the benefits plan. And number three, a regulatory asset for deferral of the cost to achieve. Now, based upon those three classifications at this point in time, it's been reduced to just one order.
Correct.
And that's the only one moving forward. Is there any additional information you would like to provide us with as relate to the withdrawal of the others?
Other than to say, we didn't withdraw it because the need wasn't there. We withdrew it because we already have an existing deferral that will accommodate that need through the fuel rider. Because that, in North Carolina retail specifically, the vast majority of that cost reallocation is the impact of fuel cost. And so we have an existing mechanism today to handle any over under recovery for fuel. So it's not that the need is not still there. We just realized that we already have an existing mechanism to handle that impact.
And what's articulated in the stipulation is that one of the savings that's anticipated is from fuel.
Correct.
And that's because of the use of the existing facilities as they are used today and what it would be, how those resources would be deployed differently that result in the fuel savings.
Okay, you're probably taking me out of my technical expertise, but it's my understanding that our ability to operate our resources more efficiently is going to generate production cost savings, i.e. including fuel.
Okay, thank you.
Thank you, Commissioner McKissick. I've got one more follow-up question. I know it's kind of out of order the way we do things, but would it be fair to ask either one of you about the 55 million, 25 million and the shareholder shortfall, et cetera? Are y'all both familiar with that and can answer questions about the shareholder participation?
I can certainly try, Commissioner Tucker.
Ms. Elliott, you've done a great job so far. You know, I read that in the settlement, and I haven't seen all of the 36-page settlement because it got here right when we started. I read one that was 18 pages, and I think this was included in that, and I'm doing it from memory, and I cannot find it with all these books up here. What is the shortfall designation that the shareholders are to pay?
So the tracking framework that we have agreed to as part of the stipulation is we will track benefits over this measurement period. And if we get to the end of the measurement period and those benefits that have been tracked, if they do not exceed or cover the cost to achieve and the share the benefits contributions, which is the 25 million for 6 years. So if you take the total of those two, I think it's $286 million. If we get to the end of the measurement period and that $286 million isn't covered, then the shareholders would kick in for the difference.
Okay. All right. On the other side of it, there was language that allowed them to get off the hook, for lack of a better term, a litany of things that could happen that they would not have to participate in covering the shortfall. Is that correct?
So the stipulation does have language in that if there is some unforeseen circumstance that to no fault of the company, the benefits don't materialize, then we would come before this commission for the commission to decide whether or not we've met our burden or if we do need to contribute a shareholder contribution for some unforeseen circumstance. I can't think of what that would be sitting here today, but there is a provision in that stipulation that addresses that.
So is it fair for me to say in my mind that the shareholders are completely off the hook for any shortfall? Because I think Mr. Peeler alluded to the fact that the savings was going to far exceed the amount we're talking about. And then, of course, a catastrophic event, or I couldn't find the language, Ms. Elliott. I'm sure you probably can, but it's not necessary though. But you know, that particular language that's in there, we're talking a 14-year window. They really don't have any skin in the game in this combination merger, do they?
Well, I don't know that I would agree with that, because again, if there was some unforeseen circumstance, we'd have to come back to this commission and the commission would have to decide whether or not they consider it, you know, some unforeseen circumstance that is egregious enough for us to not have that shareholder contribution.
Okay.
So the commission ultimately makes that determination. We can't kind of just arbitrarily do that on our own.
Do you think the shareholders are going to benefit from the savings of this combination?
The savings that we've modeled in the cost benefit analyses that we've put in this proceeding are savings that will go directly to customers. These are not savings that shareholders are going to be sharing in.
Okay. I don't know that you were privy to all the negotiations, and you perhaps were not aware that the Attorney General's office, as I understand it, said that the shareholders should pay for the combination, I guess it'd be cost to achieve 136 million or 143 million. The numbers run together for me. Do you recall, or was that ever Mr. Byrd or Ms. Elliott considered in these negotiations, or are you the wrong people to ask that?
Well, it's the company's position. So we're pursuing this combination for the benefit of customers. And again, the benefits that we've modeled in our cost benefit analysis are benefits that go directly to customers. And so this shouldn't be seen as an earnings driver for the shareholders because again, the benefits are going to flow directly to customers. And so, it's the company's position that we think it's reasonable to ask the customers to pay for the costs to do the work necessary to effectuate the combination in exchange for the long-term benefits that it will provide.
Well, if your ROE is there and the profit, the basis points are there and you make money like you did last year, the shareholders are going to benefit from that in dividends and or price share. I don't see how I don't know why it falls on all the customers versus, no input from the shareholders. I mean, they're obviously going to see some benefit over a 14-year period with more efficiencies, with cost savings, with all those, and your ROE would be better, I expect. So why was that not considered? Or you're just saying this is a customer benefit. We're going to not increase rates based on this business merger at all in the first year, yet we're going to have a rate increase in the first year, potentially. And then the shareholders are held harmless from all of this moving forward for a 14-year period. You can disagree and rebut whatever I've just said. Just dice it up and share it back with me what your thinking is, Ms. Elliott.
Again, I think I'll just go back to what I said, that this is customer driven. And as part of the stipulation, we've agreed to guarantee benefits to the level to cover the cost. And to the extent there is a shortfall, then the shareholders would be responsible for that shortfall.
Okay, just one follow-up. There's no tracking methodology in place, is there?
For what we've agreed to in the stipulation?
Right.
Not currently. We're going to need to work with public staff and others.
Let me follow up with that. I think there's a 60-day window for you to come up with this tracking methodology, and then it's turned over to the commission. I don't want to see it. We'll let you have that over the next 60 days. Thank you, though. You've been point on, and I appreciate that, both of you. Thank you. Senator McKissick's got one more follow-up out of order.
Yeah, simply this, in the tracking mechanism that's going to be established, there are 4 categories. Number 1, reduce reliability purchases. Number 2, reduce operating reserves. Number 3, reduce online contingency reserves. And number 4, fuel savings. But those are the 4 things you're tracking because they're reasonably could be calculated better than other.
That's my understanding.
Now, in the event there's savings realized due to other factors that are other than these 4 things that you're tracking, at the end of that 14-year period, let's say there were a shortfall that occurred, would you then at that point in time, and this is hypothetical, also want to carry in savings that were realized from other opportunities that were realized? Or are you really just looking at these 4 factors?
We are looking at those 4 factors.
Because I don't see a catch-all about anything separate and apart and other than those. So I'm just trying to make sure on the record today, because 14 years from now, I'm not going to be here. But what the intent of the parties were when this stipulation was entered into. That these are the only parameters that are going to be measured to determine whether there's a need for a shareholder contribution at the end of that 14 years.
So there is a provision, it's on page 6, that says the companies and public staff further agree that additional categories or types of measurable benefits may be identified in the future. So I read that to say we're not necessarily limiting ourselves to the 4 categories. If we identify other savings opportunities that we can quantify and include, that would be part of the additional savings captured within the measurement period.
All right, thank you. That provides clarity on that ambiguity or potential ambiguity.
Okay. We're at the point of questions on commissioner questions.
Your Honor, I do have a few questions. If that could be heard.
Any objection that she'd like to be heard?
No objection.
Go ahead, Ms. Grundy.
Thank you so much, Presiding Commissioner Tucker. I wanted to follow up first on a question that you actually asked about the communication about sort of the interplay between the merger and the rate increase. I'm not sure that I had really thought through that until Presiding Commissioner Tucker raised it today. But do you understand that the point that I think he's making is that the concept of the no rate increase on legal day 1 and a rate increase as a result of the multi-year rate plan could be confusing for customers?
Yes, and we'll have to make that clear in our communications. Absolutely.
And so you're committed to trying to work through how those two things are interplaying at the same time so that there isn't confusion for customers.
That's right. And we have a history of doing both, communicating to customers a rate increase from a rate case or a savings from, say, a securitization. And we'll just have to think about those two things happening at once. But yes, we'll work on that customer communication to be clear there.
And then I'm going to ask a series of questions, and I will repeat Commissioner Vandervaart's question every time if the bench so prefers. But it all relates to his essential question of will DEC be harmed as a result of the merger?
You don't have to repeat it every time.
I appreciate that, Your Honor. So I want to make sure that we're all operating off of the same page of understanding. At the time the merger is granted, DEC rates as they currently exist, which is based on a cheaper system, will not change. Is that correct?
That's right.
They will only change as the company comes in front of this commission for a rate increase and asks for an adjustment of rates that is above and beyond the rate increase that is otherwise sought, that is solely related to trying to right-size DEP and DEC rates.
Presiding Commissioner Tucker, I'm going to object to this. Counsel for Walmart is bringing up friendly cross questions, and there's already been a stipulation filed between the companies and Walmart on these issues.
Your Honor, respectfully, this is not cross-exam. These are questions in response to commissioners' questions. And I think that for purposes of the public interest nature of this proceeding, it's important to have a clear record for the commission to consider this important issue. And while I recognize that Walmart is a signatory, we also have an interest in this proceeding that we believe is helpful if the record is clarified for purposes of the bench's consideration of this matter.
I'll allow the question. Go forward.
So let me repeat my question.
Please.
You envision that even after this merger, you will continue to have rate increases that come before this commission where you likely will seek increases to rates that will affect all customers in your service territory. Is that correct?
We anticipate future rate cases, and that's what I was describing, yes.
Okay, and so the only time that a DEC customer is harmed is if their rate increase is above and beyond the rate increase that is otherwise sought, meaning above and beyond in order to right size what DEP customers or legacy DEP customers pay versus DEC.
So I was taking the word harmed in the context of the merger and the significant benefits that come along with that as benefiting all customers. And then there is a convergence process that happens over time within the rate cases.
Correct. And so let me just try to ask the question again. I want you to assume for purposes of my question that the merger is granted.
Okay.
And after the merger is granted, you guys come in for a rate increase. You're going to do the normal thing as you discussed it, right? You're going to have a cost of service study. You're going to look at rates. You're going to allocate those costs to customers in certain rate classes, correct?
That is correct.
Okay. But that is the typical process, and that will exist moving forward whether or not the merger is granted.
That's right. We do it in every case, whether for the two separate companies now, and we would anticipate doing that with the merged utility, yes.
So going forward and focusing solely on what think Commissioner Vandervaart's question was, which was broader than just the stated benefits, but the harm which relates to the differences in the rates between the DEP and the DEC system as they exist today. The only time that harm will be reflected is if you attempt to adjust rates for legacy DEC customers in order to right size the customers to bring them into parity.
I think I was saying that the merger, I'm probably just repeating myself. but
Yeah, and if you're going to point back to your prior answer, let me just stop. I don't want you to refer back to any prior answer. I want to focus specifically on my question now. So if you need me to repeat it, let me do that.
So
I'm simply trying to understand the concept of okay, so let me just take a step back and try again. For current customers that sit here today and live in the DEP and DEC system, they are paying different rates because the DEC system is cheaper than the DEP system. The DEC system is cheaper than the DEC system. And let me try that one again. DEC is cheaper than DEP, correct?
I think witness Elliott said that, yes, there's a cost of service difference between the two. That doesn't mean that there are not differences within each of those utilities where you have rate of return variances that exist now between classes and within classes. So those are all being imported into the process that we talked about. So to make a sort of monolithic statement to say DEC customers are harmed, I believe is, you can't say it like that. So I was describing the process.
Again, I could be done so much quicker. If you
I'm
could just
trying.
hear what so the DEC system right now, we've already established for Ms. Elliott that it is a cheaper system than DEP. So right now, the rates paid by customers are generally cheaper in DEC than DEP. And part of what you guys envision will have to happen over time after the merger is steps will have to be taken to bring legacy DEC and DEP in line. And either of you can answer this question.
That's right.
Okay. But there will be no harm to a DEC legacy customer until this commission issues an order that authorizes a rate increase to DEC customers that is solely as a result of trying to bring DEC and DEP into parity. Is that correct?
That's correct.
Okay. And so I think part of what you were trying to explain earlier is that the commission will have full discretion to determine what the timing of that would look like.
That's right.
So then let's back up. Many of the benefits, as I understand them, of the merger are avoided future costs that the company is going to have to spend on other resources in both systems if the merger is not granted, correct?
Correct. It's, yes, the company will have to spend less because the vast majority of the savings is from the ability to defer or eliminate capital investment.
And are you aware?
Commissioner Tucker, are we still on the questions that Commissioner Vandervaart asked about whether DEC customers will be harmed?
Unfortunately, Your Honor, I would acknowledge that we are. I am just trying to go through this very specific issue of the harm. I didn't think it would take this long, but I am still trying to just clarify the record.
Mr. Ledford does have a point. If you could dovetail your comments to try to get to your answer.
Well, Your Honor, I would certainly appreciate the witness's response to my question instead of re-answering the question from the commissioner before, but my questions really do focus on this teasing out this concept of will DEC customers be harmed as a result of the merger, which is exactly, I wrote it down at the time. That's why I keep asking it, which is exactly what Commissioner Vandervaart asked.
I'll allow this to go on a bit longer.
Okay. Are you aware that there have been resources built already or that have been approved to be built as a result of prior CPIRP proceedings? That there has been some indication that going forward, in the absence of a merger, we would not be able to just choose to site, for example, more solar in DEP's territory. More of it would need to be sited in DEC.
That's my understanding.
Okay, and that would otherwise be more expensive because the DEP land is more suitable for solar.
You're taking me outside of my technical expertise, but that's my understanding.
Understood. And so that's some of the efficiencies, the ability to make optimal siting decisions is one of the benefits that you guys are factoring in down the road that only happens if there's a merger.
That's my read of Witness Nelson's testimony, yes.
Thank you. Those are all my questions.
Okay, thank you. All right.
Commissioner
Right.
Tuck,
Yes, sir.
I do have some questions on commission questions.
Okay, I thought we were going to allow the applicant to answer on commissioner questions, but what's the format here? You allow it, or you'll grant them the time as well?
Commissioner, that is fine. I do have some questions, redirect
I
on
will make
commissioner
sure
questions,
you
but
get to
please,
those.
as long
Yes,
as I get
sir.
an opportunity, that's great.
All right, folks, jump in here. Mr. Ledford, go ahead.
Thank you, Commissioner Tucker. Witness Byrd, Witness Elliott. Commissioner Tucker asked you questions about the wholesale customer sharing between DEC and DEP customers, and in essence, if that sort of contribution could happen at a retail level as well. Do you recall those questions?
Yes.
And your response was that for DEC wholesale customers, the formula rates don't provide protection, and that's why the contribution was necessary from DEP wholesale customers. Is that accurate?
That's my understanding, yes.
And for South Carolina customers, the protection is going to be the share of the benefits plan. Is that accurate?
It will be the share the benefits plan in conjunction with the benefits expected from the combination is what will benefit South Carolina.
But there's no protection for DEC retail North Carolina customers. Is that accurate?
When you say protection from,
There's no share the benefits plan. There's no wholesale contribution.
well, if you look at our 3 cost benefit analysis, it supports that the benefits are pretty significant in North Carolina after you consider the cost reallocation, the share the benefits plan, and the cost to achieve.
But there's no cash transfer.
That's correct.
And to your knowledge, does Walmart have stores in both DEC and DEP service territory?
Yes.
And to your knowledge, does Walmart have stores both in North Carolina and South Carolina?
That's yes.
And a large part of the protection offered to North Carolina retail customers is the cancellation of this 200 megawatt battery. Is that accurate?
That is part of what we've agreed to in the stipulation, yes, in addition to tracking benefits, yes.
And the battery has not yet been approved by the commission in the current CPIRP proceeding. Is that accurate?
That's correct.
All right, thank you. Switching gears to a different question that Commissioner Tucker asked. He asked you questions about converging the retail riders. Is that correct?
Correct.
And the DEC's fuel rider application that was made yesterday, that's going to go into effect in 2027, does that take into account the savings associated with the merger? Excuse me, the combination. Thank you.
I'm not the fuel, I don't handle the fuel rider, so, but it's, I don't know the answer to that.
Thank you. And then Commissioner McKissick asked you a question about when rates will be filed for the first time for a combined utility that would start bringing rates into parity. Do you recall that?
Yes.
And based on the current rate applications, the new the Carolina 1U will need to file a retail rate application for rates to be effective January 1st, 2029. Is that accurate?
If you assume that we continue with the current NYRP cadence.
So there's a chance the companies may not continue with the current MYRP case.
I'm not speaking to what the company will or won't do. What I had said earlier today is we have not made a determination as to the timing of when we would file a future rate case. So I can't sit here and tell you today when we would file another rate case.
And that's based, if it is the next MYRP on January 1, 2029, that's based on a 2-year multi-year rate plan that's currently before the commission,
Yes,
correct?
the current NYRP is a 2-year NYRP.
Okay, thank you. No further questions.
Thank you, Mr. Ledford. Now, sir, you may, after that interlude, you may ask questions on commissioner questions.
Thank you, Commissioner. I appreciate it. So I'm actually going to begin with Ms. Elliott. Ms. Elliott, do you recall some questions from Commissioner Tucker regarding trying to understand a bit more around benefits, if any, to shareholders, and your response being that the benefits of the combination are customer driven?
Correct.
Do you recall that?
Yes.
I wanted to explore that a little bit more. So when we talk about the operational efficiencies resulting from the combination, can you explain to me, how does that work? How does that benefit customers? How does that translate to customers?
So, and I'll kind of go back to witness Peeler's testimony. So, it's my understanding that what this combination will allow us to do is it will allow us to plan our resources more efficiently. It will allow us to operate our resources more efficiently, and it'll allow us to execute on our plan more efficiently, where we'll be able to site and build resources where it's most cost effective. And that will translate into savings for customers.
Thank you. And then when you refer to kind of the financial strength of the utilities and the projected reduction in financing costs ostensibly, how does that flow in to benefit customers?
So if from this combination that there is some financial benefit in terms of the cost of debt or financing costs, that would be reflected in the future rate case filings that we would put before this commission.
Okay. And then when you think about the avoidance of capital investments, generation infrastructure, et cetera, can you explain how that flows to customers?
So, and I will say, you know, the vast majority of the savings is exactly from that category. And so, you know, we have rate cases pending before this commission now, and usually those rate cases are being driven by significant capital investment. And so the combination provides an opportunity for us to lower the overall cost of the system, because we would be able to defer or avoid some of that capital investment. And so that will show up in a rate case from the standpoint of the rates would be lower than they otherwise would be if we did not effectuate the combination, or higher than they otherwise would be. I said that backwards, but absent the combination, the rates would be higher because we would have made more capital investment.
And again, about that flow of benefits to customers versus shareholders, you mentioned corporate administrative savings as one area. Can you explain how that flows to customers as well?
So again, the vast majority of the savings are being driven by the regulatory efficiencies that will be gained from this combination. And typically, when you think about a rate case, for example, we have rate case expenses. And so again, if we're able to reduce our rate cases to go from 2 to 1, then that should lower the rate case expenses associated with the rate case. And that is costs that we typically defer and recover in the rate case. And so we believe over time that those costs that we would present to this commission to be recovered as it relates to a rate case would be lower than they otherwise would be if we did not do the combination.
Thank you, Ms. Elliott. And all of those included, do you identify or can you identify any residual benefits going to shareholders in those description of the categories of benefits?
The 3 categories, I don't see how those benefits translate to benefits to shareholders, no.
And can you then elaborate then? Is that the reason why you believe it's reasonable for customers to pay for the benefits of the combination to achieve them?
Yes, that's exactly why, because these are benefits that are going to accrue directly to customers. But we also have to have costs, we have to incur costs to effectuate the combination. And so we believe it's reasonable to request that the customers pay the cost to achieve the combination in exchange for the long-term benefits that it's going to provide.
Thank you. And I also know Commissioner Tucker referenced the AG's position with regards to the sharing, or that for shareholders to compensate the CTA. Do you recall that?
Yes.
Okay. And I recall from that testimony, he may have commented, AGO witness Burgess may have commented upon his views as to the impact to the company as a result of the combination versus staying separate. Do you recall that? Did you read his testimony?
I did read it, and I do remember one distinct comment about, you know, it would be advantageous to shareholders if we continue to operate the 2 utilities separately, because again, the vast majority of the savings are coming from capital investment. So it's to the shareholders' benefit if we continue to operate the 2 utilities separately and we continue to incur capital investment, you know, higher than we otherwise would be as a single utility.
Just want to make sure I understand. Are you saying that it potentially could be more beneficial to stay separate as opposed to combining?
Correct.
From the shareholder perspective?
Correct.
Okay, thank you. I want to move on to a different topic here a little bit. Mr. Byrd, I recall that, or do you recall Commissioner Tucker asking you questions around the customer communications plan and what that looks like?
Yes.
Okay. Do you agree that's an important component of this process to be able to explain to customers exactly what's going on in the dynamics between both the combination as well as the rate increase if approved?
I do.
Mr. Byrd, do you view that there would be an issue if the commission wanted to have the customer communication plan filed or as part of a compliance exhibit or as part of the order? Do you think that would be something that the company would be willing to do?
I think so.
Okay. Thank you. I also wanted to refer, I know Commissioner Tucker, do you recall, and this is to you, Ms. Elliott, that there is certainly complexity with regards to the work needing to be done to be able to actually effectuate this combination, both now if it's approved and in the future as it's implemented. Do you recall that?
Yes.
And in fact, do you recall, I think Commissioner Tucker's exact words were, there's a lot of work to do, right?
Yes.
Do you agree that there's a lot of work to do?
Absolutely.
And I think you, if I remember correctly, you also articulated that you don't have it all figured out just yet. Am I right?
Yes.
Do we need to have it all figured out right now?
No, I don't think we need to have it all figured out. You know, again, I kind of go back to, I look at this in phases. I consider us to be in the first phase where we're just trying to get approval of the combination. But we do have phase two that's kind of running in parallel with this phase one, where we are starting to do the work necessary so that we will be ready to operate these separate utilities as a single legal entity on legal day one. And then phase three is where we get into, okay, now we're combined. Now we got to start like the rate integration, those types of things. So I don't think we need to have all that figured out today because we're simply asking the commission for approval to combine the two utilities.
Thank you, Ms. Elliott. And Mr. Byrd, do you agree with Ms. Elliott as to whether or not we have to have everything done right now?
I agree with Witness Elliott. I think there's things that we have in front of us now that we're working on and addressing, and I think there's things that will take years to work through, as I've described with some of the rate convergence work. Absolutely.
And if you wouldn't mind, for my benefit, from your perspective, what are those things and why do you not think it's necessary to have it all resolved right now?
Sure. I think what we don't have the benefit of right now is a combined cost of service study in the middle of a rate case where we're working through how to align rates from the various tariffs with the revenue requirements in that proceeding itself. I think we can think about some of the overall principles we might consider in that. And that's what I would want to consider in a stakeholder process before the next rate case. But actually doing the math, you have to have the combined cost of service, review the spread between the rate of returns on those classes, and that actual work has to be done necessarily in the context of a rate case.
And Mr. Byrd, because of that gradualism concept, again, now referring to Commissioner Vandervaart's questions around DEC customer harm, is that the reason why you don't view DEC, do you view DEC customers as actually being harmed as a result of the combination?
I think that was the difficulty I was having with the question is right, because there's a significant amount of benefits associated with the merger. And so I didn't agree that there was harm. I think what we're seeing is a convergence over time to align with a new cost of service that is less than what the independent cost would have been. So that's a benefit to all customers. There is an alignment that happens over time in the rate case. Right.
Thank you. No further questions, Commissioner. Thank you.
Thank you. I believe we'll take a break here for about 10 minutes. If we'll just come back on, we'll start back over at 3:05. 3:05. Thank you. No further questions, please.
It's not that.
At this juncture, are there any motions or any exhibits that need to come before us? I haven't heard them. If there's one, go ahead, sir.
Presiding Commissioner Tucker, Justin Simulowski with the North Carolina Sustainable Energy Association. On February 19th, NCSA moved to have their witness excused from this proceeding. And also on February 19th, the commission granted that motion. But out of abundance of caution, I would like to move the accompanying exhibits to the direct testimony of Justin M.J. Matson. Exhibits DMM1 through DMM10, with DMM3 being marked as confidential into the record.
Okay. Without objection, so ordered. Yes.
Presiding Commissioner Tucker. Peter.
Yes, sir. Mr. Ledford.
I would also move Sigfer Elliott Byrd panel cross exhibits 1 and 2 that were introduced in the previous panel into evidence.
Okay. Without objections, so ordered. Okay.
Commissioner Tucker, I have one as well, or maybe two, but I also.
Wait a minute, let me.
I'm sorry.
No, just, you're used to waiting, so I thought I'd get you to wait.
I'll wait.
Yeah.
I'm patient.
Thank you for being so courteous. Go ahead, sir. Go ahead. Mr.
Thank you,
Hobson, go ahead.
Commissioner. I would also move that Elliott Exhibit 1 and Elliott Supplemental Exhibit 1 be admitted to the record as evidence.
Very well. Okay, without objection, so ordered. Thank you. Anything else?
So Commissioner, I think as of right now, our two witnesses that were just on, Mr. Byrd and Miss Elliott, they will be back on rebuttal, but unless there's any further questions, we will have them.
Well, again, you got them to step down before I could tell them to step down, so that's fine too. All right, call your next witness applicant.
All right, thank you, Commissioner. At this time, the companies would like to call Alan Hutcherson to the stand.
Mr. Hutchins, let me swear you in. If I could, please, sir, put your left hand on the Bible and raise your right hand. Do you solemnly swear the truth? The testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. Yes, sir.
Thank you.
All right, good afternoon, Mr. Hutcherson. Can you please state your name and business address for the record?
Yes, Alan Hutcherson, and I'm at 525 South Church Tryon Street in Charlotte, North Carolina, 28202.
All right, thank you, Mr. Hutcherson. And by whom are you employed and in what capacity?
I'm employed by Duke Energy Business Services, and I'm a principal compliance analyst. Employed by Duke Energy Business Services, and I'm a principal compliance analyst.
All right, thank you. And on August 14th, 2025, did you cause to be pre-filed direct testimony consisting of 7 pages?
Yes.
Do you have any corrections to your pre-filed direct testimony?
No, I do not.
If I ask you the same questions that are set forth in your pre-filed direct testimony today, would your answers be the same?
Yes, they would.
All right, and Mr. Hutcherson, have you prepared a summary of your pre-filed direct testimony that was pre-filed in this docket on February 19th, 2026?
Yes.
Thank you. On January 20th, 2026, did you cause to be pre-filed rebuttal testimony consisting of 11 pages?
Yes.
Do you have any corrections to your pre-filed rebuttal testimony?
No, I do not.
All right, and if I asked you the same questions that are set forth in your pre-filed rebuttal testimony today, would your answers be the same?
Yes, they would.
And have you prepared a summary of your pre-filed rebuttal testimony that was filed in this docket on February 19th, 2026?
Yes.
All right, Mr. Hutcherson, on February 20th, 2026, did you cause to be pre-filed settlement testimony consisting of 4 pages?
Yes.
And do you have any corrections to your pre-filed settlement testimony?
No.
All right, and if I asked you the same questions that are set forth in your pre-filed settlement testimony today, would your answers be the same?
Yes, they would.
Have you prepared a summary of your pre-filed settlement testimony that was pre-filed in this docket today, February 25th?
Yes.
All right, Commissioner Tucker, at this time, the companies would ask that Mr. Hutcherson's pre-filed direct, rebuttal, and settlement testimony be entered into the record as if given orally from the stand.
Without objection, so ordered.
Thank you. One more motion, Commissioner Tucker. At this time, I would also ask that the summaries of Mr. Hutcherson's direct rebuttal and settlement be entered into the record as if given orally from the stand.
Okay, without objection, so ordered.
Thank you. Commissioner Tucker, Mr. Hutcherson is available for cross-examination and questions from the commission.
Okay. All right, for cross, we have Siegfer, Mr. Ledford.
Thank you, Commissioner Tucker. Mr. Hutchison, my name is Peter Ledford. I represent the Carolina Industrial Group for Fair Utility Rates. I have some questions that are going to focus on your rebuttal testimony.
Sure.
You may recall that Siegfer's witnesses made a few recommendations regarding the regulatory conditions and code of conduct, and some of those recommendations dealt with the privacy of customer information. And on page 4 of your rebuttal testimony, lines 1 to 2, you testify that Siegfer's proposed revisions would drive customer confusion and dissatisfaction, not consumer protection. Is that accurate?
Let me check. So that's page 4?
Page 4, lines 1 to 2.
Lines 1 through 2. Okay.
And then flipping ahead to page 8.
Yes.
On lines 17 to 19, you summarize the recommendations made by Siegfer's witnesses. Is that correct?
Yes.
And this recommendation deals with customers being notified when customer information is inappropriately disclosed, correct?
Correct.
And on the next page, page 9, you shared the definition of customer information.
I do, lines 4 through 11.
And that includes things like electricity consumption, load profile, credit history, correct?
Correct.
And, you know, electricity consumption, load profile, credit history, billing history, that could all be confidential business information, correct?
It could be.
And so flipping forward one page, you say on page 10, starting on line 14, that the vast majority of these disclosures, while reportable to the commission today, do not create financial risk of harm to the customer. Is that accurate?
That is correct.
Would it create a risk of financial harm if Duke inadvertently shared Nucor's load profile and electricity consumption with Charlotte Pipe?
Well, I'm not sure I could answer that, but I can answer that the risk of financial harm and identity theft is driven by our data privacy laws. Our customer notice provisions are hinged on data privacy law, and we have policies and procedures around customer notice that's hinged on data privacy law.
So to be clear, you don't think Nucor would want to know if their information had been inadvertently disclosed?
Well, to be clear, I can't speak for Nucor. I can speak to our processes and how they align to data privacy law.
But it is your testimony, is it not, that not disclosing this does not create financial harm?
Right, does not create financial harm as defined by data privacy laws.
What about as defined by your testimony?
As defined, my testimony and references to financial harm are hinging back on our processes and procedures, which align to data privacy law.
So would it create a risk of financial harm if Duke inadvertently shared Target's credit history with Walmart?
Once again, I can't speak for Target or Walmart, but I can speak to our processes, and I'm sounding like a broken record here, but it can speak to our processes which are aligning to data privacy law. And let me add that the code of conduct and regulatory conditions have never covered customer notice. And in our proposals, we're not representing that they do. I just wanted to highlight that.
But customers pay attention to what's filed with the commission, correct?
I would hope so.
So a filing with the commission that there was an inadvertent disclosure is a form of notice.
Could be, yes.
And it's a form of notice that y'all are proposing to discontinue if it affects 9 or fewer customers.
If 9 or fewer, correct.
But it could cause serious financial harm to a business if that information was inadvertently disclosed.
I can't speak to a business and represent their financial harm.
But for the sake of argument, it could create, and they would want to know if that had happened.
No, I can't speak to that. I can only align to our processes and procedures, which have been vetted over the years and vetted against well-crafted data privacy laws.
So it's your position and the company's position that this is an appropriate time to loosen privacy restrictions instead of strengthening them, correct?
Oh, no, not at all. We're not loosening anything. The customer notices that we've done in the past, once again, were not driven by the code of conduct. They're driven by privacy laws, which haven't changed. So we're not loosening anything there.
We're not talking about customer notices, though. We're talking about notice to the commission.
Notices to the commissions would be reduced, yes, in the proposal.
And so that's loosening customer privacy.
Well, we still protect customer privacy. Our code of conduct still has provisions to protect customer information. And yes, our revisions would likely result in fewer notices to the commission. And I'll add that the commission's authority is never going to be in question in this case.
So the companies and the public staff stipulated on this issue, correct?
Yes, that's my understanding.
And it's possible that residential ratepayers and large customers may view this issue differently. Is that accurate?
It could be, yes.
So, for example, it may not matter to me if my neighbor learns about my home's load profile, correct?
Correct.
But it could present a sharing of confidential business information if a large business's competitor learns about that information, correct?
That could be.
All right. Switching gears, SIGFR also made recommendations related to the code of conduct related to reliability. Are you familiar with that?
Reliability.
Reliability.
Yeah, but is that in my testimony?
It is.
Okay.
You state in your direct testimony, specifically page 3, that you are sponsoring Exhibit E to the company's application, which is the red line that you initially proposed at the regulatory.
Oh, yes.
Yes.
The original Exhibit E, yes.
Yes. And are you aware that SIGFR witness Mueller made a recommendation regarding section 11.3 of the regulatory conditions?
No.
Okay. Have you reviewed the testimony of SIGFR witnesses?
Yes.
Have you reviewed the rebuttal testimony of Duke witness Bowman?
No, I have not.
Okay. But it is your recommendation not to adopt the the red lines to the regulatory conditions and code of conduct proposed by SIGFR.
Correct.
So even though, well, you have read witness Mueller's testimony. So he recommends that the commission adopt regulatory conditions section 11.3 as it exists currently. This has been renumbered as 10.3 because of some of the other changes, which deals with reporting reliability metrics to the Utilities Commission. Is that accurate?
I'd have to look at that to see.
Okay. If you would like to look, it's on application Exhibit E,
Okay.
which is on page 42 of 70 as
Okay.
attached to the application.
I have that here.
Exhibit E.
Excuse me, it's on page 41, not 42. And it
Okay.
starts with quarterly reliability reports.
Okay.
And you see that DEC and currently DEP are required to provide quarterly reliability reports to the public staff regarding System Average Interruption Duration Index, SAIDI, and System Average Interruption Frequency Index, SAFE.
I see that right here, yes.
Do you have any familiarity with SAIDI and SAFE?
No, I do not.
All right, but you addressed the recommendation regarding that in your rebuttal testimony, correct?
Point me to that wording again, just so I can make sure I can see it.
Page 4 of your rebuttal testimony, lines 1 to 2, SIGFR's proposed revisions would drive customer confusion and dissatisfaction, not customer protection.
Okay.
So you're not a fan of SIGFR's recommendations?
Well, I would say I would not agree with Sigmer's recommendation related to customer notice. Correct.
Okay, but you take no issue with their with their proposal related to reliability?
Yep. I can't speak to reliability. That's outside my wheelhouse.
Okay, what witness can?
I do not know.
Okay, no further questions.
Okay. All right, Siegfried is the only one listed on here. You concluded completely, Mr. Ledford?
Yes, sir.
Okay. I guess we're, Mr. Hutcherson, we're at, commissioner questions now. Duke might want to do that. Okay.
Presiding Commissioner, I do have a few redirect
Okay.
questions.
Excuse me, go ahead.
Thank you. Mr. Hutcherson, would you agree that the questions and the recommendations made by Sigfrid's witnesses regarding the Sadie and Safety recommendations would be best addressed by witness Peeler?
I would agree.
Thank you. Would you also agree that in the rare occasion there is an inadvertent disclosure of customer personal information, the companies would provide notice to customers of such disclosure in accordance with the North Carolina data privacy laws?
And I would agree. And I'll add that the changes we're proposing and the public staff agreed is we're delineating between customer information and customer personal information.
Thank you, Mr. Hutcherson. Would you also agree the companies have a long-standing customer notification procedure that are aligned and in accordance with the North Carolina data privacy laws?
Absolutely, I agree.
All right, last question. Do you agree the companies do not need to address customer notifications and the regulatory conditions and code of conduct?
I agree.
No further questions.
Okay, thank you. I guess we're here at commissioner questions now. Chair Brawley? Commissioner McKissick? No questions? Mr. Hutchison, I just got a couple for you.
Yes.
First of all, did you stay up at night and make all the blue lines in the rules of code of conduct?
It was a process, let's say that.
Wow, what a process.
Yeah,
I looked through this and
yes.
it's dizzying what has changed. But you kind of alluded to this earlier. Was there a specific reason that Duke differentiated between the customer information and the customer personal information? Can you kind of elaborate on that, why there was?
Oh, absolutely. So that's a common question we get is of individuals or whoever often conflate customer information with PI data as personally identifiable information. And we're aligning customer personal information with PI data. So we're drawing a clear distinction. And PI data or customer personal information is things like social security number and that kind of thing.
Okay. Was there reasoning behind the 10 customer threshold?
That's
What was that?
That was a best guess. And the reasoning is if it's 10 or more, it could be a systematic issue, and systematic issues, those are what keep me up at night. If there's a system issue that causes a mass issue, if you will.
Okay.
So 10 or more, that's something that's more alarming than one bill shared with another customer.
Okay. I really don't have any further questions other than the fact that you, when you had 10 or more, you obviously stayed up at night to blue line all these rules of conduct, right?
It's a fun process.
My word, sir. My hat's off to you. That's all I can say.
Thank you, sir.
Thank you. I don't have any further questions. Anything else here for them? No redirects. Everything's good. All right. Questions on commissioner questions? No questions? Mr. Hutchinson, you're excused, sir.
Thank you.
Council, any motions need to be made?
None from the companies.
Okay, thank you. All right. Next up is public staff.
Presiding Commissioner Tucker, I'd like to call the public staff's panel and help get them organized, if I may.
Very well, sir. Yeah. What comes next? So I asked. So I'm asked for process. Do we have more than one Bible?
Yes.
5 Bibles. That's amazing. 2 years we were here and only had 1 Bible. Let's face doing that. Thank you, Chair Brawley, for getting that done. Okay, let me swear you folks in. If you'll put your left hand on the Bible and raise your right hand. Do you solemnly swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth? So help you God?
I do.
Thank you. All right.
Right. Commissioners, we have a panel, so this might just take up.
Very well,
a moment
Mr.
if we
Creech.
can,
Go
please.
ahead.
I'll start with Ms. Boswell. Would you please state your name, business address, and current position for the record?
My name is Michelle Boswell. My business address is 430 North Salisbury Street, Raleigh, North Carolina. I'm the Director of Accounting for the Public Staff.
And Mr. Metz?
My name is Dustin Metz. My business address is 430 North Salisbury Street, Raleigh, North Carolina. I'm the Director of the Public Staff's Energy Division.
Mr. Thomas?
My name is Jeff Thomas. My business address is 430 North Salisbury. And I'm the engineering operations manager of the operations section of the energy division.
Mr. Mitchell?
My name is Blaze Mitchna. My business address is 430 North Salisbury Street, Raleigh, North Carolina, and I'm the engineering manager of research, economics, and modeling.
Mr. Lucas?
I'm Jay Lucas. My address is 430 North Salisbury Street. I'm the manager of rates and energy services in the Public Staff's Energy Division.
And Mr. Williamson?
My name is David Williamson. My business address is 430 North Salisbury Street, and I'm an engineer within the Public Staff's Energy Division within the Rates and Energy Services section.
All right, we'll start with Ms. Boswell. She's filed 3 pieces of testimony here. Most recently, on February 24th, 2026, did you prepare and cause to be pre-filed joint settlement testimony in these dockets consisting of 4 pages?
I did.
And before that, on February 20th, 2026, did you prepare and cause to be pre-filed in these dockets settlement testimony consisting of 5 pages in support of the regulatory conditions and code of conduct settlement?
I did.
And on December 19th, 2025, did you prepare and cause to be pre-filed direct testimony in these dockets consisting of 13 pages, 1 appendix, and 2 exhibits?
I did.
And do you have any corrections to your pre-filed testimony?
I do not.
If you were asked the same questions today, would your answers be the same?
They would.
And lastly, did you prepare and cause to be pre-filed 2 summaries of your testimony? First on February 24th, 2026, and then before that on February 20th, 2026 in the sub-A dockets of these proceedings?
I did.
Okay, let's go to Mr. Metz if we can. Mr. Metz, most recently on February 24th, 2026, did you prepare and cause to be pre-filed joint settlement testimony with Ms. Boswell in these dockets consisting of 4 pages?
I did.
And earlier on December 19th, 2025, did you prepare and cause to be pre-filed direct testimony in these dockets consisting of 13 pages, 1 appendix, and 1 exhibit?
I did.
Do you have any corrections to your pre-filed testimony?
I do not.
If you were asked the same questions today, would your answers be the same?
Yes.
And lastly, did you prepare and cause to be pre-filed 2 summaries of your testimony, first on February 24th, 2026 for your settlement testimony, and then earlier on February 20th, 2026 for your direct testimony in the sub-A dockets of this proceeding?
I did.
Thank you. Now we'll go to Mr. Mitchna and Mr. Thomas, if you can. On December 19th, 2025, did you prepare and cause to be pre-filed joint direct testimony in these dockets consisting of 31 pages, 2 appendices, and 1 exhibit?
Yes.
Yes.
Do you have any corrections to your direct testimony, Mr. Mitchna?
I do not.
Mr. Thomas?
I do not.
If you were asked the same questions today, would your answers be the same, Mr. Mitchna?
Yes.
Mr. Thomas?
Yes.
And lastly, did you prepare and cause to be pre-filed a summary of your testimony on February 20th, 2026 in the sub-A dockets of this proceeding of Mr. Mishna?
Yes.
Mr. Thomas?
Yes.
Thank you. Now, Mr. Lucas and Mr. Williamson, on December 19th, 2025, did you prepare and cause to be pre-filed joint direct testimony in these dockets consisting of 18 pages, 2 appendices, and 1 exhibit?
Yes.
Okay. And do you have any corrections to your direct testimony, Mr. Lucas?
No.
Mr. Williams?
No.
If you were asked the same questions today, would your answers be the same, Mr. Lucas?
Yes.
Mr. Williams?
Yes.
And lastly, did you prepare and cause to be pre-filed a summary of your testimony on February 20th, 2026 in the sub-A dockets of this proceeding, Mr. Lucas?
Yes.
Mr. Williams?
Yes.
Okay. Presiding Commissioner and Commissioners, this panel is available for cross-examination and commission questions.
Okay, very well, sir. We'll call on Sigfer now.
Thank you, Presiding Commissioner Tucker. Good afternoon, lady and gentlemen. I've got a couple of questions for you all. Please feel free to answer whomever is most appropriate or more than one of you as you see fit. The public staff is charged with representing the interests of North Carolina ratepayers only. Is that correct?
Yes.
And the stipulation that the public staff entered into with Duke Energy yesterday effectively holds North Carolina retail customers harmless. Is that a fair characterization?
Part of a review of the overall case and our stipulation is that we believe this was in the interest of North Carolina retail customers.
So is the answer to my question yes or no?
Well, I think your question had a potential qualifier on there, and that's why I made a distinction with my answer.
Do you agree that the stipulation attempts to hold North Carolina retail ratepayers harmless?
Could you point to me in the stipulation where it's saying harmless? That's the distinction that I'm trying to understand what you mean by harmless and harm or harmless, and it can have very many interpretations.
Why don't you tell me what you think the stipulation does and does not do in terms of impacts to North Carolina retail ratepayers?
So give me a second, just trying to process that, trying to summarize a multi-page item there. One second. If you go over to the joint settlement testimony of Boswell and Metz, we briefly describe the overall stipulation, and we identify the benefits of the stipulation for ratepayers.
Is it your position that North Carolina retail ratepayers will be better off, worse off, or the same under the terms of this stipulation?
We believe the overall stipulation implemented ratepayer protections, and the overall merger is in the benefit of North Carolina customers. Ms. Boswell?
I agree.
But there's still a risk of harm to North Carolina retail ratepayers. Isn't that right?
Can you define what you mean by harm?
Just answer the question that you were asked, if you could. And if you need to qualify it, that's up to you. But there is still a risk of harm to North Carolina retail ratepayers, correct?
I can't answer the question as I don't know what you mean by harm in this very open and over generic question.
Isn't it fair to say that the stipulation as written does not guarantee that North Carolina ratepayers will be better off post-merger than they were without the merger?
I disagree with that one. Again, if we go back to our overall testimony and overall conclusions of the merger, that we found this was the interest for North Carolina retail. The overall settlement, again, give and take between the parties, identified key aspects that we believe were reasonable for ratepayer protections.
In the event of a shortfall between the anticipated benefits to ratepayers and the costs, is there a possibility that Duke's shareholders will not have to pay the difference?
That is correct. That is the possibility, but it would have to be extenuating circumstances. And then one reason that is in the stipulation that they would have to come before this commission and demonstrate or prove, and then ultimately make that request before this commission.
And would it be fair to say that there are any number of things that could qualify as an extenuating circumstance, including but not limited to a hurricane?
That is true, but under a non-merged utility, those same extenuating circumstances could also occur.
Are you aware of ORS's testimony filed in South Carolina?
I'm generally cognizant.
Have you read through the testimony filed by ORS in South Carolina in the parallel proceeding?
I have read through it. I believe it was 5 or 6 witnesses. I can't recall the exact number, with dozens upon dozens of pages, and I cannot recite each piece of the testimony, but I did read over it.
Okay, at this time, Presiding Commissioner Tucker, I would like to request that SIGFR potential cross exhibit number 15 be marked as SIGFR public staff cross exhibit number 1. Thank you. And gentlemen and Ms. Boswell, if you could please turn to page 13 of witness lawyer's testimony.
On page 13 of 19.
That's correct. And can you confirm that lines 3 through 9 read as follows? To mitigate the system cost reallocation impact to South Carolina retail customers, the companies proposed to contribute $25 million from the North Carolina retail jurisdiction annually for 6 years and $55 million annually from the wholesale jurisdictions for a period of 5 years to South Carolina retail customers. According to the companies, the proposed plan is a reasonable way to share the benefits among the jurisdictions such that each jurisdiction receives sufficient projected benefits to justify approval of the combination for its respective customer base. Is that correct?
Yes, that is Mr. Lawyer's testimony.
And is it also Mr. Lawyer's testimony in the very next question, which reads, is the company's proposed share the benefits plan sufficient to mitigate the harm to South Carolina retail customers? The first sentence of witness lawyer's response reads, no. While the company's proposed share the benefit plan attempts to mitigate the harm done to South Carolina retail customers as a result of the proposed combination, it does not hold South Carolina retail customers harmless in and of itself. Is that correct?
That's what Mr. Lawyer's testimony states.
And Mr. Metz, as we sit here today, there has not been a stipulation filed between the companies and ORS in the parallel merger proceeding in South Carolina, correct?
That is my understanding, correct.
Doesn't the public staff worry about what the terms of that stipulation might look like? Or alternatively, if there is no stipulation, what the Public Service Commission of South Carolina might decide and how that might impact North Carolina retail customers?
So there's at least 2 parts of the question. I'll try to answer the first one, but please ask me the second part of the question after I answer the first one. Is to the extent what the South Carolina ORS enters into, I don't have any control over that. The public staff entered into a settlement agreement with Duke Energy and as well as other interveners who have signed on to it. The items that we identified in the settlement agreement that we believe are reasonable ratepayer protections, and we ultimately support. And there was a second part of that question.
Yes. Isn't it fair to say that potentially the stipulation in South Carolina, to the extent one is filed, or the Public Service Commission of South Carolina's decision in the parallel merger proceeding pending in that state could have impacts to North Carolina retail ratepayers?
I mean, any decision ultimately would, but to the extent that, again, requiring a degree of speculation, which I'm pausing to do so, but if the South Carolina said that we require $35 million from North Carolina, it doesn't mean that North Carolina is going to pay $35 million. That decision would have to come back before this commission. Now,
On request of Duke.
and upon request of Duke, thank you. I mean, another challenging aspect of this is we're looking at the overall merger saying, who needs to go first? If we wait until South Carolina is completed and then comes back to the decision here, does it get into a kind of how I look at it, is it a chicken or the egg? Again, I don't want to speak for South Carolina. I'm not speaking for South Carolina, but if I was a consumer advocate, I'd be saying, what guarantees can you make for me today? And what other items are tangential or contingent? So Duke filed their case with FERC. FERC made their recommendation. Duke has filed their case with North Carolina Retail. That's what we're here today about. And through the overall process and the timing, and depending on the commission's decision, will help inform, presumably, the South Carolina Commission on the surety that they have of the overall contribution to what they have identified as harm to their ratepayers.
So if the Public Service Commission of South Carolina conditions regulatory approval of the merger on additional share the benefits contributions above and beyond that which the public staff has agreed to with Duke, will the public staff oppose North Carolina retail ratepayers having to bear the burden of those incremental benefits?
I can't answer that question this time. It would have to be looked at the facts and circumstances surrounding the overall request, which I believe Duke Energy would have to make. Ms. Boswell.
That is accurate.
Who from the public staff can answer that question?
I believe we just did answer that question, that it would have to be taken in the confines of the request if Duke made the request to come back to North Carolina and seek that, and then we would look at the request in its entirety at that time.
So is it possible that the public staff could support a future request to have North Carolina retail ratepayers contribute more than the $25 million annual contribution to South Carolina?
It's uncertain at this time. We would have to, again, as we stated for the third time, that we would have to look at the facts and circumstances that are presented to the extent that Duke Energy would make that request before this commission.
So you can see, do you not, that there's a substantial degree of risk and uncertainty that would remain for North Carolina retail ratepayers?
I don't understand where you're making that connection, that if we have the settlement that's here before us today, or the merger that here's before us today, public staff completed its analysis, made its recommendations and findings, presented the results to the commission. We also have the stipulation. We presented our case ultimately to the commission.
But you're also testifying that it's not necessarily final, because Duke may, depending on what South Carolina does, may come back and make a future request for additional share the benefits contributions from North Carolina to South Carolina, correct?
Under your hypothetical, again, it was going down your hypothetical, what if? I mean, we can go after degree after what if. It was saying under this hypothetical, if this was to take effect, not knowing of how the actual ruling was or the language was, that is a possible avenue that may take course. Ms. Boswell.
I would further state that anything that may theoretically or hypothetically happen would still have to come before this commission, and this commission would ultimately get the final decision on what, if anything, it approved beyond what it is ordering within the confines of the case before them today.
Are you aware of settlement discussions happening between the companies and ORS?
Duke would be the best person to answer that overall question on what conversations they're having with the ORS.
But as you sit here today, do you have any knowledge of these discussions?
Our focus has been on the settlement before us today and dealing with the North Carolina ratepayers.
What happens if Duke subsequently enters into a stipulation with ORS in which ORS and Duke agree to a specific jurisdictional cost allocation methodology that differs from the one currently being used in North Carolina and approved by the North Carolina Utilities Commission?
Objection. Presiding Commissioner Tucker, we've gone down the road of speculation here and understandably so, but I think we are reaching the limit here. A lot of speculation here. The witnesses are attempting to answer the questions, but they do not have a crystal ball.
Respectfully, Presiding Commissioner Tucker, this is a very material data point that is currently missing from this record. And we are not able to fully litigate this proceeding. And it's frankly a due process issue. The fact that we don't have this information as we sit here today and are still being asked to cross-examine witnesses when we don't know how this major issue that is germane to everything we're talking about here today is going to be resolved.
Presiding Commissioner Tucker, I'll just add that there is but one part, well, the main party here in South Carolina is Duke. And the Sigfors had the opportunity to cross the Duke witnesses. They'll have the opportunity to do that again. Our folks have gone to the limit, or going to the limit of their speculation, and there's only so much crystal ball that they have. They've testified, well.
Very well. Sustained.
Mr. Metz, do you agree that it may be appropriate to come back in before this commission and answer additional questions once a stipulation, if any, is filed in South Carolina?
It would be based upon the request of Duke. There's so many tangential items that are tied into that. I'm struggling I'm trying to answer your questions, but I'm struggling because there's so many layers of what does it look like? What is it? What's the amount? What changed? What didn't change? What stipulation did Duke enter into? I'd have to see the facts and circumstances that are filed and consult with my team and do our due diligence before I can reach that conclusion.
If indeed anything is actually filed by Duke.
And all of those questions that you just raised, Mr. Metz, would be fair to answer during a reconvened hearing once a stipulation, if any, is filed in South Carolina. Is that fair?
I'd say it's heavily dependent to what we laid out here is based upon the analysis and numbers that we have, the jurisdictional allocation factors. Again, to the extent that Duke, again, going on speculation here and going a little bit further than I'm comfortable with, is that if Duke agrees to something with South Carolina, it doesn't mean that this commission is necessarily bound to follow those items. That we're here and we'll await the commission's conclusion on this case and what their recommendations are.
Presiding Commissioner Tucker, at this time, SIGFR would request that potential cross redirect exhibit number 16 be marked for identification as SIGFR Public Staff Cross Exhibit number 2.
Objection.
It should be in the same binder in front of you. And if you could turn with me to page 5.
Page 5, Exhibit 16.
Page 5, Exhibit 16, that's correct. Is it correct that one of this witnesses, witness Sandinato for ORS, testifies in lines 3 through 6 on page 5 that one of ORS's recommendations in the parallel proceeding in South Carolina is that DEC and PEC would file decrement riders within 30 days of the close of the merger to pass through to their respective customers A, their allocable share of the $650 million in system fuel and fuel-related cost savings, and B, the capacity cost allocated to the interim wholesale sales.
That is what his testimony states, and that's based upon their analysis, not mine.
And their statutes.
And their overall statutes. Thank you, Ms. Boswell.
Thank you. No further questions.
That concludes the question from Seeker. Mr. Burns, do you want to be heard?
I just want to let you know that I had reserved time for this panel, but I will waive that at this time, reserving the right to question on commissioners' questions if any come up.
Okay, so ordered. SACE is next one up.
Yes, Commissioner, and SACE et al. Wave Cross, also reserving the right to ask questions on questions.
Okay. And then, of course, last but not least, Walmart. Okay, thank you. All right. Is there any redirect by public staff?
I'd like to, if I may, Mr. Metz and Ms. Boswell, you got a number of questions about the possibility of settlements elsewhere, but with respect to this settlement, you continue to stand by this. Is that correct?
The public staff fully supports the settlement for which it is entered into in this case.
Correct. And it's not contingent upon what happens in some other jurisdiction and or yesterday, tomorrow, et cetera. This is your analysis as of today. Is that correct?
That is correct.
That is correct.
Thank you.
Okay, thank you. Well, I guess we're at commissioner questions. Okay, I've got a few here for you. Thank you all for being here. What a large panel. A lot of brains there. I don't know, between the six of you, we can determine, I guess, who can best answer this question. And these are all questions from North Carolina. Of the three CBAs presented during the proceeding, the public staff appears to see that the third CBA as the most reasonable projection of the future possibilities. Is this still the case? And please provide any additional context that you see necessary.
Mr. Thomas would be best to answer that.
Okay.
Sure, and Mr. Mishna may have more detail to add, but generally we looked at the first two filed with the initial testimony as they largely were based on the 2023 approved carbon plan. And as you know, that interim target was a big factor in the capacity expansion build out between the two BAs, between the two plans there. With the removal of that target, and the updated analysis that was filed in the supplemental, even though those precise inputs have not yet been adjudicated, it's an ongoing proceeding. We felt that the removal of that interim target and the general updating of assumptions provided us a clearer picture. So certainly we looked at the first two as indicative and still showing that benefit of, a lower required total megawatts of reserve margin because you're now planning towards a coincident peak of both utilities and you can share those capacity reserves. So it's helpful in that way, but the third CBA really did provide us with a little bit of a clear picture based on these recent inputs. So
okay, thank you for that.
I would also add that the 2023 CPIRP order stated that the P3 fall-based scenario should be used up until a updated IRP is filed. And I believe it followed that procedure where the 2025 CPIRP was filed and then the supplemental update was reflected to this docket as well.
Very well, sir. Are there any other concerns of the public staff that you may or may not like to flag for the commission with the Duke analysis that hadn't been discussed so far? Is there anything?
Mr. Thomas, at a high level?
At a high level, I think we tried to address our main concerns in our testimony. I can't think right now of anything in particular that we did not testify to originally that we'd want to bring up now. And I think we stand by the settlement and believe it puts North Carolina retail customers in a good position.
So you feel like all the loose ends are tied up as best you can at this juncture?
Yes, I mean, there's still a lot to decide, and the merger, whether approved in all three jurisdictions or not, will obviously have ripple effects in the ongoing carbon plan, several CPCN proceedings that are ongoing. So lots of loose ends on that front, but as far as this testimony and our stipulation, we stand by it.
So if I may, Commissioner Tucker,
yes, sir.
Kind of add in different context. And Mr. Lucas, Mr. Williamson, maybe to jump in here is, Mr. Thomas is correct. We agree with our analysis. We stressed it to the bounds that we believe are reasonable. We presented our conclusions. I want to maybe shift a little bit to the bill impact analysis. And I think this ties into the other questions that were asked from other panels. I just want to go back a little bit in time and orientation of say like, well, how we got here and then looking at the DEC versus DEP impacts. And I think this benign issue is a factor that is missing from the analysis, but it's not intentional. It's just, again, a history of how we got here. So when the utilities ultimately merged, and again, this is my understanding, Mr. McLaughlin was the prior director and had multiple conversations with him, is that the JD was implemented, and that was to have the fuel savings associated with it. It just made sense. Two utilities, non-firm energy, let's dispatch our system more economically, and Duke has testified to the savings that they have demonstrated to this commission. And every year that we've had a fuel filing, the JDA has been a component of that fuel filing. And for the most part, the public staff hasn't challenged the results of the overall JDA. And I say with the most part, there was one annual fuel filing where Duke found a mathematical error, but that was corrected. Again, just putting caveats and context. Over time, as we advanced, is that worked awesome for a system that was already built. We weren't really building new assets, generally speaking, from 2012 to 2020, 2022. So around the time that we started looking at the first carbon plan and we started seeing load pickup and retirement assets, it became more to the forefront of new, larger generation was being built. Prior RFPs identified the need for a building, but those elements were largely being deferred because load wasn't manifesting itself. And so that we identified to the commission is how we're looking at the integrated resource planning from a total system lease cost. We started seeing inequities between DEC and DEP. We identified it in the 2022 CPRP, subject to check, that we identified the power flows that were increasing from Duke Energy Progress to Duke Energy Carolinas. And I believe that it was kind of like a curve. It started out around 3 to 5%, and it plateaued about 15%, again, subject to check, then tapered back down. But that number in his testimony for this commission was the total energy. 15% of DEP's total energy was being transferred over to Duke Energy Carolinas. But through the JDA, Duke Energy Carolinas does not pay for fixed cost. It does not pay for the capital plant investments. So utility-owned solar generation, that has zero fuel cost. But Duke Energy Progress customers are required to pay all the capital costs, transmission cost, pipeline costs, like we filed testimony in the Roxborough or Person County CC1. That fixed cost element will be 100% direct assigned to Duke Energy Progress customers. But even though there's massive amounts of energy transfers shifting from Duke Energy Progress to Duke Energy Carolinas. When we advance to the 2023 CPRP, subject to check, those power transfers almost doubled. I believe that DEP was now at its peak was approximately 24 to 25% of its annual energy was being generated, but for Duke Energy Carolinas. Putting a pin in this conversation, when we look at present rates, it's not accounting for the inequities. A element, why Duke Energy Progress rates are slightly elevated above Duke Energy Carolinas rates and will continue to grow upon, are the exact reasons that I tried to articulate just now before this commission. So the merger in itself helps, a element of the merger helps address that inequity issues that Duke Energy Progress customers that are currently paying and are projected to even have more burden as a subsidy over to Duke Energy Carolina customers.
Well, I think that was well stated. That's not the first time I've heard that. As the carbon plans move forward, and I've sat here for 2 years and listened, I've heard you talk about the inequities between DEP and DEC and the power transfer to them, the upfit on a 240 kV line through Lylesville, if I remember correctly, et cetera. You expounded on those. But you think that the merger will address some of the inequity that you see moving forward. That's why or one of the reasons why you think this is a good thing to have the business combination move forward.
That is one of the many reasons why we're supporting the ultimate merger or the business combination of Duke Energy Carolinas and Duke Energy Progress.
Okay. We talked about benefits of the merger and the business combination. Is there any risk that some of the things that have been articulated will not come to fruition? Or is there anything you'd like to share with the commission that would possibly, in a projection, happen? And I mean, not in a hypothetical, not in a what if, but is there anything that you've seen as you've perused through all these numbers and the discussions, what may not come to fruition?
Let me start out and I'll turn to my colleagues to expand upon their conclusions. That with any long-term projections, there's always risk. There's no denying that fact. That based upon our analysis, our own independent analysis, that at this decision point, based upon the risk factors that we identified, that's why we made our ultimate recommendations. As Ms. Thomas can expand upon, one reason that our initial testimony went from $25 million to $20 million was to account for some of these tangential risk factors, Mr. Thomas.
Yeah, I think, one thing I'll just say off the bat is that I think the stipulation by requiring the tracking of these 4 categories of measurable benefits, I think it brings some comfort to us that those benefits will be tracked and will be recorded, and we'll be able to review those, because those are, spending on, rate-based expenses or reliability purchases, right? Those are things that are, that can shift around and are kind of subject to a lot of discretion and system operations. And so tracking those and understanding how close they got to those estimates and ensuring that North Carolina customers are protected from those costs falling short, I think is really an important concept. But as we talked about in our testimony, in my testimony, and Mr. Michener's, is that the biggest category of benefits is the capital deferral or elimination of megawatts, right? That reduction in needed capacity. There's always a risk that something can happen, load can grow, and we see things change. But I think public staff, through CPCN proceedings and CPRP proceedings and ensuring that, assumptions and the benefits around the merger are modeled and incorporated into our multi-year rate plans and our expansion plans. That's going to be on us and our role. And I think we're committed to holding Duke accountable for that and making sure that, we're not continuing to build to a plan that reflects two utilities when we know that these, especially once we know that these merger benefits are, that the merger is approved and we can plan to that combined BA. So,
well, that's a good point. I lose sight sometimes. Excuse me, Ms. Boswell, you have a comment?
Just to add one thing.
Oh, excuse me. I'm sorry, Mr. Machina.
It's all right. Just to add one thing to what Mr. Thomas just said about planning to the 2U situation, and to expound on what Mr. Metz just said about the DEP versus DEC inequity. This came up in the Person County hearing as for the Person County 2, as it was the first incremental generation being added to the system in a while. And there was a whole debate about siting analysis and also which balancing authorities to be part of. So the merger does resolve some of the issues around the reserve margin between two separate utilities, as well as placing a utility or placing an asset in one utility and then sending power to another utility. In the 1U case, a lot of these issues are resolved, and we can focus on making the best placement possible.
Okay.
And I would add, in addition to that, to Commissioner McKissick's question from earlier, there are other outside of operations, there are some other costs for which are not inherent within the confines of the settlement because they're not fully known yet. While the company and the public staff don't totally agree as to what all of those cost categories are, we will be auditing their books going forward to tease out all of those dollars to make sure they all flow back to ratepayers as they should.
Okay. I was just saying that in my time here, sometimes I lose sight of every 2 years we're doing something, or you're behind the scenes doing an audit, that what decisions that the commission's making is finality and it's going to last forever. And it certainly is a moving target, certainly, depending upon what the load is. I got one question for Ms. Boswell. During the course of the public staff investigation, did you obtain information concerning the journal entries that will be made on the combined utility general ledger to understand how the payment from North Carolina retail jurisdiction to the South Carolina jurisdiction over the 6-year period will be funded and recorded for accounting purposes?
So within the confines of the settlement that's before the commission today for decision, that will be handled as a rider for North Carolina purposes. We did not look at how South Carolina intends or how Duke intends to handle it for South Carolina purposes because that's outside of our realm of review. But that is why we proposed and agreed with Duke to set forth a rider for those dollars.
So that's how the accounting is going to be handled moving forward?
For North Carolina.
Okay, yes, for North Carolina. Okay. I think that's all the questions I have. Was Chair Brawley?
No question.
Commissioner McKissick?
Just one or two questions. You heard the testimony of the public, of the Duke's witnesses previously. Are there any issues that they spoke to in terms of providing testimony that you would like to provide clarity upon as it relates to any of the issues that were discussed? And if you, and I ask that generally, but I'm also very concerned about the stipulation that's before us in terms of the settlement. So it's a wide open question. So if there are aspects of the testimony that we heard that you take issue with, that you'd like to provide clarity to, this would be the prime time to do it.
So I will start to provide some clarity. There were some commissioners' questions regarding the overall benefit and how it would impact rates. And I think it's important to understand that there's more than one rate. There's base rates, and then there are all the rider rates that come along with it. So within the confines of the merger agreement before us today, you will not see any base case impacts until the next general rate case filing, and not the one that's currently pending before the commission. We will start to see some of the impacts from the riders starting after legal day 1 in 2027. It is the public staff's understanding that Duke intends to follow or to request to follow DEC's timing of riders, which would put that in the first quarter of the year for review. So those would be within the confines of early 2027 that you would begin to see some of those flow through. Depending on the rider, depends on how long it would take to actually flow all of those through. Fuel being probably a little faster, DSMEE probably slower within the confines.
Nothing that I disagree with. I think that's important to highlight that when we talk about legal day 1, as we have commission rules that are into effect, we have to follow those processes unless the commission decides to change those rules, that there will be a function of lag associated with this. But absent the merger and as the benefits as are listed, overall total cost would just be higher. And I think that from my perspective, that is a key takeaway. Absent the merger, overall system cost, and Mr. Lucas and Mr. Williamson have graphs on the bill impact analysis to illustrate that very point in their testimony.
Yeah, and the testimony that Mr. Williamson and I prepared, page 15, figure 2, working with Duke, development analysis on bill impacts. We think the merger is a net benefit for both DEC and DEP customers.
Okay, good to know. Okay.
Okay. Now, there was some testimony relating to cost of service study or analysis moving forward. And of course, they indicated that they would begin on day 1 of a reorganization, but that will likely take several months, involve stakeholders. Of course, I asked specifically about public staff's involvement with that. Is there any greater testimony you'd like to provide in terms of what you reasonably anticipate at this time as this moves forward?
As Mr. Williamson and I recommended, we do recommend that Duke put together a stakeholder process so that all parties can weigh in on how that cost of service will be developed. It should be developed very soon after the merger is complete. Want all parties to participate. It will affect all the parties that have intervened.
I guess just to add to that, I believe Duke Witness Byrd discussed that it would be follow a relatively consistent process as far as how a cost of service would be designed and created. I think a primary difference will be there'll just be a lot more inputs into it to account for legacy revenue from both sides as we start moving towards combined costs as well. But as we start to create that combined, that merged utility system, we'll start to see, and that's kind of what a lot of conversation that we'll still need to have at some point is how jurisdictional allocations are going to change, and then how the retail allocations are going to change, because we're going from 6 categories down to 3, and you're kind of moving allocations around that we just don't have. We haven't performed, Duke hasn't performed a cost of service that reflects a true 1U costs and revenues. But what they did provide in this case probably is a good representation of what to expect through it. So we were satisfied by their illustrative approach at a 1U cost of service in this proceeding.
If I can just expand slightly, timing is critical. To the extent that we can start, I believe as Witness Elliott talked about, phase 2, phase 3, timing is critical. The faster that we can start moving towards these phases, the more efficient that we can move through this overall process and continue this dialogue.
And in terms of coming up with the ability to measure, the totality of the benefits that are coming from it. I mean, obviously, it looks like you're looking at 4 categories: the reduced reliability purchases, the reduced operating reserve, reduced online contingency reserves, and of course, fuel savings. Do you envision those categories going beyond those 4? That would be categories that you would look at that could be verified to determine the net savings that are going to occur as a result of the reorganization?
So let me start out with, and I'll turn to my colleagues. I think just taking a step back, if looking at the stipulation in whole, is that if those 4 categories do not manifest themselves and those benefits do not exceed the cost, shareholders would pay the differential with the caveats that we talked about before. So going into stipulation again, from my view, it's more advantageous for Duke to have more categories than what they had listed. They provided the minimum categories. Again, the stipulation is a give and forth upon multiple items, but from my opinion, my perspective, they are willing to say, here are the bare minimum, the lower the cost, lower deltas in terms of total savings, and they're willing to say shareholders will pay that difference if they don't come across. So as we move forward, that it would, as per the stipulation, that we will work with Duke, and sense that if they identify a cost saving measure, or if we identify a cost saving measure, that's why the verbiage is in there, that we'll begin identify that and follow the overall stipulation as possible.
And that would be in addition to any of the additional items that Duke Witness Elliott has spoken to, and that we would look at in addition to those that are outside of the operational.
Mr. Thomas, you have anything to add?
Okay. Well, I think that I've gotten the clarity which I need. I mean, I think you guys have a wide open question there that gave you a chance to chime in on any issues relating to the testimony we've heard today. And I think you provided some excellent clarity. So I thank you for your testimony, and thank you guys for working hard to get the stipulation before us.
If I can have liberty to
Yes.
maybe even expand upon further.
If you could, sir, I'd appreciate it. You've provided some excellent, insightful testimony this afternoon.
So we've started identifying these issues before the commission, and the public staff identified this commission to say, look, we need to work on what if. We need to start making plans if the merger is not successful. The merger, as challenging as it will be, and we will do our due diligence and work on it because we see the benefit to ratepayers. Not going through with the merger, as you called it, Plan B. The commission instructed us and the utilities to get to work. We have had quarterly meetings with Duke. We're continuing to work on those. We continue to identify issue, have conversations and follow up. Not implementing this merger, Plan B, as I'm saying it, is going to be much harder than implementing the merger itself.
Thank you for sharing those observations. And obviously, over the last 6 years, there's been repeated, consistent concern about when these entities would one day merge, or I guess the technical term of art right now is reorganize. As a commissioner who has listened to those discussions repeatedly over the years and testimonies that's been discussed about that growing in equity, I'm pleased to see this before us for our respectful consideration. Thank you.
Okay. Commissioner Vandermark?
Thank you. So, Mr. Lucas, I'm glad you brought up your testimony. I think that was December 19th.
Yes.
And I think the figure you're talking about is the same one I expected to hear in before, which is at that time, and of course, you have all kinds of, tell me if I'm wrong, but I don't mean to put words in your mouth, but you got all kinds of caveats about how it's difficult to make these calculations at the time and, you know, all that stuff, making a 1U combined estimate. But you showed, the way I understood it is you showed all the rates were going to go down. Is that right? Did I interpret that figure correctly?
I can see,
Or what I should say is the 1U rate is below both the DEP and DC rates?
for many of the years, from like 2030 through 2034.
Right.
Duke's calculation showed, would be a savings for, on average, DEC's customers and DEP's customers would be paying less.
Right. And so I was hoping for that kind of answer earlier. And the disconnect, I was sitting here thinking about it through all this. The disconnect call comes to that guaranteed value that's in the stipulation. It's extremely low compared to the kind of money that that figure assumes would result in that lower rate. Do you understand what I'm saying?
Just comparing the, what the stipulation says.
Yeah.
All these different savings.
Yes. I mean, it's
I mean,
44 million other than the avoidance of the battery cost.
Mr. Lucas, if I can jump in.
It's about 44 million or something, but that wouldn't cover the 1U rate being lower than DEC and DEP, right? I mean, that's based on a bigger savings, which I know is going to happen. It just doesn't get reflected in this settlement. You know, I'd be a lot happier if the settlement said some, you know, bigger number like, you know, 500 million or, you know, $1 billion or something like that. Then it would all make sense. And it would also make sense with the question of what if South Carolina comes in and demands 50 million more, okay? Well, in the current calculation, unless you say it's a force majeure expense, you know, that might actually have to accrue to the shareholders, which, you know, I mean, am I reading that correctly? Because you'd be over you'd have, you know, unless you're over the 14 years, the savings that you accrue through those 4 categories exceeds that, right? And it just seems to me that, am I saying anything that does make sense so far?
I'm following.
So, I mean, I feel sure that you're gonna see all kinds of benefits. But somebody's not sure enough to put that number in the stipulation. The only number in that stipulation is a pretty small number. And that's the only disconnect I have about this whole thing.
So a few items there, and if I'm veering too far, I understand you will bring me back on track. So it's not me not trying to answer, it's just, it's a lot of items to try to cover, and I'm trying to
Keep it
handle.
concise. There you go.
So I think the first item is this, let's isolate the cost. And so that we looked at the NC retail portion. So everything that I'm talking about is at NC retail level, is that we looked at the cost to achieve, the incremental cost, the capital cost, the O&M to implement those items. Ms. Boswell, Mr. Thomas can expand upon more details if you want to know specifics about that. So on an NC retail basis, that is 136 million.
Correct, $136 million.
And so that sounds like starting, but what does it take to get just to?
Plus the 150 million for South Carolina, right?
Correct,
mean,
for the
that's
share of
part
the
of it.
benefits, yes.
Right.
So looking at the overall 136 million, we then compare that to the overall benefits. Mr. Thomas, what are the overall benefits?
In the third supplemental, it's a little over 500 million MPV for net gross benefits to North Carolina.
And so we looked at the gross versus the net, and we're still way to the positive. And then looking at the overall stipulation, it said even so, we had to put forward that $136 million in cost, plus now the North Carolina contribution is that the stipulation from Duke's end of the equation say if we don't get the benefits that we're the minimum benefits that we're manifesting from a North Carolina ratepayer perspective, we won't cause
North Carolina retail customers will not have to pay for it
thank you.
in the advent
Unless
that the,
force majeure, unless the increases
And the
qualifies as
commission-
the force majeure.
right, and the commission approves it.
But if the commission, see, and people talk about that. I mean, if, for example, I think the lady from Walmart or somebody said, oh, you know, if the costs do come and they have to go higher than they ordinarily would, they would have to come before us, which makes sense. But then that cost would still be attributed to this merger.
But absent the merger, total system cost under the two utility scenario would just be that much higher.
No.
Okay.
She's talking about increases beyond what they would otherwise be. And all I'm saying is, of course, they got to come in front of us to get that. I'm just concerned that when those come in, that really means that they should be accrued back to the costs of the merger. I still think there's going to be tons of benefits. Don't get me wrong. It's just the way nobody would, I was a little disappointed that nobody was so assured of the massive benefits that they put a higher number in the stipulation, because I know why Duke did it. Duke was protecting their shareholders. I get that. I was just, that's where I got the disconnect. And that's where I couldn't believe, Mr. Lucas, your figure, because there's no way that would cover that reduction in overall rate for the 1U rate. I think that it's going to happen. That, you know, I'm not at all against the merger. I'm just disappointed with that number in the stipulation. That's it.
And understand that. I would say that the 136 million for which you said one of the other attorneys had said if it went higher, we do have language within the confines of the stipulation that if it goes above and beyond the 136, there is no guaranteed recovery for Duke. They may come in and request it. If it's, we would audit it, and if the commission and if the public staff deems it prudently incurred, we would support it. If not, we would not. And it would ultimately still be up to the commission for anything in excess of the 136
Sure.
million.
I get that. Thank you, though. Appreciate it. No more questions.
Any questions on provisional questions?
One question, if I may, Commissioner Tucker. This goes to your presiding Commissioner Tucker. This goes to your question about hazards if this goes forward, risk if this goes forward. I'd like to see if I could ask the opposite question about what if the merger does not go forward, and what issues, cost allocation, et cetera, might we see?
So I think I touched on that briefly with Plan B, and say, what if the merger doesn't go through and we have to now start looking at cost recovery, and to the extent that we, for a generation resource asset, I'd say it's relatively simple. It'll be a complex argument in itself, is when the need is established, what was the basis of the need? Where you start becoming further challenged on that is dissecting the elements of the overall generation plant. Let's just say again, for a hypothetical combined cycle, how can you take piece part a combined cycle that's providing non-firm energy over to the other resource when you have fixed costs such as the pipeline, and when you also still have the presently effect joint dispatch agreement? It'll be a very complex puzzle to unwind. Mr. Thomas might be able to expand upon to the extent that the pros and cons of citing generation resources in each area for overall system lower costs.
Yeah, and I think Duke Witness Peeler talks about this in his testimony, right? Is that right now they kind of are in this hybrid state where they try to locate resources where they're most economic, but there's a JDA, but it's contributing to this rate disparity between the two BAs. And so Witness Peeler testifies that, if the merger falls through, they will have to plan differently, plan more separate, site, for example, you might try to site more solar in DEC versus DEP, but it's higher land costs and harder to find contiguous plots. So you end up with a higher overall cost of solar. Or maybe you need to start putting natural gas plants further away from pipelines just to make sure that the right customers are paying for that asset. And so you end up with a system that maybe is more equitable between DEC and DEP, and you have not as much cost cross subsidization, but overall it's more expensive, right? So it's like a bigger pie, but it's cut a little more fair, right? But I think the benefit of the merger is you get this smaller pie of costs, and you don't have to worry about how you split it up and proceed going after one-off transmission cost share arrangements to address the disparity or inefficient planning and siting of resources. You kind of get to look at the whole system, which is what Duke tries to do now, but because of how rates are set between the BAs, it produces this inequity. So I think the merger will help address that in a way and not force us to take steps back from this hybrid process that has yielded some benefit in terms of lower rates overall, even if it has at the same time resulted in an exacerbated disparity.
If I can expand on it, another example is just looking at even new nuclear. New nuclear, it's in the IRPs. We've had prior conversations about it. So we know that we have a prime candidate location in South Carolina that's in DEC territory, and we have a prime candidate that's sitting in Duke Energy Progress's territory. But if the merger isn't effectuated, will you be able to build that new nuclear power plant in Duke Energy Progress, talking about Harris specifically? Because you have to look at the needs of Duke Energy Progress customers. So the merger, as we're continuing down this massive capital expenditures, this merger will open up many, many doors where if we don't continue down this process, it's going to get worse in terms of the rate disparity, in my opinion. Mr. Michener.
And while I can't speak to kind of how the joint dispatch or agreement would look like in a 2U Plan B scenario, there's a lot of nuances that would need to be ironed out. I would, again, harken back to the discussion that was had about Person County CC2, which was the first piece of incremental generation added. In this IRP that will be heard before this commission in about 3 months, there's a massive, massive system expansion, and every single asset, should there be power transfer between the utilities, would have to have that discussion about does this belong here or here based on the need of that respective balancing authority. It creates a much, much more tangled web and is maybe not the best optimized use of resources as Mr. Metz and Mr. Thomas just stated.
And then there's another layer. Do we need to revisit the joint dispatch agreement if we don't merge to address these inequities? Joint dispatch agreement's got to go through 3 entities: FERC, South Carolina, North Carolina. We might be here right again as we continue down this path if the merger doesn't go through.
A lot of hypotheticals there.
Yeah. He's making me tired thinking about it. Yeah, okay. Mr. Creech, you done?
No more questions.
Okay. Nothing, Duke's waived theirs. Okay, folks. I guess you are, yeah, well, I'll do that. I'm getting 2 parties here. Let me ask you to sit there a minute longer. Are there any motions?
Yes, Presiding Commissioner Tucker, SIGFR would move admission of its public staff cross exhibits numbers 1 and 2 into the record at this time.
All right, without objections, so ordered.
Presiding Commissioner Tucker, I'd like to move the public staff testimony and exhibits into the record if I could, the pre-filed joint settlement testimony of witnesses Boswell and Metz, the pre-filed settlement testimony regarding the regulatory conditions and code of conduct of witness Boswell, and the pre-filed direct testimony of witness Boswell, witness Metz, witnesses Michna and Thomas, and of witnesses Lucas and Michna be entered into the record. And finally, I'd like to also enter to the record and have marked for identification as pre-marked are their exhibits, witness Boswell's 2 exhibits, witness Metz 1 exhibit, witnesses Michna and Thomas's 1 exhibit, and witnesses Lucas and Williamson's 1 exhibit. And then I'd also like to ask that their pre-filed summaries also be placed into the record as if given orally from the stand.
Okay. Without objection? So ordered. If anybody's wondering whether or not I'm keeping up with all the exhibits, someone in the back's doing that for me. I'm barely keeping up with where I am now. One other item of housekeeping, and well, let me just excuse you folks. You may get down.
Thank you. And I'll just approach and clean things up if you like.
Yeah, that's fine while I'm doing this. I'm sorry. Did I, wait a minute, hold on 1 second. I'm looking out for Sace. Mr. Magina, did Jimenez, you have reserved time. Did you have some questions?
No, sir. I have a motion on a different.
Motion, okay. Go ahead, sir.
If the commission has no questions for him, we would move to excuse witness John Wilson.
Okay, all right. I don't have any questions. Anybody got any questions for him? Okay.
And to move his pre-filed testimony and summary entered into the record as though given orally from the stand, and have the exhibits attached to his pre-filed direct testimony identified as pre-marked.
Okay. Do you have objection? So ordered. The other housekeeping measure is, I have a note here to please ask counsel to enter their excused witnesses' testimonies into the record so that it'll be included in the transcript. So if anybody that has an excused witness that is omitted and has not asked to have it put in the record, so it's included in the transcript. Oh, we have folks lining up here. Folks, you may be excused, I think. Go ahead.
I think finally he's excusing someone from proceeding for the first time today.
Right.
It's quite the party.
Well, they can step down the hall.
Your Honor, at this time, Walmart filed a motion to excuse its witness Lisa B. Perry. That motion was granted, I believe, on the 19th. At this time, we would move for the admission of the direct testimony of Lisa B. Perry and the witness summary and all exhibits into the record as if given orally from the stand.
Okay. Out objections, that's allowed.
Yes.
Could you state your name, please?
Excuse me, Heather Fennell on behalf of Google, excuse me. Google moves the testimony of witness Berry consisting of 18 pages and 1 appendix that was filed on December 19th, 2025 into the record as if given orally from the stand.
Okay, thank you, Ms. Fennell. Without objection, so ordered.
And then finally, Rita Coxton on behalf of the AGO, making a similar motion for the testimony, exhibits, and witness summary of Edward Burgess.
Okay. Without objection, so ordered. Anything else right now? Well, I just, give me a moment, folks, just 1 minute. Yeah, we need to, I think we'll move forward with Sigford and Mr. Mueller, please.
Yes, sir, Presiding Commissioner Tucker. Sigford calls Bradford D. Mueller to the stand.
Mr. Mueller, through there, if you can find yourself a Bible and all those books and put your left hand on it and raise your right hand. You solemnly swear that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, I do.
Thank you. Ms. Crest?
Thank you. Mr. Mueller, could you please state your name and employer for the record?
My name is Bradford D. Mueller. I work for Charlotte Pipe and Foundry.
On whose behalf are you testifying in this proceeding?
I'm testifying on behalf of SIGFR.
And Mr. Mueller, did you cause to be pre-filed in this docket on December 19th, 2025, pre-filed direct testimony consisting of 20 pages, including one appendix and one exhibit?
Yes.
Was there a later filing of the same testimony and exhibit on December 29th, correcting an inadvertently misfiled testimony in a different docket?
Yes.
Do you have any corrections to your pre-filed direct testimony?
No.
If I were to ask you the same questions today, would your answers be the same?
Yes.
Did you also cause to be filed on February 20th, 2026, a summary of your pre-filed direct testimony?
Yes.
Thank you. Presiding Commissioner Tucker, at this time, I would move admission of SIGFR witness Mueller's pre-filed direct testimony consisting of 20 pages, one appendix, and one exhibit into the record as if given orally from the stand, as well as witness Mueller's summary be entered into the record as if given orally from the stand.
Okay, without objection, so ordered.
Thank you. And I request that witness Mueller's direct exhibit 1 be pre-marked for identification as filed and admitted into evidence at the appropriate time.
So ordered.
Thank you. Mr. Mueller is now available for cross-examination.
What? Right. Okay, can we call on Duke?
No questions.
All right. Any questions from public staff for Mr. Muller?
We traditionally cross last, but I'm not aware of any questions at the moment.
Okay. Seba?
I have but yes, sir, I have a few questions.
I'm sorry, CC.
That's okay. I want the record to be clear because CEBA
Yes,
is all
sir.
for parties. My name is John Burns. I'm the General Counsel of Carolina's Clean Energy Business Association. Mr. Mueller, it's good to see you. I have a few questions for you today. You are testifying as an expert on behalf of SIGFR.
Correct.
And you are described in your testimony as a member of Charlotte Pipe and Foundry's executive team. Is that right?
Correct.
And based upon your position as VP of Corporate Communications, is that still correct?
That's correct.
As a member of the Charlotte Pipe and Foundry executive team, you've got knowledge of the firm, of the finances and operations of that company, don't you?
Correct.
And in your filed testimony, you do address the impact of on that company's bills and operations of power supply, power quality, and issues like that in your testimony.
Correct.
Okay. And you add that it is, well, let me see. You also speak to the need for keeping confidential business information confidential and the impact of leaking that information on your company's operations.
Right.
So you have more knowledge than the commissioners or anyone else in the room right now about the operations of Charlotte Pipe and Foundry.
Correct.
But you also testify in section 5 of your testimony, beginning on page 17 of 20, as to the effect of transmission investments.
Correct. Can you point to the
Page 17 of your testimony? Do you have
Yes,
the
sir.
testimony in front of you?
I do.
I don't have any cross-examination exhibits for you, sir. I'm just going to be asking questions about your testimony, but.
Mr. Burns.
Yes, sir.
Mr. Burns, just question. None of this is confidential, right?
I'm not asking any questions about the confidential material at all.
Okay,
If there was
very well,
something
sir.
blacked out, but I'm working off the publicly filed document.
There was some rate information that was confidential.
Yes. Okay, I saw the red stamp and I was
Yes,
just
sir.
being cautious.
I
Thank you.
appreciate
Move-
that.
Move
Thank you.
forward, sir.
Thank you for checking up on me, but I'm not going to ask any questions about any of that material.
Very well, sir.
You refer, at least in section 5, beginning on the bottom of page 17 of your testimony, you talk about transmission investments, correct?
Yes.
And you're asked to comment on Duke witness Peeler's testimony about geographic differences at the top of page 18 of 20. You're asked to comment on witness Peeler's testimony. Is that correct?
Yes.
And in that, you are asked, what sort of challenges would Mr. Peeler's testimony about geographic differences create? Right?
Yes.
Your response is to discuss transmission needs between the two existing balancing authority areas, right?
Yes.
I've reviewed your resume, Mr. Mueller, and your testimony, and you don't have any experience or expertise in transmission planning, do you?
Objection. This council is testifying. That was not a question.
I'm cross-examining a little. In my experience, cross-examination is a statement by the attorney and ask the witness if he agrees, and I believe I did that.
Objection sustained.
Do you have any expertise in your background, Mr. Mueller, in transmission planning or in transmission of electricity?
No.
You are not an electrical engineer?
No.
You hold no advanced degrees or certifications in transmission planning?
No.
And you have not participated in the transmission planning for any utility, have you?
No.
Have you participated in meetings of the Carolinas Transmission Planning Collaborative through its stakeholder processes?
I have not.
Your background, as impressive as it is in political and corporate message management, is not in transmission, is it, sir?
No.
You make an assumption in your testimony on page, make sure I'm referring you to the right page, on page 18 and into the top of page 19, you are asked, you state page 18, line 12, that it would be necessary for transmission investments, quote, to move electricity generated by solar from DEP's service territory to DEC's service territory, correct?
Correct.
And based upon that, you make a recommendation on the top of page 19 that this commission should require Duke to hold ratepayers harmless for the cost of any transmission investment triggered by new solar generation.
That's correct.
Are you familiar with the term multi-value strategic transmission planning?
No.
So you would not be, are you aware that the commission has required Duke to adopt multi-value strategic transmission?
Objection. This not only goes beyond the scope of this witness's testimony, it also goes beyond the scope of this proceeding.
May I respond, providing Commissioner Tucker?
Yes, sir, Mr. Burns, go ahead.
This witness has made a recommendation that would have if adopted, would have a significant effect upon the operations of Duke and also on the suppliers of solar energy. I'm only merely asking and trying to establish whether he had a background to make that recommendation and whether he would understand that the process of transmission planning would take into account all of those things without his recommendation.
I think you've established, Mr. Burns, that he does not have a background in transmission planning. However, one could not have that background and assume that if you place a solar field in use, that there would require transmission to that particular solar site.
Yes, sir.
So I have that expertise, and I have no expertise in transmission planning, and I can make that assumption about 3 miles from my house where I saw them put in the transmission for the solar site.
Mhm.
So I'm going to sustain that objection.
Well, Commissioner Tucker, I would agree that this witness doesn't present any background that would be any different from anyone else in this room on that basis. And so I'll ask just one more question then.
Well, just rephrase it if you can in some manner that would not require an objection.
We've established that you're not familiar with MVST, multi-value strategic transmission. I can't talk. Multi-value strategic transmission planning. So you are not aware and not able to testify as to whether or not considerations about cost, expense, value, benefits, and costs already go into transmission planning in the Duke territories.
The purpose of my testimony in this line of questioning, and Commissioner Tucker is right, the assumptions that transmission will be required for new solar.
Sure.
Is that the generator cover the cost, not the ratepayer. If you're adding more generation, the transmission and distribution costs should be included in that.
And you're aware that all generated electricity must be transmitted, correct?
Correct.
No further questions.
Thank you, Mr. Burns. Any other questions for, let me get to this paperwork. Public staff?
No, sir.
Okay. I'm sorry I asked you that. Sace?
No, sir.
No questions. Okay. Just for clarification, on the list here is Mr. Collins. Is he to testify for SIGFA?
Yes, Presiding Commissioner Tucker, and I think we could get him in today,
Yeah.
potentially, because I just have one question on redirect for this witness.
Okay, redirect, move forward.
Mr. Mueller, to the extent you are aware, is SIGFA actively involved in the Carolinas Transmission Planning Collaborative process?
Yes.
Thank you. No further questions.
Thank you. Okay, any questions for? No further questions? Commission questions?
Yes.
Chair Brawley?
Mr. Mueller, there was a lot of discussion of problems that are generated in your facilities from erratic electricity, where maybe it's not smooth power, it's intermittent. Would you elaborate on that? Have you quantified how much money that costs you? And is that something
That's something we could get you. We do track that, and there's a chart in the testimony that shows power outages at our North Carolina facility in Monroe. Many of those are weather related, but we do have general concerns about power quality, which is why we're requesting additional power quality metrics via my testimony. So that, because power outages can knock our equipment offline, even a voltage sag of a few milliseconds can knock our plastic pipe extrusion lines and molding machines offline. And then it becomes very expensive for that outage. You got to replace equipment, you got downtime of people, you got ruined product you're not making because you're fixing the machine. So it is possible to quantify those costs. And, you know, we make and ship millions and millions of pounds of pipe and fittings a year. So the numbers add up pretty quick.
Now, the plant you referred to in Monroe is served by Duke Energy Carolinas.
Correct.
Now, you also have a plant in Stanley County that is dealing with metal pipe. That's served by Union Electric.
That's correct. That's our cast iron foundry.
Now, their primary source of generation is Duke, but are they delivering higher quality, more consistent power than the Monroe plant is receiving?
I don't have the answer to that. We can get that for you though. Yeah.
I'm not sure how, well, that's relating to the.
We'd be happy to make a late exhibit filing to go both to Commissioner Tucker's question as well as Chair Brawley's question. And we may need to make part of that filing confidential under seal because we would be potentially making reference to electric service provided by a utility other than the applicant. But if that's acceptable to the commission, we'd be happy to do that.
I think I appreciate that, but I'm going to decline it. I think you've answered the questions that are really relevant. And the other is, it's kind of as much curiosity on my part as anything. Unfortunately, I'm a divergent thinker. So I will expand to want to know everything about it, and I don't need to know everything about this. Thank you.
Yes, sir. That's all.
Any other questions? Excuse, sir.
Okay, thank you.
I'm sitting here all day.
I learned a lot. Thank you.
Having a motion?
I believe our exhibit that was pre-filed with this witness's testimony was already admitted into the record, but just in the off chance it was not, SIGFA will err on the side of caution and move it into the record again at this time.
state the motion.
Sigford would move admission of what was pre-marked as witness Muller's direct exhibit number 1 into the record at this time.
Without objection, so moved. So ordered, I'm sorry. Okay, and you have Mr. Collins here?
Yes, sir. Yes, Presiding Commissioner Tucker.
Um,
And I can be very quick.
Yeah, folks, Mr. Collins, come forward. It's 4:56. We'll hear this and then we'll adjourn. And then we'll come back in to say, be back on the record tomorrow morning at 9:30. I may move some things around for people's schedules, so just be aware of that. But yeah, we move forward, Mr. Collins.
Thank you. Mr. Collins, good afternoon. Could you please state your name and employer for the record?
Just one procedural, should I be sworn in?
Yes, you should.
Can I swear you in, sir? Left hand on the Bible, raise your right hand. You solemnly swear that the testimony you're about to give shall be the whole truth and nothing but the truth, so help you God.
I do.
Thank you, sir.
Let's try that again. Mr. Collins, could you please state your name and employer for the record?
My name is Brian C. Collins, and my employer is Brubaker and Associates Incorporated in Chesterfield, Missouri.
And on whose behalf are you testifying in this proceeding?
I am testifying on behalf of Sigford.
Mr. Collins, did you cause to be pre-filed on December 19th, 2025, pre-filed direct testimony consisting of 37 pages, including 1 appendix and 2 exhibits?
Yes.
And was there a later filing of the same testimony made to correct an inadvertent misfiling into a different docket?
Yes, there was.
Do you have any corrections to the pre-filed direct testimony made in this proceeding?
No, I do not.
If I were to ask you the same questions today, would your answers be the same?
Yes, they would.
Did you also cause to be pre-filed on February 20th, 2026, a summary of your pre-filed direct testimony?
Yes.
Thank you. Presiding Commissioner Tucker, we would move admission of Sigford witness Collins' direct testimony consisting of 37 pages and 1 appendix, as well as 2 exhibits, and his witness summary. And we would request that it be copied into the record at the appropriate time as if given orally from the stand.
Okay. Without objection, so ordered.
Thank you. And we would also request that Mr. Collins' pre-filed direct exhibits identified as Collins Direct Exhibits 1 and 2 be pre-marked for identification.
No objections, so ordered.
Thank you. Mr. Collins is available for, I believe, just questions from the commission at this point. I believe everyone else has waived cross.
Okay. Any questions for Mr. Collins? Well, let me take the other 1 minute we've got. Mr. Collins, you have a BS in electrical engineering from Southern Illinois University and then a master's of business. What is, in generality, what is your thrust of your testimony, other than what I've read, that you're here to discuss about Duke and its balancing authorities and the DEP, DEC territories?
I'm sorry, Commissioner, is it, you said with respect to the balancing authorities?
If you want to be specific about that, I was really looking for, you've got 37 pages, I think, and prior to that, Mr. Muller was asked about his experience. You have extensive experience in background on transmission planning, et cetera. If you can expound on those things and then pick out one particular identifying calculation that you've made through modeling or whatever manner it is that you can state to us about Duke and the merger, or excuse me, business combination.
Okay.
That's pretty general, but you can do that, sir, I'm sure.
Sure. Well, I did testify, I think on page 37 of my testimony about, transmission investments and interties related to the merger and, or I'm sorry, the combination and the balancing areas. And
my recommendation there was, that the commission should require, the utilities to conduct a cost benefits analysis for any such transmission investment before allowing rate-based treatment and recovery of those costs from customers and Duke's retail rates. And just to expand upon what Mr. Moeller said earlier, to the extent that there are solar investments, if there's new generation, there will have to be transmission built to serve those, more than likely to serve those units. So I did agree with what he said there at the end of his testimony.
Okay. All right. Do you have any other assertions that in your testimony you talk about transmission? You are, and I don't want to put words in your mouth. You're talking about the expense of transmission to solar sites in general. Again, as stated earlier by Mr. Burns, that all electric generation requires transmission. Is there some value in what you've done in this analysis that you can share with us as a commission that we need to be looking at?
No, I've not done any analysis. It's just that I would recommend, that the commission require, cost benefits analysis, if there's any interties needed to, merge the balancing areas. So.
Okay, so I don't want to put words in your mouth, but your assertion is that if there is transmission required to a solar facility, that it be paid for by the solar developer. Is that what I'm understanding from your testimony?
I would not disagree with, Mr. Moeller's testimony.
Okay, all right. Any further questions for Mr. Collins? Mr. Van Wart, Commissioner?
I'm sorry, this might be a very quick question.
Sure.
Is this your point, is that particularly true because of the level of penetration solar has in North Carolina? In other words, all of the choice spots that made it more convenient to tie in are taken? Are you just generally saying when you plop down a plant, and you have to hook it up? Is there any distinction you're trying to make there, or?
Well, typically, in my experience, when a generator interconnects with the utility, it's responsible for its interconnection costs, and it would be appropriate to recover those costs from the developer.
And you're saying that doesn't occur right now?
To be honest, again, that wasn't the major focus of my testimony. I was really looking at ties, but I don't disagree with what Mr. Moeller said earlier in his testimony.
Okay, thank you.
I just have a couple of clarifying questions related to what was asked by the commissioners, if I may.
Okay.
Thank you. Mr. Collins, is it fair to say that a brownfield site might not have the same level of incremental transmission investment costs as a new greenfield site would?
That's correct. A brownfield site, that means you're utilizing the existing site where a generator is currently located. It's been retired. So if you were to, develop and site a new generator there at the brownfield site, there may not be as much, transmission needed to be constructed.
And while the transmission piece wasn't necessarily your focus, and Mr. Moeller did address it in his testimony, did you make 11 separate recommendations in your testimony, all of which are summarized?
Yes, I did.
Summary?
That's correct.
Thank you. No further questions.
Any further questions? No questions? Okay, any housekeeping, any motions?
Just one motion, Sigfer would move Sigfer Witness Collins Direct Exhibits 1 and 2 into the record at this time.
Without objection, so ordered. Any further business today?
Commissioner, if I may, I would just
Yes,
note, as always, we'll seek to coordinate with the parties this evening to get updated cross times as we do for these major proceedings. We've obviously made a lot of great progress. And we do have one scheduled conflict that I'm working with staff on to resolve, but it will help us to make a decision if we can get feedback on potential cross time to the extent parties can share. So we'll work on that, and just want to notify you we're doing our best to get to.
Yes, sir. I'm aware of the conflict. Okay, thank you. Thank you, Mr. Collins. You're excused.
Thank you.
All right, for today, folks, we are adjourned.